Good morning, everybody. It is Thursday, August 27th, and we are here finally for the closings in the Lindsay Clancy's case. So let's get to All right, so we are all anxiously awaiting the court day to start. Sorry I'm a little late. I gave in to my daughter's request that I take them to Starbucks before school. I was like, she's like, if we leave at 6:55, you'll be home at 7:15. I mean, I'm like, no, you mean you'll be dropped off around 7:15. So I demanded like a 6:45 departure time. Still wasn't enough time. And so here I am. But let's talk about closing arguments. Let's talk a little bit about closing arguments just in general. Before we do that, I'll say hi to Jennifer Phelps, new member. Welcome. Family hug. Mallory Davis, 3V, has a drink called No, This is Patrick. Is that a joke? I mean, like, is that, I see you're saying it as a joke, but I don't know. Okay. Hannah says a van down by the river is a bike trail in Massachusetts. Assuming that's also a joke. I'm too slow this morning, you guys. Hey, a Cupcake Diaries. Love Cupcake Diaries. So glad I get to spend my birthday with you all. Well, happy birthday. I'm trying to decide if I can muster up half a birthday song. But you are a Cupcake Diaries, so I should do it. I don't know why it's easier when Bob's here. All right. Happy birthday to ya. Happy birthday to ya. Happy birthday to Cupcake Diaries and all the rest of you out there with the birthday. And thanks for your continued support for 5 months. All right, so let's talk closing arguments. What is like the best thing that could happen in a closing argument, just generally? No, from a defense point of view, and I guess from a prosecution as well, but I feel like a prosecutor can't, just come out with some shit at closing that they never really connected during the trial. But it's that you laid breadcrumbs for something that gets connected in closings in almost a way you maybe didn't see coming, or just like it's like a real like, oh shit, I didn't even think about it that way kind of thing. Now, do I know if that's going to happen here? No, I don't. Like in my mind, it's happening left and right, and there's, plenty of ways, again, in my mind that I think stuff like that could play out. So we'll keep an eye out for that. But that's really what it's about, like a controlled defense attorney. You're making your notes of words you need said, and then you just wrap it all up at closing in a way that brings it all home. That maybe people didn't even see coming. And a lot of sometimes that can't really happen, but there's a lot of times that it would. I kind of think this whole dream of him using clips couldn't possibly be happening, because I feel like he's one man, maybe an assistant, his son, like it would have been asking for help. It's like, hey, can people help find timestamps? And that was happening, Bob would have asked me, and so unless they've been doing it along the way and someone from his office has been making them, maybe they have. Maybe they have, So hold on. Let me clear my throat. Like, I don't know what the prosecutors are going to do. This is, they have been presenting one case and then a whole other case, and I just don't know how they're going to piece these two things together, in closing. I mean, you already saw Red cite from their opening. Maybe it's going to go on one of his little cardboard things. Got a cough again. Hold on. But I mean, some of the obvious things to expect from closings is clearly a very strong focus on, the burden and the fact that even though the defense put on experts and, if you think, well, I kind of believed, I'm going to say all the experts made sense, but I kind of believe the prosecution's experts a little more. So I'm going to say guilty. That he's going to explain that that's not the law. That's not the burden. That's not what you're trying to do. But, that's like a given. That's, obviously he's going to focus on that stuff. Obviously he's going to focus on the inconsistencies in that, in the experts. And in every way, I would assume that their experts supported what he said, which happened a lot, even with this last expert. It happened a lot. Okay, so no joke. Atypical lemonade. God, you guys are quick with your names. I love it. No joke under the drink menu chalkboard series. That's wild. It's crazy. What did they name it? No, this is Patrick. So what are they saying? Are they saying was Patrick that came in there? That Patrick did it? Like what do they mean? No, this is Patrick. I don't know. Thanks, Atypical Lemonade. Denise Michelle says, thank you, Allie, Cam, and Bob for going through this trial with us. You all did a fantastic job. Well, thank you for your generosity. Appreciate it. And your kind words. Music to My Soul says the Commonwealth to choose between delivering on its opening and supporting its experts. Either way, they will have to abandon some part of their case. I mean, that's for sure. I mean, they're going to present it like, look, we put these other experts on just to say, like, if you believe this bullshit, I mean, obviously not like this, because they also can't do it like this, but I'm just saying, if you believe what the defense is throwing down, our experts told you she could still conform. She could still know the difference between right or wrong, so they'll present it that way, but they're going to have to abandon. There's so much more of their case, to your point, Music to My Soul, that was obliterated by their experts. I mean, that whole quoted opening statement that I'm shocked was able to, to get in. I was waiting for the objection to be compound. Like there were 15 sentences there. But they let it in. And he said, well, that's minimizing. Thanks for your generosity. What up, Iceman? Iceman says, what up, though, Allie? Also, for today, can you give me a note for my job so I can focus on closings today? LOL. I would greatly appreciate it. Well, it depends what job you're doing. You might need to pay attention. I don't know what you're up to out there in them streets. We might need your attention. But good morning, Iceman. Magical Mary says, and thanks for your generosity. Magical Mary says, Allie, you have done an awesome job. Well, thank you, Magical Mary. Thanks for your generosity. Brenda Crowley gave some jewels. We love the jewels. A lot of birthday wishes in the chat, so hopefully you guys are seeing that. I'm just going to go to more people need notes. Lady Di needs a note. Let's see what some of our members are saying. Well, Legal Mama says, good morning, DD Femme and Allie. The anti-Lindsay opinions just break my heart. No understanding of women's mental health. Hopefully the jury understands this. There's 12 women. I mean, who knows how many will get on? I mean, it's supposed to be random, right? With the little spinny thing. But yeah, hopefully it does. Kylie says, oh, I don't know. She's responding to an at Mark, and I don't know what Mark said. The fact that she couldn't speak changes everything for me. I couldn't even imagine false memory to Patrick. I couldn't even attribute false memory to Patrick. I'm testifying in a trial coming up in November for something that happened and she's got more to it. But that brings me to another point about the closing. We had the Bowden or Bawden. I mean, the judge and the judge and Reddington pronounced it one way, Commonwealth pronounced it another. I mean, in Karen Reed, most of our, well, Yannetti is obviously Massachusetts, so I don't know if I heard him pronounce it, but Alan Jackson's New York, so who knows? But I'll stick with Bowden. The fact that he's looking for a Bowden instruction for the jury to be told, and I think I pulled the instruction up yesterday just in case he was going to let him have it. So, but anyway, it just says that they can rely on the fact that there was an incomplete investigation, in determining whether the Commonwealth has met their burden. The fact that he's going to rely on that gives you a little window into what's going to happen, that he's going to argue that the state hasn't proven that she committed the offense, and that's something that they need to decide, and that's something they're free to decide that they can't. And he is going to be pointing to the fact that all this information came from Patrick. Everything came from Patrick. How Patrick was traumatized. Who knows if Patrick was right? The 911 call defies what Patrick said. And the point of it to carry into, I mean, I think the real point of all that is going to be, and then these experts, the Commonwealth experts, relied on that in making numerous findings supporting their determination that she was able to conform her conduct to the law, that she was crushing up pills, that she used the words, what did you do? I killed myself. I tried to kill myself instead of I did what I had to do. That was something that he relied on. Both of their experts relied on. I think all three of the Commonwealth experts relied on heavily. So he's coming at that. Now, I don't think he's going to, go as far as to say maybe Patrick did it, I can't imagine that. But he's going to be challenging Patrick's memory. He's going to be challenging that they relied on it, solely. So that's a window into what we're going to see. I expect to see that timeline. They keep talking about how much time she had when he didn't leave until at least 5:25. Just because he said 5:15, that's an estimate. The evidence shows he didn't leave until 5:25, at least 5:25, sometime after 5:25. How's he going to use the heartbeats? I'm so confused about the heartbeats. Like, I just don't know. What was the heartbeat when she was right before she jumped out the window? Do we know? Oh, she took her watch off. So we don't know. Okay. I had a day yesterday. I was supposed to get on with Bob. Things got wild here. There's no reason for me to get into the details, but I couldn't get on with him. I haven't even watched it. So I don't know, like what my husband was saying yesterday. I'm sure he had some amazing insights. That's why when we do trials together, we get both of our ideas and then realize, oh, okay, let's do this, So I'm sure he had some stuff. Misbehaving says, no, this is Patrick, is from SpongeBob, not about Patrick Clancy. Well, that makes so much more sense. Why are they SpongeBob still pretty big, huh? I didn't know if that like was over. Thanks, Misbehaving. Frosty Seas says, I need a note for today and yesterday, please. Here's my lawyer note. Sue and Becky with the jewels. Thank you. Kate is what I'm assuming. Allie, you think the lesser included in Bowden is to reduce the chance of a hung jury? You know, again, we all say it, trust in red. You know, I don't practice in Massachusetts. He's practiced double the amount that I've practiced, you know, so I trust in him. You know, I always thought the voluntary intoxication didn't fit exactly, obviously, because it's not like it was more like involuntary because she didn't know what it was going to do, although she put it in her mouth voluntarily. Because there was so much of that language that I just felt was really helpful in that instruction. And then with the lesser included, I don't know. Could this get like, because the judge said he was going to do manslaughter without the words voluntary or involuntary, but allow him to argue the involuntary intoxication. So does that lessen the whole 20 years? I don't know. It's like I need to delve in more into their sentencing scheme than I have. But when I'm thinking, wait, she could get 20 years, that horrifies me. Like, wait, no, I don't want a lesser because I want them to say no. I don't want them to think, well, this is fine. This is our middle ground. This is our, our meeting spot. Like jurors meet in the middle often. Now, again, I don't know, and I don't know if anyone out there knows in the chat from anybody else, any other. I don't think that any of us know because I don't think there was any part of jury instruction or voir dire that was televised, or was it? I don't know. But if these jurors followed Karen Reed, and hold on. I don't know why I keep getting the hiccups. It's weird. Because then they saw how important it is to not just meet in the middle and be like, all right. But that's what they did there, right? It worked there. And you know why it worked? Because the meet in the middle spot was a DUI, was nothing, was not, you're not going to jail. I don't want to meet in the middle spot where you go to prison for 20 years. It's like, what? But if it's day for day, that's 50%, then maybe that is what you want. Maybe that is what you want. Because you're still going to be, you're definitely getting out, You're definitely getting out. So I guess maybe that's why, Let me just make sure. I don't know if I can get on Westlaw or just like trust a Google search. I don't know. Mm. Yeah, I need to do more research to see because they don't have like a day for day. It's like there are good time rules, but the good time rules usually end up being a day for day kind of thing. And, like in Illinois, there's certain offenses you can't get credit for, like credit for certain things. Like you're not going to get credit for taking a course or for, graduating high school, or like there's things that you're not allowed to reduce your sentence with. And I just don't know that information in Massachusetts. So I guess my best guess is that it actually, if she's able to get like good time or like credits for certain things, and that could reduce her down, that she has a chance of getting out in 10 years. Obviously, there's also a chance the judge doesn't give 20. He could give a much less. But this is a hard one. If the jury says guilty, the judge is going to be like, well, if anything deserves 20, it's this. But he might take all the mental health stuff seriously. But he is an old white male. But after hearing all this, maybe if he wasn't taking mental health serious before, he's taking it serious now. So I think that Bowden wasn't a chance to get not guilty. That's why he asked for the Bowden, is to try and get people to say they have not proven she committed this offense, regardless of the fact that we heard all this words about stipulating. And you're going to hear that from the prosecution. How many times did you guys hear the defense say they offered to stipulate? I don't know if they could say that because the stipulation wasn't accepted. But they could talk about in the opening. You remember in the opening, Kevin Reddington stood up here and he said to you, she knows she committed this offense. But Reddington will have to front that. You got to predict what the Commonwealth is going to say. I venture to guess that this is going to be a masterful closing. This man has had quite a career. He knows what he is doing. He also said he could do it in 30 minutes, but so maybe with this extra time, it's going to be able to be like, which also makes me think he's not using any clips. I mean, 30 minutes, he's not clipping shit. He might quote from the transcript, and he might put parts of the transcript up on his little blow-uppy things, So, but I think Bowden was in hopes of getting not guilty. And now I think the lesser is in hopes of she might actually be able to get out quicker than she would, in a, we got some movement. We got some movement. At least the camera guy moved. Thanks, Iowa girl. And thanks, Kat or Kate. Sorry, Kate. I'm assuming Kate because there's the I. So thanks for the jewels. We got Gina Humphreys or Gina or Yina. Sorry. Good morning, Alison, your Italian friend from the Poconos. I missed your answer if you're from Jersey or PA. So I was born outside of Philadelphia, but then I spent my summers. Oh, shit. Hold on a sec. And I was what you call a shoebie, growing up on the South Jersey Shore with my summers until the summer after middle school, so right before high school, and I moved to the Jersey Shore. So, the South Jersey Shore, Ventnor. Yeah, and I went to camp up in the Poconos. I used to do, so I'm very familiar with the Poconos. And welcome. And thanks for your generosity. Hashtag Patrick is lying. Shastar says, can you please pull up a photo of the house showing the basement window? If she said basement, wouldn't he have looked in at least once? He's right there. All right, let's pull up a picture. Okay. Let me see images. I mean, is this a good picture? That picture looks like shit. Let me see. Let's just do this. I mean, if the cops said that they could see in, like, I don't know, you know? Like, these pictures are no good. They're just, like, random pictures. Hey, let me go back to... Oh, geez. I hit a paywall. I don't know. I can't find good pictures. But I think it'll be something that, you know, these, God, you know, I don't know if you can see in if it's the lights are off or the lights on or the lights off. I don't know. All right.
Court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
Well, good morning, everyone. Good morning, counsel. Good morning, Ms. Clancy. All right. The party's ready for the jury?
Yes.
All right. I'll bring them in.
Hey, there's my husband. There he is. Look at him. Looking as handsome as ever. I don't see Lauren. All right, that Lauren a couple people down. Packed courtroom. That poor lady has to sit there with the camera right next to her. So no sidebar this morning. They don't need one. It's closing. Sounds like they might introduce some evidence. We'll see. There was a question when we left whether they needed to reopen evidence.
Hey. All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the full of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
All right. Thank you, Madam Clerk.
Yes,
good morning, everyone.
always on point, Madam Clerk.
You know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. They can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right? So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right? So my instructions on the law are going to be delivered to you in 2 phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which he is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect or wrongfulness of her capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There's no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing.
So that's why he's asking for manslaughter, because she's got a chance to get out.
The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and/or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and/or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation, even if she suffered from a mental impairment or consumed prescription drugs. But you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death, where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right. And I discussed those elements earlier when I discussed the charge or the theory of first degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right. Now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first degree or second degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora, Dawson, and or Callan Clancy. 2, that the defendant intended the conduct that caused the death of Cora, Dawson, and or Callan Clancy. And 3, that the defendant's conduct was wanton or reckless I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates, a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right, so that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right, and I'll go over that a little bit later, but I just want to remind you that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right, and so, counsel?
There was about 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows loss. And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell the jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will likely tell you, even though a person is a defendant in a system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one. A son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt?
Fake.
The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up, and she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat, Googling suicide, Googling drugs, Googling side effects, Googling ketamine treatments, Googling all of these drugs, Googling the effects of Tufts medications, lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, mirtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother, should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a corner. I don't know if you have to play pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses
Counsel, address the jury, please.
said, their witnesses.
Sorry. What he did right there that we didn't see is he slammed on their table. He probably pointed at them because he said, I challenge you to explain to this jury. And the judge is like, hey, address the jury. All right, sorry, I'll keep going.
Serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Lapasada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Lapasada and says, wrapped. They were just wrapped. They weren't knotted because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Lapasada said, yeah, I saw what you did. And she walked away like if the gloves won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Lapasada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they gotta have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations and she's talking to people and the kids are in the basement, her throat was crushed. You heard the 911 tape. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. you determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got charges before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Do they take pictures? Did they analyze? Did they test the blood? Did they? Lousy investigation of that. Well, that's okay because she was guilty, and they put her in the hospital, and she's the evil woman that killed the 3 innocent kids, and they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? You remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital, treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having your tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the what is it, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that, in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You read the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no, they were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory don't lie. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolata gave it to her.
Manipulation.
You have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it and we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with I forget where they rub the thing. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking, you've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting.
But not enough.
So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2, Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her, one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halbrun. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. They're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. And I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Duxbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her. And God forbid they actually sometimes have dinner. Remember that? They got the Duxbury records. Boy, there's a good score. Let's go through the Duxbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly. For 3.5 years, she's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. The guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records. She signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate. And more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Conley. And they were paid for their testimony. We're all paid. Like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Halburn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday, who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why? The how? And the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect. As Dr. Zeisel said, she was suffering from a disease or defect. As Dr. Condi said, she was suffering from a disease or defect. And Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence. So you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday that testified, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard, charging, manipulating woman that was controlling And everything in their life was controlled. And she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified, when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan put down for a nap. Hopefully will nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I didn't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time that she killed her children. You all remember this. October. This is not an evidence, it's marked for identification. It's too big, so. But basically, it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie there, The Shining, with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice woman. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the baby, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You'd think that goes right along line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live a life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact that it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% with almost 1,000 people that were examined report voices from inside their head. And it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, come on.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself.
That's not what you said.
That's not the issue in this
That's not what
trial.
you said.
The issue is whether at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The two older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for one 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you 2 options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications.
Objection.
She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up a dose, went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work and that it takes time for them to get into your system and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted it faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to MGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts. I need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never says she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, well, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she's just, no, doesn't want to do them and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time, because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore. Didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought. That telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought, because You don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad. It's because it's wrong. It's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Cora's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there, no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. make an appointment. Pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science, you have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report. And they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom obviously was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How did Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction.
She still has 40 minutes.
And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now, her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day. Very low dose. And then she told Dr.
I'm sorry, real quick. I promise. Someone told this woman to act like the most empathetic, sensitive, caring person in the world during this closing. And it is infuriating me because I know she's disgusting, but it's effective to come off like this. That's what she needed to do. And I hate that she's doing it.
Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis, all the way up to January 23rd. Nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. When this is on her phone, you can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Map search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there.
Then why?
What she needed to know was how long specifically on that night it would take to get there.
Yeah.
Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly How much time will I have? And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them and asks them if they have kids' Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it, and then go on to 3V, so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3D and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me
Headed
X, Y, and
out
Z?
the door?
And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34. And then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, what did you do? And her response is, I tried to kill myself. And then it's, where are the kids? In the basement. It's not, I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them. No. It's, I tried to kill myself. And the kids are in the basement. And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised. Her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911,
That's not what the
He's
internet
talking
told me.
to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know, from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time. And then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time. And then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground.
24 minutes.
And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well.
Huh?
And Patrick saw Dawson eating the chicken nuggets and green beans.
There's 3 kids, lady.
So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report. You can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's in stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied.
That's
But
tied.
even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots. And he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson. And he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own.
The jury's not stupid, lady. You just said they were tied. A knot and a tie? Come the fuck.
And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m. because he's making the call to her at 6:09. There's not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20 odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it.
She didn't kill her
I'm
mom.
saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted.
I'm so soft and empathetic.
And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
Said that was all accurate.
Objection. There
let's
was
move on from that.
an objection. Yeah.
Lindsay Clancy
Hmm.
hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance. You have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these 3 different versions. Another red flag, it doesn't make sense that she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise band. Choose again, exercise band. Choose again, exercise band. She had to choose how to kill herself. Now, if you're being compelled by this voice and you have no free will whatsoever, you're just doing, your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself.
Yeah, why?
We're not saying she didn't want to kill herself.
Yeah, you did.
We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse, those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. And she landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself.
10 minutes more.
And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked.
Not that you asked. I'm muting. You'll tell.
She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking.
No one knows
we
what
didn't
happened.
show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office. and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity.
No, it's not. It's the law. Object.
She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
All right, thank you, counsel. Now, members of the jury can sit here for a while. They may need a short break. I think that would. All right.
You guys, I am like beside myself. First of all, like the part of the reason I'm so angry is because, and I know a lot of you aren't going to like to hear this, there was a lot of that presentation that I thought was effective to a certain extent. Okay. To a certain extent, let's be like objective about it. That stupid demeanor she put on, like she's so empathetic, you know, and I know a lot of you are saying like the jury's going to see through it. The jury's going to see through it. They know what they were saying at the beginning and now how they're changing it. You know, let's hope. But that last thing she said, she didn't put them in their beds. She discarded them on the basement floor like broken toys, whatever. You know what? Everything we heard about this woman, if what she was doing was rational, if she was making her own decision and she was thinking, that's where the kids would have ended up. If this was the homicide that the experts talked about, that's where those kids would have ended up. The loving one, they would have ended up in their beds. The fact that they were just on the floor, I think to me supports that she was out of her mind. Out of her mind. But, you know, someone told her, you have to be a stark contrast to Reddington. Everybody knew Reddington was going to get up there. He was going to be dramatic. He's going to put down the corners. He's going to point at them. He was going to have a tone. So she put on her, and you know what? It infuriates us. I don't know if it's infuriating the jury, right? But she put on this fake empathetic and said so many times, that's understandable. That's relatable. I literally, when she kept saying that, wanted to reach through with this back scratcher that those of you who are just getting here that have been kicked out of Mel's might not know why I'm waving this thing around, and just literally grab her by the face with it. It wanted to just, I've got to, I really do. I have to regulate because let's just make sure. I'm sure the judge broke is what he did right here, but let's just make sure.
Everybody get there. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing. All right.
Let's see what he said.
Everybody get there. My instructions. All right. Sitting here for a while. Anybody need a short break? I think that would...
No,
all right.
Want to get it through.
So we're going to return now to the instructions
let's just keep going.
that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but specifically for the charge in murder in the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. So now I'm going to go to the general principles in regards to this case. All right, now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments.
All right, let me ask you guys, chat. Do you want to wait, discuss, let us vent and then listen to the instructions on 1.25? Or do you just want to get through the instructions and then I read your chats, we vent, we do whatever? How do you want to do it? How do you want to do it? All right, we'll stand by and see what you guys are saying. All right, vent first. Get through it. Get through it. Vent first. All right. We're going to just keep going. There's a lot of you that say keep going. We'll get through it. Regulate. I'll put it on 1.5 until we're caught up because we've got a couple
with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you, unanimously as a jury, that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless her guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. The charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial was conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of a hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions, anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying, and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, you have heard some evidence suggesting the defendant's actions after the killings. I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? We said, so I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right. So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay. Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following. All right. You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring you back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you keep.
Ay, ay, ay. I mean, I don't. Can you guys see me, or the whole thing is shut down? I mean, I don't know what's going on. If I got to go let my dog in. Oh no, you see us, but can you see the stream? Is it paused? You can see and hear me. Can you see the? All right. I don't know what the hell's going on. The stream is paused. Okay. All right. So I should click play.
Continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing, send me a note and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone. All right. Now, your communications with the court officers should have to do really just matters of scheduling and breaks when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right. So no subcommittees in a sense. What you do as a group. All right. You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury. All right. When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this was a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12, all right? And so the way it's done is the clerk will draw the alternates' names, we put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, they would have to substitute
you guys can't see me again?
one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. So I put in here, fate makes you an alternate juror, don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
People are saying back up.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12.
Some people are saying we're back and some people are saying we're not. All right.
Juror number 385 in seat number 14. Juror number 122 in seat number 6. Juror number 124 in seat number 7. And juror number 245 in seat number 15.
All right, thank you. Now, what I kind of had forgotten to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callan Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation, or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know that we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest respectfully that you each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence in the law.
So are we up? You
Now, I'm
guys-
about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
All right, I am sending something to the pool camera people about what the hell's going on, because this is bullshit. Oh. Give me a second. And Bob's going in there to talk to someone too. All right. All right, let's see what's happening. I don't know. You guys see some of us? Like we're back? We're not back? See if we're live. All right, we're live. Oh, frustrating. All right, we're back. Yay. You guys can see us live. All right. All right, so I'm going to start going through your stickers because now I'm like, got so worked up about and stressed out about this that all the comments we have about the closings are like out of my head. All right, let me just start with this. First of all, Ian Runkle is going to be joining us. I've offered Mel to join us if she wants to. I don't know if she's still having an issue. It sounds like Attorney Bederow is going to... Oh my God, we're gone again? What is happening? What is happening? I don't know what's going on. Let's see what you guys are saying. Maybe we need a new stream. It's working on X, so X can see us. New stream. Should I start a new stream? Now you guys can see me. Refresh. I'm not refreshing anything. Here's what we can do, you guys. I know, and I have, and that's what I'll put up, all of the jury instructions. The jury is being sworn right now. I'm not going to put it up. Jury has been, the jury has retired. It's gone. Okay. So that's over. That's done. Now, got questions about jury instructions? You want to hear another instruction? I hear you guys saying a new stream, and then Bob is saying, okay, a new stream. But let me try to, I mean, there's, at least this is saying that we still have 12,000 people here. Oh, start a timer. Okay. Timer. Stopwatch, start. Okay. And then I've got it running on my phone. I'll figure out how to put up a timer. People are reaching out to me on, okay. So we're going to keep the court feed off. We're going to just keep going like this until someone tells me otherwise. I have the model jury instructions up. Do you guys want to go over any jury instruction that you didn't think you heard? What do we want to do? I wish that, all right, so I'm good on YouTube. I don't want to create a new stream because I started to say it. I don't know if you heard me. Ian Runkle is going to join us soon. And in a little bit, Bederow is going to join us. So I'm going to have a little panel. I'm going to keep this up unless somebody tells me take it down. I invited Mel. She's always welcome. She's always welcome. All right. So let's rage, and then, okay, so that's what we're going to do. We will rage for now. And then if people want to go back and hear any new jury instructions, we don't need to play the feed for it. I can just read you the jury instruction. Let's go to our supers. Let's see how we're feeling. I've got tons of notes. I've got tons of thoughts, but I'll answer them like through your supers instead of just starting to talk. I'm going to start with this one. It was right beforehand where Shaz said, can you please pull up the photo of the house showing the basement window? If she said basement, wouldn't he, Patrick, have looked at least once? He's right there. And then during the closing, there did say that the state did say, the Commonwealth said that the officer could see right through the window and watch him unwind. I mean, let me ask you this, lady. If he had to unwind, then I guess it didn't just fall off, right? So we got Mama G. Thank you. Thank you, Selena, for your membership. Chief says Commonwealth witness testified he didn't listen to 911 yesterday. He said he did. I think that was two different experts. So he listened to it that night. Unless I'm wrong, I think that was two different experts. Had to get it from the Commonwealth. Is that an issue? That would be an issue if he had done it during his testimony. I think maybe it was two different people, but thanks for your generosity. Manslaughter in Massachusetts, probation and up to 20 years. I mean, that to me is scary. And we talked about this, but there could be good time that gets that 20 years significantly down, and it could give her a chance of getting out. And I think that that's the but I think that Tracy and Bob, although Tracy's in the middle of some stuff right now, I don't know that she can help at all. But somebody gave us a clock to put up for verdict watch. But for now, I just have it running on my phone at 3 minutes and 44 seconds. So, you know, I don't know. Bob says start a new stream. Like, start a new stream now? All right. Well, maybe we should just start a verdict watch stream. No, because I have to go through all these supers. So no, too many supers. So I'm not going to start a new stream until I go through all the supers at least, because y'all paid good money for those. Hey.
How are you? Can you hear me?
Wait, hold on. Here you are.
Oh, can you hear me?
I can hear you.
Do you see my pathetic dog? It's raining and storming, and she's freaking out in the corner. Just staring. Yeah. How's it going?
I mean, I wanted to like be pulling my hair out of my head. I need you to tell me that, because Bob says he didn't think it was effective, and I thought the little empathy game they started playing, that she's reasonable. It was reasonable and understandable that maybe that might have been having an effect on the jury.
I thought I don't think she addressed the issues that she
No.
has. I mean, she has this kind of really antagonistic problem called burden of proof. And I don't think, and I mean, in all fairness, I don't think Reddington did this either. I feel like they both mentioned the word reasonable doubt in conclusory terms, but never got into it. And ultimately, it's her problem more just because it's her burden. But I thought, I mean, I get what Reddington did, you know, the whole, he's really good on his feet. He's really charismatic. He's really old school. He relates. But I also think that, and we could talk about this too when we go up there. But the risk is that you do kind of ramble and kind of like thoughts get a little bit jumbled and you might forget stuff. And for me, I don't know why he didn't say that reasonable doubt means in this context, if my expert is even remotely plausible, just this much, then we're done here. And I feel like he kind of left that on the table.
I thought the same thing. I bet it's in my notes of things to say. Like,
that was the big one.
If you're contemplating this, if you're this, if you're that, reasonable doubt. If you're this, reasonable doubt. Like 100%.
It's so weird, you know, on all these big ones that everybody watches, at least the ones I have, the lawyers generally haven't done that. I don't know why. I mean, he mentioned reasonable doubt 100 times, but he never explained the huge advantage of them having to disprove it. He just said they have to disprove it. But I just thought he left that a little bit on the table. I guess the best props I could give what's-her-face is picking up the quarters. I mean, touche. Right. I mean, you know, if he tries the stunt and she plays along, I mean, you know, she's not exactly charismatic, but I actually chuckled and said, all right, maybe I don't dislike her as much as I thought I did.
What did you think? Do you think the jury saw through the demeanor change, or do you think that demeanor change was as effective as she wanted it to be?
I don't know. I mean, they've seen her the whole time. They've seen how wooden and unsympathetic she was. And then today she shows up, which means she probably is looking at social media and all the criticism. But I don't know that it's going to matter. I mean, look, I even said this on Twitter too. When she first started, in the first couple of minutes, I thought, okay, finally, she's acknowledging this woman is ill, but that is not necessarily an excuse. You still have to satisfy, right from wrong and all of that. And I thought she was going to like actually do it the way that they should have from the beginning. And then she just veered into this. It's Clancy's fault for not taking her medication. And she basically said, without saying it, that she's some rich, white, privileged woman who had access to all this healthcare, and she blew it, and she didn't want to take her pills, and she didn't want to do this. And so I thought she got really rambling. And then this idea that she went to a birthday party and was laughing. So clearly that means she knew what she was doing. And then she just kind of buried in the middle the whole sending him out to get food in CVS, which I think that's their best argument. I mean, I think that's a fair point. I don't know if it's enough to carry the day with the burden of proof, but you could make a good faith argument that that's, I don't want him to be around because I'm about to do something and I just want to be dead, when he gets home. And at that point, who cares? And I think she just like threw that in the middle when everybody was already asleep. I mean, I started wandering off. I wasn't like raptly paying attention to her. So
All right, we got an addition to our panel.
Oh,
It's Ian Runkle.
oh, look, there he is. Finally.
I didn't
Hello.
even say it's Mark Bederow. I mean, everybody knows it's Mark
We've been
Bederow.
trying.
Say hi to each other. I got to close my door.
We're here. How are you? This isn't how I thought it would be, but here we are.
Well, tired and still a
my
bit sick,
God.
but this has been such a bizarre trial.
It's Massachusetts is like crazy, right? I mean, this is like the grifting YouTube capital of the world. Everything comes from Massachusetts.
I need to ask you guys a question because to me,
If
I
you ran
thought-
that close here, you would get yelled at by a judge, followed by a mistrial, followed by and get your checkbook because you're paying for it.
Yeah.
Well, because in this, what I wanted to ask you guys, when she said,
Oh, Andrea Yates. Oof.
when she, well, the
Oh.
Yates thing too, but just, how she could conform, that we have satisfied that she could conform her conduct to the law, which to my understanding, and I'd love to hear from you two lawyers, doesn't mean that she could conform any old conduct to any old law, but that she could, comport her conduct so as to not break this law, to not.
Yeah, I
murder.
think what it means in this context is that she was not so psychotic that she just couldn't control what she was doing. And in other words, like, maybe I shouldn't be wrapping exercise bands around my kids' necks and I'm not supposed to do this, which is kind of similar, knowing right from wrong. But yeah, I think if she kind of left it out there without explaining it, perhaps there should have been a correction there. I agree.
I mean, I was like, that's not the law. It's not that we proved she can follow red lights and stop signs. So that means she could conform her conduct to the law.
Right.
I mean, the Andrea Yates thing should have
That was
just been,
horrible.
it shouldn't have been, move along, counsel. It should have been, counsel, you're done
Well,
here. Sit down.
Correct me.
This is over.
Correct. Because I know you guys saw this too. I mean, I had it on in the background, although I was paying attention at this part specifically. But I thought I heard him object, and she just kept rolling. And
She
he
did.
objected again, and she just kept rolling. And the judge was kind of shell-shocked for like 5 seconds. And then he just kind of gave a, let's move on, as opposed to stop what you're doing and let's not assess Andrea Yates, who, by the way, was found not guilty. So if we're going to play that game, that was bad. I thought the Yates thing was not cool.
No, if you pulled that here, the remedies I would expect to be on the table would be mistrial, termination of your close. I've seen that issued as a remedy for some improper close, is just like, okay, your close is over. That's it. Counsel just said something that is wildly inappropriate. You are to strike it, and counsel's close is finished.
Well, that ship
or
sailed
the
a long
mistrial.
time ago. the mistrial on inappropriate conduct. I mean, it's kind of unfortunate, but it's one of those like the bad guy rule situations. A mistrial here, and if you said it's because of the DA's fault, I mean, they would literally wheel her out of the courtroom and say adios. I mean,
Yep.
go ahead. You want to go get lunch? I mean, it's just
And
one
the
of those-
weird thing is that I don't think she even wants that. I think she wants the mental health treatment. So she'd probably be upset with just the mistrial, because if you're, confined to treatment, usually that's paid for by somebody, and I can't see how she'd be able to pay for it otherwise. So
yeah. I mean, look, I don't know what's going to happen here, but I don't know. I'm a little. I feel like Reddington did a good job, but he left like a lot of ammunition in the tank, which is kind of stunning. And I guess that's just the risk of like without a net, right? It's really impressive to watch visually without notes and without whatever, but especially towards the end, it started to get rambly, and
it was a bit rambly for sure.
Yeah.
And there were points where I was just like, dude, you got to pull this together. There's somebody's entire life on the line.
Yeah, it's I think I made a note that he started a sentence and then went to the side and then never came back.
He did. And I think it was related something about Ian Whiffen and Celebrate. And then it triggered a thought. And I hate to say this is not a political comment at all. That's what Trump does. He starts a sentence talking about A and tries to refer to B, and then B takes him down a whole nother road, and he's talking about something totally different. That's kind of what Reddington did.
Right. And I'm trying to remember where I wrote it, but I literally wrote the words got sidetracked and I was waiting for him. I was waiting for him to come back to it.
Yeah.
And I also thought, and I did he focus enough on the whole, was the call in the middle, and as opposed to the way the Commonwealth is saying that I thought the Commonwealth said it more clearly than he did. The defense would have you believe that the voice that all of this started after the call. And I was thinking, did the defense make that clear that we think it was after the call, that we don't know when he really left?
No, because I think what he did, again, very effectively in his charisma, and I'm sure the jury was captivated and eating out of his hand, but it was very broad stroke, non-specific, and I guess the word I'd use is conclusory with what he was saying, but not necessarily backed up with here's how you know on everything. And one of the things that I think she did effectively, which I don't think there were many things, was at least to attempt to kind of break down that timeline and make it sound not plausible, make it sound like it was the product of planning and awareness of I shouldn't be doing this. But then I feel like she also left, the ultimate issue on the table too, which was there's this great big burden, and here's why I've satisfied it, and here's why nothing they're saying matters. I mean, you hear her finish, and then the judge goes right into the reasonable doubt charge, and you're saying, how did nobody really talk about what this means? It's crazy.
I was kind of shocked by that, because for me, every single close I talk about reasonable doubt, and I talk about reasonable doubt even if it's a close in front of a judge alone trial.
I all the time. It's you burn a hole through the verbiage. And I'm having flashbacks to all the Reed discussions that we were having back over the couple of years, where it was the same thing in the first case, particularly about, why didn't they talk about reasonable doubt and say it again? And every time you think you've said it too many times, go say it another 7 times. And why this, that, and the other. And I don't know. I mean, he didn't really focus on his expert, which is really the whole case, really. It's surprising.
Yeah, we've got the best expert. Everybody else agrees that our expert is the leading guy, so
that's
listen to our expert. When you get the other expert to agree that your expert is, king of the hill, man, you wouldn't be able to shut me up.
Right.
He did, but he left. I thought the setup is I have the world's leading. I mean, he said that. He definitely said, and then, but he didn't finish. He didn't say you would have to completely and thoroughly discredit everything he said in order to find proof beyond a reasonable doubt. And even if he's just maybe he knows what he's talking about, just this much, maybe if it's plausible that he knows what he's talking about, as opposed to these other clowns, my words, not his, obviously,
Right.
then, and why not just say you only need to find reasonable doubt? And why not in a case like this, where you concede guilt from the get-go, why not even say what reasonable doubt means in the abstract, meaning you can think she probably did it, but and we know she did, but if there's a little bit of just, I'm not sure about her mental state, that's legally, not guilty by reason of mental disease or defect. And I almost wonder, I don't know what a judge would have done. He allows everything in light of the fact that he was giving the charge, which they, I think, requested properly, that don't worry, she's going to a mental institution, like she's not walking or wheeling out of the courtroom. I wonder if he should have tried to touch on that and see, what the judge would do or not do, just given that what they were doing.
I mean, the judge was just so permissive of such wildly inappropriate things.
Yep.
And the problem is they're like, well, it's a murder trial, I'm not going to throw out a murder trial. But the problem is that if you take that view of like, I'm not going to throw out a murder trial, then what it is, well, these rules of evidence and these rules of procedure that we have are super important unless you're facing life in prison, right? Like, unless all the chips are on the table, then they can do whatever the fuck they want.
I think it's even worse than that, because I've seen, certainly here, cases where murder cases, there are consequences. The problem here is the conduct is so awful. I mean, it's as awful gets. She's layperson word crazy, or was, or probably is not well. And the idea that, it's not like O.J. Simpson, right? If he gets off, it's like he's not going to reoffend. He solved his problem. It was a very unique thing. He killed someone and whatever. The concern with her, Clancy, right, is that she's not well and probably shouldn't be around anyone given what she did. And this judge knows that if he were to grant a mistrial and literally let her go, that I agree with everything you said. Either you have rules, exclusionary rules and constitutional rights or not, and it's harder in the harder cases. But the reality is they were never going to let her go because of what she did.
There are still some sanctions that I think were on the table that are not like quite as nuclear, but would have been viable. For instance, I would have been very tempted with Heilbrunn to just say, all right, Heilbrunn is excluded. Jury, you are not to consider anything that this witness has said. Prosecution, think real hard about where you want to go on this one, because, I'm not screwing around.
Yeah, because I said we should have had a voir dire of the witness. Did you discuss this aspect of your opinion before she put you on the stand?
I think the only remedy was a mistrial. They did it twice. It was clearly intentional. And I think, to your point, Allie, at a minimum, jury, go home for the day, possibly tomorrow, and let's have a mid-trial. I'm going to come back in 2 minutes, okay?
No worries.
I think they should have done a hearing on that. I'll be right back.
Yeah.
Sorry.
Yeah.
And then I'll shut my...
Okay.
Yeah, an evidentiary hearing on what exactly, was said. What was your prep? What was,
right.
Was this intentional? And
Ian, did you think that the change of demeanor and the way they kept calling her relatable and understandable and was effective?
I thought that they hit a much better emotional tone, like the Commonwealth in their clothes. And to a certain extent, better than Reddington. Like, Reddington was kind of angry, but he wasn't going for sympathy, which maybe he should have a bit more. But, I mean, the thing that sort of, as I'm listening to it, I'm going, okay, this is a new theory, because every time the Commonwealth talks, they have a new theory of the case. I'm like, so you've got a new theory of the case. Wonderful. We get one of those every day. Cool. They told the judge, we're not going to suggest that this was a fake suicide, but then they're like, we're not saying this is a fake suicide, but look at how fake it is. And I'm going, if I'm the judge, I am not pleased by that at all. And I would probably say, I would probably just say this needs a curative instruction, And the curative instruction would probably be something along the lines of, the Commonwealth has stipulated that this was a serious suicide. I mean, you've got to,
I thought,
and they're coming up with new theories that have never been articulated at all, which is kind of, an ambush strategy. And I'm going like, where is this coming from? You didn't put this to any of your own witnesses even. The whole thing about she needed to remove the protective factor. Which of your witnesses did you run that by? Because if she didn't run that by any of her witnesses, then it's a new theory and they're ambushing the defense with it at the last minute.
Right, and the mom was one. The mom's still alive.
Yeah, well, this whole thing is like, where are we, where is this coming from?
And I thought that did you think that Reddington should have addressed, to your point about new theories? We all knew there was going to likely be new theories, right? That he should have said, because he started to say something like, pay attention, I told you this, but to more clearly say, they're going to stand up here after me and say something completely different than they told you in the beginning. And you need to consider.
Probably would have gone through a timeline of prosecution theories and just be like, in the opening, they said this. And then their own witness said that was not, accurate. He said that was, downplaying things. He disagreed with it. So what they told you in the opening, their own witness disagreed with it. Now, then they suggested this. Well, they backed away from that. Then they suggested this, and now they backed away from that. You're probably going to hear something new and exciting in their, in their close that I haven't even thought of yet. And, you should be skeptical of that because they're just grasping at every little possible straw to try to get a conviction here.
Right.
And, this isn't somebody who knows what's going on and is trusting their experts, because if they were trusting their experts, they'd already have the idea of what was happening. Instead, it's somebody who's willing to go with anything. And, I would have pointed out, like, their theories don't necessarily make sense. They're willing to come up with any theory that they can to try to secure a conviction. You heard from them that it's impossible to crush a pill bottle or to crush a pill without specialized tools. Well, that makes no sense. You know that's not true.
And he pointed out those manipulations and those changes to a certain extent. I wish he would have just tied it
hammered on it.
Right, hammered on it and tied it into how the experts relied on it. Like the pill crushing you just said. That was one of his experts' factors that they relied on. So what I'm hoping to see as a result of this is questions coming back from the jury. Like, Your Honor.
Did you see my short on that one?
No. People kept saying it, and I was like, well, I'm sure I can play Ian's short, but let me. And then I was like, oh, I should probably ask him first. But if you want to pop it up right now.
I'm just trying to see. Oh, can I present it? Video file. Let me see if I can find it here.
Stop sharing mine, just in case that you should be able to present. Hopefully he knows he lost his signal.
It'll come back in just a second, I'm sure. There we go. All right. So I put it as a present, but you have to actually pull it up.
Pushing pills is really a challenge. If you don't have the right equipment, if you don't have like a mortar and a pestle that they might have in a pharmacy. And so what I wondered about was that process of crushing the pills to the point that
the beer
they
bottle
were
was actually
powder,
the hardest one.
in order then to put them
the
in
rounded edge. I should
lemonade,
use the side.
and then drink them. And so that is, to crush pills, significant number of pills into fine powder.
Oh, wait for it.
Is not an easy thing to do, particularly if you don't have the right equipment. It's just kind of a laborious process.
That onion might have been a harder one. Took another second. No, that is great.
Because, it's so stupid. You need some specialized tools. It's like, no. So I just kind of looked around my the little room I was in. And I was like, what is the dumbest thing I can use?
Right.
And, onion. and the onion worked just fine.
It took an
The
extra
only
second.
difficult part with the onion is that it was kind of soft, so
Right.
pressing didn't work as well. But like just kind of bouncing the onion on it just worked. Worked peachy.
I
So
hope you didn't need those pills.
no, they're actually what is it? Quetiapine. They're actually
Oh,
I got a prescription for it at one point because they thought it would help me sleep. The problem is that if I take even a quarter of one, it ruins like not just that day, but like several other days. So it wrecks the entire day because I'm in a fog for the whole thing.
yeah. They
So
gave
it's like,
my
okay,
father-in-law that to sleep, and he literally said he felt like he was going insane.
yeah,
He probably took stronger than what you were doing.
it's the ADHD doctor, was sort of prescribing them because I'm like, ADHD, it gets in the way of sleep. And he's like, how about this? And I'm like, it really sucks. And he's like, well, try it again. And I'm like, I'm not taking it again, dude. So, but
So now speaking of that, I thought that was burden shifting. I thought that they tried to convince this jury that if she didn't tell her
it's absolutely burden shifting. If she
didn't get the right
and it's
type of
irrelevant.
Yes.
It's because the thing is that those defenses apply, and there isn't a requirement that you did things properly, right? There is no requirement in that law that you had to have sought proper treatment or anything like that. You can be a homeless person who is actively refusing treatment, and so long as that's where your head state was at, that's still enough to. So, like, they're not chasing any like exemption to the law. There's no, but they're just basically saying she didn't do things right. Therefore, you shouldn't give her the benefit of this defense. And it's an argument based on entirely improper grounds.
Exactly.
And the judge allows it.
But
Reddington doesn't
I thought
speak
needed
up.
to be an objection because she's
Reddington needed
the
to
law.
stand up a lot more for himself.
Yeah.
And
because, you're old school, and us defense attorneys, it's like, oh, you never object at a closing unless it's something this egregious. What could be more?
You don't object to a closing without a good reason.
Right.
And the thing is, I basically treat it like, okay, you don't object unless you've got really good things, but you really want to object if they give you those things.
And I think
because you absolutely want to object to a close if you can. You just realize that you can't do it unless they, give you certain, basically, unless they open, that door for you.
Right.
You can't do it. But if they do, then absolutely mess with their clothes, right? Why wouldn't you mess with somebody's clothes if you can, and you're not going to get yelled at for it?
Right.
So,
But I thought he needed to predict that they were going to blame the way she took the medicine, the way she got her mental health treatment, and explain to them. It does not, even if you believe that the Commonwealth is going to come up here and they're going to tell you she didn't get medical treatment right. She didn't say enough to the doctors. She didn't take her medication right. That is not the question before you. The judge will instruct you. Even if you believe she did all those things they say, it's if those things, doing whatever the Commonwealth says, she took too much, she took too little, she didn't say the right words. If those things ended her at a point where she was unable to conform her conduct to the law, then she is not guilty. It does. And
I would have asked for a curative or a clarification on the law on that.
Yes.
And just say, look, judge, based on the Commonwealth submissions here, the jury is likely to be misled and to have an incorrect, application of the standard they are supposed to apply. So this has to be fixed, and you're the only one who can fix it. So, judge, do the judge thing now, please.
Right. And I felt equally strong because their expert said the same thing on the stand, and I was screaming when he said it. He said, how do I know she could conform her conduct to the requirements of the law? She got in the car and she followed the rules of the road. And I'm like, wait a minute. You can't just say she could conform her conduct to any old law. I know we just talked about this, but to me, it's important. She had to be able to not commit the murders. And again,
how do we know she actually followed the rules of the road? Like, were you behind her? Did
Right.
she, did she use her turn signal? How many times? Was it, once? Was it every time she turned? Was it never?
But
Like,
still,
how would you know that? Oh, you just made this up. You're inventing convenient facts because you've already come to a and
conceived-
I mean,
right.
I would have
And-
hammered
and
this guy.
by
I would
the
have just
way,
been
it's
like,
a misapplication of the law because it doesn't matter that she could walk in a house and conform her conduct.
I mean, my cross-examination of that guy would have been a bit different. I would have probably started with, let's go through all of your, your publications, your whatever. The same way Reddington did. I really liked that of like, let's go through everything. And okay, you're a government man. Objection. Awesome. Have you heard of confirmation bias? Yes, I have. Okay. Can you tell the jury what confirmation bias is? Yeah, confirmation bias is you come to a decision and, whatever else. Okay. So, and you'd agree that part of confirmation bias is that you might accept a weak argument that supports your position and reject strong arguments that are against your position. Yes, that could be part of it. Okay. So let's talk about the pill crushing. You're saying that is and I just want to quote you here, tell me if I got you improperly quoted. You said that would be a laborious process without proper equipment.
And something you considered in finding this, and something you relied upon.
And you stated that this was something you relied upon. It was sufficiently something you relied upon that you felt the need to tell this jury that it was important and that the Commonwealth asked you the question, right? Yes. Yeah. Okay. And you might even go so far, if the court will permit it, to just be like, these pills are lamotrigine, aren't they?
Right. He's a
Crush. Was that easy or was that difficult?
Yeah.
So you'd agree that you don't need proper tools.
right.
So
Mark, we were just talking about, I want to know your opinion. Do you think it was either burden shifting or even just a misstatement of the law? The way they tried to make it to me, they were telling the jury, if she didn't say the right words to her doctors, if she didn't take the right pills, if she took the wrong pills, if she didn't take enough pills, she is guilty. Like you can't find that this defense applies. It seemed to me that's what they were arguing.
Well, the way you described it, that's definitely burden shifting. She can do nothing. The burden of proof is on them, and you can't find her guilty just because of that. And that's kind of what I said earlier, even on Twitter, and I'm sure we'll talk about this when we do this. That first 15 or 20 minutes of her closing, where it was just about, she had the best doctor, she had this, and she didn't want to take her pills.
Convict her because she had money is basically what that felt like.
Right. And also, but on top of just being stupid and irrelevant and failing to react to a really powerful closing, like by going into her clearly canned speech, which most prosecutors do, they just can't react in real time. I think the idea that if that's how she's winding up to say she's guilty and it's her fault because she's a shitty psych patient, that's irrelevant, it's prejudicial, and probably burden shifting because if you're describing it in the context of find her guilty because she didn't want to take her pills. That's kind of what she said.
Right.
I don't think she I think she said and she was a nurse and she should have known to take your medicine. Yeah. Okay. And she's clearly ill. So what? Did she have the ability to form criminal intent or not?
Exactly.
I get it. She's a bad person and a bad patient. Okay. What does that have to do with whether she's legally guilty or not? Nothing.
Right. And that's what I thought. I had wished, look, there was a lot of things about Red's closing that I loved. And I know it's very easy for us on this side of the screen to be like, well, he should have said this, should have said it. I get all the time to sit here and think about it. But that was one of the things I thought I wished he would have predicted. He knew she was going to say she didn't take the meds right. She didn't get mental health right, to make clear that even if you believe, and we just said this right before you on, but even if you believe she didn't say the right things to the doctor, she didn't take the medication right, she took the wrong medication, she did this, she did that, none of that matters, because even if those things led to the point where on the day in question she could not conform her conduct to the law, or she did not understand the illegality or criminality or moralness, wrongfulness of her conduct, she is still not guilty, because that's not the question you're asked to answer. If she took a pill wrong, if she took her pills wrong, and that led us to, on the day in question, she couldn't form the requisite intent, not guilty. If she didn't say the right things to the doctor, I mean, that kind of thing.
Yeah, no, I agree. I thought the prosecutor's closing mostly was bad. And I think the time where she was most effective was when people like myself were already kind of veering to like, what else do I need to do? Because this is not very interesting. And it just kind of got buried in the middle about what would have been the strongest evidence of the argument about knowing right from wrong and being able to conform yourself. I think it was a very effective point. I mean, I've seen these cases. Every prosecutor would make them. Sending them out to get dinner and then go to CVS, and how long is it going to take? And then the kids end up dead and you tried to commit suicide. So stay away, not telling him literally, but stay away. So when you come home, we'll all be dead. I don't have to deal with this. Turns out for her, she lives, and here I am. That's a powerful argument. I'm not sure how you don't lead with that.
And
I said yesterday, it's like, first of all, I wouldn't have saved that for rebuttal. I would have had that as before the defense gets to put on a single witness. I would have had that guy as my last witness if I'm the Commonwealth, and I would have cut 90% of the questions they asked. I would have cut the thing about the pills, because it's not only like the guy just bullshits on the stand,
and there was no residue,
and and it just opens up. I would have just been like strategically laser focused on, so let's talk about this whole thing of sending him away, sending him to this restaurant that, they don't usually get takeout from. What does that mean to you? How does this connect to the test? I probably could have done.
Closed, by the way.
What's that?
I don't know if Reddington knew that. The chat has said that the usual place they went was not open that day.
Yeah. And I mean,
of the week.
You can just say,
did
like,
she know that? I mean,
this.
there you go.
Yeah.
I'm sending you to a different place. Anything, I hate to get all Columbo again, that people know I like Columbo, but little things or anything that seems out of the ordinary. I mean, this happened to be the day my regular place is closed. Go there, go to CVS. How long is it going to take? When is he going to be home? To save that for rebuttal, when that's your most powerful evidence, that's not rebuttal evidence. That's your case. What are you doing?
That should have been on their direct, like just on their case in chief. And I would have had it as their last witness. Just this is the laser point. And they needed to be ready for things like, I mean, I thought Reddington also addressed it pretty poorly on cross, that particular element, because the aspect of it being closed, people were talking about that on Twitter and so forth. Maybe Reddington doesn't have the resources to check Twitter on that one, but, like suggesting to the witness, oh, and you thought it was very significant that she picked this place that was new, right? Yes. Would it affect your reasoning if the regular place was closed on that day? Okay.
Right. And like he did when he was like, do you know I was on a 1-month trial? When she tried to make the point about the family members didn't get back to them, and they said they wanted to hear from him, and he stood back up and said, but did you know that they couldn't get a hold of me because I was on trial for a month? So that's why they didn't call back?
One of the other things, correct me if I'm wrong, because I didn't like watch the whole trial gavel to gavel and don't know everything that literally happened. I did watch the closings, the whole thing today. When Clancy was in the hospital after this happened and came to, didn't she make some kind of statement about like, how are the kids, or the kids are something along the lines?
Kids are safe.
Are the kids okay, or
okay.
something? Yeah, are the kids safe?
She said to the chaplain, I'm glad the kids are safe.
Okay. that would seem to suggest like I'm still in a psychotic state then, or in another one right then and there. Cause that's a weird thing to say. I don't think there was any reference to that in the summation from his side, which I probably would have mentioned. If I missed that, I don't think I did, but if I did.
thought that the chaplain was one of the strongest witnesses because of that. And I went back to find where I wrote, he went to the side, and you were exactly right. It was during within. And he started to say that there were three, he said, the government bears the burden of proof beyond a reasonable doubt. They called Cellbrite. I mean, they called within. You didn't just, who said it doesn't count going down, it just counts going up. And there were 3 stairs climbed. At 5:38, what happened to the phone? Did she just put it on the bed? It could have been anywhere. And I thought that was such an important thing to follow up with that whole, was the phone call in the middle or the beginning, and why the stairs don't matter. And then that's where he got sidetracked, as we talked right before you got on, and started talking about the CVS thing, and that he needed the Muralax. And then I kind of thought, which is what you were talking about, Mark, that in the middle, the prosecution came up with this explanation, because a lot of us are saying, who the hell calls and makes sure the product is there? You don't really need the product. Your kid's about to die. Why are you calling CVS to make sure it's there? Wouldn't it have been better to send them somewhere where they didn't have it? That's going to take longer. And she pulled an excuse out of her ass, which I'm sure she was saving for closing, which is the best way to do it, that what she was doing was making sure it was there so he'd have no reason to call her, so she didn't get interrupted.
But the thing is, if she didn't want, like, it's really easy to just send a call to voicemail, right? Like, that to me doesn't make a whole lot of sense.
No.
And this notion of like, she's calling to make sure it's there. I'm like, if I was trying to stall my partner out, and I just wanted to make sure that they didn't get back in time, I would absolutely do something like,
make sure it's
send them to, like, call around, find a place where it isn't,
right,
and then be like, okay. And then when he calls, you just don't take the call. You send a text going, can't talk right now. What's up? And he'd probably text and say, they don't have this. And you're like, okay,
go to the other one.
We really need this specific variety. It's got to be this brand. It's got to be this, like, please make sure, like, you're going to have to go to another pharmacy. Right. That would have stalled him out for another half hour. Like,
I can't get past how the prosecutor, the two of them, whoever, Sprague, ADA Sprague. Well, is that offensive too?
Attorney Sprague.
I've by the way, in New York, we would call you Mr. Runkle and Miss Motta in court. And same. I have repeatedly in Massachusetts called, Mr. Cosgrove, Mr. whatever. No one has ever given a look or anything. They probably know this guy is not a local and is clearly making it obvious, but everyone just kind of like doesn't care because it's not inappropriate. That was ridiculous. But I still don't understand how in her summation, she makes a few of these good points. She talks about a lot of other stuff that doesn't matter, but never knowing that, and finally conceding that Clancy was seriously ill, muzzle tub for admitting that finally, but never embracing the burden of proof and saying why there's no reasonable doubt, and addressing the defense expert, not really anyway, not addressing the points that Reddington raised. I mean, look, there is such a huge advantage in any trial, and trial lawyers know this, in going last. It's the biggest advantage, bar none, of anything. They get to go first and they get to go last, and it matters, people. It is a huge advantage. You get the last word, and you often see prosecutors, even when they do it without notes, like she mostly did, which is fine, and that's impressive, but it's canned. I mean, her whole 30-minute windup of, this white, privileged, wealthy woman who had access to this, that was clearly canned, as opposed to maybe I should react to what the lawyer was saying. And the ironic thing is, the only thing I saw in which I give her credit for in terms of reacting to the defense summation was playing the pool quarters on the table game, and touche to that. That was a cute little stunt that Reddington did, and she threw it back, and I hope she didn't steal the quarters, by the way. I did know she put them in her pocket, but as it were, on like the critical points that the defense was raising, even if he didn't really hammer home the presence of reasonable doubt based on his own expert, she didn't really address it. And it didn't land when she was not addressing that, but is talking about a children's birthday party and a smiling mentally ill woman, which means clearly she knows right from wrong. And again, it's like they don't understand what mental illness is. I still stand to that fact that they don't understand the nuances of coming in and out of psychosis or spiraling down, and that people who are seriously ill may not always appear 24 hours a day to sit in a corner and rock back and forth and speak gibberish, speaking in tongues and saying that voices are talking to them. It comes and it goes. It comes and it goes.
And he made such a point of it through his experts, like you're saying. He established all those things. And that was one of my things on my notes. Like, I wish he would have leaned into that and reminded
I kind of wished he'd done more on it. Like,
yeah, of course.
Can you tell us about masking? Like, what is masking? Okay, why would a person engage in masking? So somebody who might be very seriously depressed might, still want to present,
I would have liked to have also seen something where, to your point, to follow up on it, where you have to talk about that a person can be in a certain state on, early 2023,
right,
and be sitting here in 2026. And my concern is, as Clancy sits in the courthouse today, and from what I watched on TV when they were showing right before the opening started, and when the judge was reading the preliminary, mentioning the children by their names, I thought she was going to collapse. I mean, you could see but my point is, in 2026, she clearly appreciates right from wrong, is aware of the nature and consequences of her actions, knows that this was not what you're allowed to do. And I feel like, the jury sees her looking like this is a terrible word to use in these cases, a normal person emoting normally. And you saw it in the trial when she collapsed, when the autopsies and all of that were going on, that you make it abundantly clear that her state of mind today has nothing to do with, what it was or wasn't back then, and not to be influenced by her reaction today, which would tend to show a guilty mind in terms of the way she's reacting now.
Way of putting it right. And
there were some other things that just drove me nuts. Like, I want to find out if Reddington ever objected to the bows, because I would have been objecting to the bows. The bows, and if I was the judge, I probably would have been just like, counsel sidebar. And it would have been, okay, if you show up in my court with a bow again, we're going to talk about penalties.
Right, because
it's probably going to be, we'll start with $10,000.
So
we'll move up to mistrial.
I need to know if that was her habit before this case.
No, so people went and said they watched another public trial of hers. I think Reddington might have even been on the other side. She was not wearing the bows.
And she mentioned it in her opening, like, I'm wearing these for Cora because she loved bows.
Wait a minute.
She didn't.
I didn't see that.
I forget the line, but she mentioned that Cora loved bows, and
she
so
did
she's
mention
wearing a
Cora
bow.
loved bows, but I don't.
Well, that's outrageous. Yeah, I mean, I think you object to that, and again, the jury's not even present. This is before trial. But even if there's no objection, a judge running his own courtroom, you see it all the time when people, I mean, we've all had murder cases where family members will show up in T-shirts with a picture of a loved one, or wearing special pins or whatnot, or you see it sometimes in police shootings. We don't want cops in uniform coming. A judge will just say, we're not having that. If
Judge Canone said, I'm not seeing any pink in my courtroom.
Exactly.
Right,
perfect example.
Perfect example.
But if she doesn't wear bows, to put on a bow for the victim, not even alleged victim. In this case, all could agree, clear victim in the case, as a prosecutor, and then mentioning that one of the children had a particular affinity for bows. It's just not appropriate. And also, I hate to say it, but when you factor in the analysis of some of the other shenanigans that they pulled, particularly the Catholicism, the mortal sin, these are tactics. These are, in Reddington's vernacular, manipulations being used to kind of improperly appeal to emotion, and say we're on the side of the good guys here, which I get, but a prosecutor can't do that, and it does show that they're trying too hard on moving goalposts. You should never do that. I mean, that is a clear ploy to play to jury sympathy in a case where the sympathy is off the charts, because it's just the most horrific conduct you'll ever hear in any case.
And the prosecutors have a different, ethical stance. It's not that they because defense, you got to do what you can within the bounds of ethics to win for your client. But the prosecutors
in the United States, and it's recognized in their duties that they do have a higher one. So go on.
So, but the prosecutors, it's not the same sort of standing. And it's, if you can't win cleanly, you should be thinking about whether you should bring the case at all. Like if you're sitting there going, I need to do these tactics because I don't think my case is strong enough unless I, put on the bows and, and make the sympathy plays and all of these things. That's a real strong indication that maybe your case isn't where you'd like it to be. And either you need to fix your case or, this one seems to me to be just like, if I was the prosecutor, I think this probably would have just been like, okay, we, either I'm going to run this very differently, or I'm going to be saying like, this is, we agree that this is a not guilty by reason of insanity. And, she's going to go to a mental hospital for the rest of time.
Yeah. Look, if you're bringing the case, I mean, which I understand, it's not frivolous. I mean, she killed her kids, and there's a dispute whether she knew what she was doing or whatever. That's fine. But if you're bringing the case, I mean, my God, do it in a way in which it's credible, proper, with dignity. And I said this to someone else right before the trial started or right after it started. You have to own the fact that Lindsay Clancy was at the time, and forget what she is now, was seriously mentally ill. That is not a license to commit murder and commit crimes, and it is not a get out of jail free card to do what you want. But as a prosecutor, the biggest thing you have is your credibility. You wear the white hat. You have to be the one. You're supposed to be the moral authority in the courtroom to the jury if you want to win, which is better than wearing a bow saying, see, I'm a nice person and I feel bad for the victim. Why not just own the mental illness and just say, nevertheless, the law says this and the facts support that, and you win the case in jury selection. I mean, you pick a jury where you hopefully get 12 or 18, with whatever the alternates are, people who are willing to say, and you believe, will not be guided by sympathy, will not be guided by prejudice, and will not feel too sympathetic or unsympathetic, and that, as terrible as it may be, will follow the law. And then the chips fall where they fall. And the reality is they started the case poo-pooing the suicide attempt, poo-pooing the fact that Lindsay Clancy was even mentally ill, talking, like they live in the 1890s, saying about seeing unicorns in the corner. I mean, how offensive was that in 2026? You're supposed to be an educated prosecutor trying a serious case with a clearly mentally ill defendant who strangled her 3 kids to death. I mean, and you're talking about, how can she be ill, crazy, if she doesn't see unicorns? The way they handled this, we'll see what the verdict is, but the way they handled it, I thought was shameful.
So
I mean, they have a very real chance of like the prosecution winning, but if they don't, it's really on these prosecutors for how they ran it, because
Yeah, I'll
I
say,
mean, I might have even gone the other way and just said, look, this is a horrific crime. We're not going to, tell you, we're not going to belabor that, but we're not here to play on your sympathies. We're going to ask you to put that aside. We're going to ask that you consider only this question. And then you get to be like, look, we are the stand-up people. And I think that might be more effective for the prosecution than being the like, all we've got is the sympathy thing. And so let's have you watch some horrible, see some horrible pictures. And,
yeah.
I think they're going to have again, I would have liked to have seen the defense closing highlight this point more about their own expert and what that means for reasonable doubt and his credibility, and that the prosecution just can't get there. But I think they're going to have a hard time getting 12 out of 12 to convict, given some of the evidence that the defense put forth. And then the real wild card is is there some kind of cheesy compromise verdict on a count that frankly has no business being in, whatever your views of Clancy's guilt or mental health and not being responsible. The fact that there's a manslaughter charge here strikes me as absolutely unjust and absurd. Yeah. And I don't care what side of this you're on. I mean, the general standard, so people know, to get a lesser included offense is if there's a reasonable view of the evidence that the defendant may not be guilty on the top count, but there's a reasonable view they could be guilty on the lesser count. And the only issue here is whether she can form criminal intent. If you assume that Clancy is able to conform her conduct to the law and knows right from wrong, the idea that she somehow would have been wanton and reckless as opposed to intending to murder her kids, I've got news for you. If she was sane, she strapped exercise bands 3 times around her 3 kids' necks. That is intent to kill. That's open and shut as it gets. And if you get a verdict where she ends up getting convicted of manslaughter because some of the people who don't want to convict her of murder say, well, I can't convict on murder because of her mental health, but if it's just manslaughter and I'm afraid she's going to go to a hospital and, as we were told, so let's just bang her for manslaughter and maybe she'll get out in less time. I understand the morality of it, but as a legal exercise, that is gross and wrong and unjust.
Right. I was shocked that he wanted it in. I was like, all right, I'm going to take time to process this because he's been practicing a hell of a lot longer than I have.
I get it. I mean, look, he doesn't want a murder conviction. And if she were to be convicted of manslaughter, that's a win. I mean, that means the jury finds that, she had the ability to form some form of intent and killed her 3 kids and got acquitted of murder. I mean, that's a win on some level. So I don't blame Reddington. I'm surprised the judge did it. Right. I can understand why he would, but we're sitting here as like trained legal people, not emotionally involved. As a legal exercise, it's farcical. Yeah. It doesn't make sense.
Yeah, it's either not guilty by reason of insanity or it's murder. Like those that's the entirety of this universe. Like there is no. When I heard manslaughter was in, I was like, how? I mean,
just bear in mind, before the trial started, and I'm not faulting the defense. I mean, you deal with the cards you're dealt and you shift and you react as the trial moves on, and Reddington is good at that. But prior to the trial, they were ready to basically concede every element of murder. Okay, and let's just go straight to mental health. The judge allowed the DA to overtry the case, which they did, in proving murder to, obviously gin up the passion of the jurors and get them all upset. And then after all of that, now we're talking about, well, let's give the jury the option of saying, well, she's guilty, but not that guilty. And, and the irony is they obviously know if she's convicted of murder that she's never going to see the light of day, even though they're not told that. They also know that if she's NGRI, that she's going to go to a hospital and may or may not see the light of day. The part that they don't realize is that if she gets convicted of manslaughter, she absolutely, positively, yes, is definitely going to see the light of day. she's young, and she's not getting 40 years, people, if she's convicted of manslaughter.
Could she get 20 for each child?
I mean, she could get consecutive, so maybe it does actually, now that you mention that. I don't know the exact numbers, but I mean, it is separate victims, and I assume,
Because if that's the case, then I question more, because that's why I thought he did it, so she could get out. 20 years, she gets out in.
Yeah, you could get consecutive time for this. You're not getting for one homicide in the course of a few minutes the argument that this is just like one transaction, so we're only good for one. I mean, you can get, each victim is gonna potentially get a sentence, which, by the way, if she is criminally responsible, she deserves consecutive sentences. I mean, if she knew what she was doing and the law recognizes it was wrong, I mean, she killed 3 young, defenseless people who looked to her for trust and, support and motherhood. So, I mean, if she's legally guilty, it's hard to have a problem with
that, Mark. She relied on that as cruel atrocity, and that's not in the specified ways that you can find it to be atrocious.
Yeah, I mean, well, she relied on what exactly?
She specifically said she's their mother, and she's the one that's supposed to be taking care of her. That's atrocious.
No, that's not atrocious. Atrocious is torturing somebody, drawing and quartering them, and painfully. I mean, the conduct is certainly atrocious, and
right, but under the law,
right, it's more offensive that a mother would do that to their children than other. Not that I'm justifying other killing of other people, but legally to say that's atrocious under the law, that's not right. Right. I didn't hear that. Wow, I missed that.
Yeah, and I'm sure I wrote it here, like, object, screaming and yelling, like, but she definitely said it at some point.
Yeah, and that's not appropriate.
Yeah, and then I want to ask you guys about the voluntary intoxication aspect of the jury instruction. So let me just read it to you. And I know it doesn't fit exactly, but I always thought if he could get this in, the language is helpful. But as soon as the Commonwealth starts saying there was a lack of compliance, meaning she either overtook or undertook her medication, I'm screaming that voluntary intoxication portion
wiped out.
Right. Yeah. So here's what it says. It says, but a mental disease or defect might be caused by or result from a defendant's past chronic use of alcohol or, and I think he would have put prescription drugs, okay? Also, the consumption of alcohol or prescription drugs may trigger or intensify, that is, make worse, a defendant's pre-existing mental disease or defect. So she had anxiety, did she have bipolar, whatever. If it did so here, and the mental disease or defect then caused the defendant to lose the substantial capacity to appreciate the criminality or wrongfulness or to conform his conduct to the requirements of the law, the defendant is not criminally responsible. And then there's more, I think, wording that is helpful. And I think I would have left that in.
Yeah, the way you just described it, I'm nodding my head. I'm like, this is good for the defense, clearly, because it's just another pathway to get where they want to get about, not potentially being able to appreciate right from wrong. And frankly, it kind of undermines a lot of what the prosecution was trying to do. I mean, they can't have it both ways. They can't blame her for over-medicating and under-medicating. And then, when the reality is, and I thought Reddington was very effective with this, crapping all over, the young, inexperienced doctor whose solution was just throw pills at her, which I think he did around looking at the note. I took a few notes, not like you, I don't take as many, but where he did a nice job where he was showing pictures of her apparently bucolic, nice, typical suburban, upper middle class, lovely, I'm a nurse, I'm a mother, I'm a friend, I'm this.
She had so much more than your average. She had the nanny. She had a husband.
Yeah.
She had her parents. She was gifted from the gods. Like I'm sure you must have your ex. Like, just so privileged.
And then she just went down. And I mean, I thought it was very effective when he said, "How do you get from here?" And he's showing these wonderful Facebook pictures of these beautiful family photos that everybody wants, to her lying half dead and paralyzed in a hospital bed the way she was. And it's not so much a legal argument, but it may play to a jury, which is the common sense argument of you must be nuts to do that. Nuts, of course, not being a legal definition kind of thing, but juries are juries, and it's hard to fathom. How do you just go from there to there? And I think when the prosecution's trying to argue that, well, she just didn't want to go back to work and didn't want to deal with kids, that doesn't land at all. That just felt,
That was so weird.
It was disgusting.
it was dumb. I thought it was not credible. It was offensive and just ultimately not persuasive. And if that's the best you have, or again, arguments like that and smiling at parties, and you're not talking about the burden of proof on the other side or why they haven't poked holes in it, it's not good for them.
Mark, you know how Spinelli was their expert and then Spinelli couldn't testify for whatever reason. Are you aware of that?
Vaguely. Which one is that? Is that the TikTok one or?
No, this
No.
was like one of their listed experts. And do you know what I think she was a postpartum special expert in postpartum.
Yeah, there was
right?
some suggestion she'd made comments on Facebook or something.
Oh,
that would
I know
have,
what you mean. Yes.
And
Yeah.
and at least Bob says that Red said that is not the reason why she can't testify, and he couldn't go into why. But there was another reason.
Well,
And I'm like, okay, then I would ask for time, if whatever this is, to get, if that was an important expert, get him.
I mean, her bias would not be a reason she's not allowed to testify. She
I
could
said the
get
same.
vigorously cross-examined
Right.
by the DA about being a fanboy. And, you saw some of this in Karen's case with, was it Dr. Russell, the California dog bite doctor, who just kind of showed up, if you will, and they tried to suggest that she was just wanted to be involved. But if there's some other reason that she was not able to testify and she would have been an important witness, then I would think the defense would have the opportunity, as long as it's not their own fault, why she couldn't testify. It's definitely not because she just posted on Facebook, support Lindsay or whatever, which is not helpful, admittedly.
Right.
But
I
that's
said
not
the same thing.
qualifying.
Like, there's no law that the judge would say, now you can't testify. It would just be fodder for cross-examination.
Yeah.
But
it might be a really bad idea, right?
Right.
I mean,
But
Yeah.
if it's
technically
an
you can have
important
the
expert, you ask for time, or you say, then I'll want to bring them in make an exception for Sir rebuttal.
Right.
you know?
Yeah. I mean, I guess we'll find out after what the reason was that she was unable to testify. I mean, look, the case was interesting. There was a lot of key witnesses, including perhaps the most important one who, appears on Zoom, that's unfortunate. I mean, that's just never the way you want to do it.
Yeah. Did you think that the closing for the Commonwealth may have swayed some jurors? I mean, I felt like Bob tells me it wasn't effective. I'm like, all right, well then you're calming me down, because I felt like it could have swayed some jurors.
Go ahead.
Ian,
sorry, you'll have to repeat that.
I was
I
saying,
couldn't
did
hear you
you
for a
think
second.
that the Commonwealth's closing might have swayed some jurors?
Oh, I mean, absolutely. It's playing on emotion. And that is their strategy. I would have liked to see more objection, to be honest, because I thought there was more grounds for objection. And quite frankly, I think that Reddington should have pursued that afterwards. Like, okay, move on. Cool, she's done. Judge, I need a sidebar. I
Right.
really want to, because move on was not sufficient for that blatantly improper argument that you identified as improper and told her to move on, and she didn't hold off when I was saying objection. She just powered through, because when the other side objects, you're supposed to stop doing the objectionable thing until it's resolved, right?
Yeah. I don't know if how many minds she changed. I mean, again, I took just a few notes, and the first thing I wrote down for the DA's summation was the right focus finally, but that relates to the first 30 seconds to a minute where she said Lindsay Clancy is ill, but that doesn't mean that she's
Yeah.
necessarily the law is still the law. I'm like, all right, here we are 5 weeks later. She's actually going to, sound like a prosecutor, but also be a credible prosecutor. And then I wrote immediately veering off course with, her access to wonderful health care, and it's her own fault for not taking pills. And then she just weaved in a few other key points. But I mean, if you believe that juries are influenced by advocates, especially on a case where emotion is everything, then Reddington was 95% to 5 that in terms of just presentation, relatability, and all of that. And given that the DA has the burden of proof, the judge probably did the DA no favors by doing the charge on reasonable doubt 10 seconds after she concluded her.
Yeah, what was that about? He came back to I forgot to tell you for second degree, and I don't know if he really did forget to tell them.
I don't think he did. Once again, they do things differently in Massachusetts than I'm used to. I kind of like the idea of charging the jury something before summations. Actually, I'm not used to this.
Yeah,
maybe it, again, it kind of, but again, I think it was a missed opportunity by both sides to then talk about why it matters. But the fact that the prosecution finishes doesn't really talk about getting rid of reasonable doubt, and then the judge reads the instruction on reasonable doubt, which still gives me trauma from being a prosecutor when we would do the jury charge after every trial as a prosecutor and listen to the judge instruct the jury on the law of reasonable doubt, mutter under your breath and say to anyone who's listening, how does anyone ever get convicted of any crime in the history of life with the way the judge is instructing what reasonable doubt is? And I feel like that kind of undermined what the DA did. I mean, it almost is like a rebuttal to her,
right,
what she didn't do. I mean, I guess that's a gift for the defense on some level.
Yeah. And, I thought let's go back to the way Reddington started. He said, like, you guys have listened and you've been fair and you've been objective. And he was like reminding them, you didn't love that?
I don't like that stuff. I was surprised because he's so earthy and so, he's so old school lawyer, right? I mean, he's like the classic kind of guy. And, I don't like. To
but
me,
I
that's
thought
like
it was reminding them to. It's like you're complimenting them for something they're about to do. Is the way I kind of took.
Yes,
it. I'm going to
totally
say, putting in your mind that you're going to do it.
Right. No, I like that. It was kind of like a Jedi mind trick. Like, these aren't the droids you're looking for. Trust me. This is how we're going to do it. You're going to do it. I tell you. And again, he's so relatable. I assume the jury loves him just in terms of his shtick and whatnot. So maybe like 20 seconds of that. I felt it was a little long for what it was, given how emotional it is. But I understand your point completely. And I give him credit for being the moral compass to the jury during the course of the trial as the guy who actually believes in what he's doing and what he's advocating for. And I think the jury probably loves him. So, yeah, and he would know better. He's been there. He's seen them. He picked them. He's been doing this 100 years. So I assume there's a reason for why he did it. And I think for the most part, he was very effective. I thought his summation, if we're comparing both, was far superior. And he doesn't have the burden of proof. So I think he's positioned very well.
Yeah. And then to your point, like he made this comment about the whole burden of proof. Like he said, he talked about it. He emphasized it so much. We're blessed to have this burden that the government has to prove, but then not applying it for them is where we would have wanted to see it more.
Yeah. Just tell the jury, I'll give you a perfect example. This was a missed opportunity. The prosecution's own experts couldn't agree on what, if any, mental illness Lindsay Clancy had. How do you not juxtapose that to the jury in terms of how are you supposed to be satisfied beyond a reasonable doubt? Their own experts don't know what the hell is going on here. Okay. How are you getting past this and supposed to conclude that it has to be this when our expert is saying this and he's the leading expert and there's all these other issues and all the meds and the poor, the not great expert that, Tufts, not expert, but treating physician that Clancy had, who was just throwing pills at her and all of those sorts of things. So yeah, I feel like there was just a little bit of meat left on the bone, and that's always the risk in any case where you give a summation like completely without a net, which he did, and it's really impressive. I think the jury likes it, but you do run the risk of maybe leaving out certain things or getting a little repetitive at times. But that's the balance you strike. He definitely was captivating, definitely.
Right. And like you said, hers was canned. Like she practiced that and she said what she was always going to say. She improvised to pick up a quarter. But other than that, she didn't really respond to
that opening salvo was coming out the way it was practiced, no matter what.
Right.
Clearly, because it just felt so canned and so unimpressive given what we're dealing with.
She practiced that soft talking, and it probably hurt her to say the words over and over again that she said about how understandable and relatable Lindsay Clancy is.
I wonder if I'd be
I
concerned
suspect
that the jury.
There was some discussion there to be like, hey, how am I doing? You got to change your.
Right.
But here's the risk of that. It's only 5 weeks. The jury knows who you are, and now they see you pull the chameleon act in summation, and all of a sudden you're all peaches and cream and relatable, and you could hear the tone of the voice. It was almost like nasally, like fighting back. A little bit until the end. And constructive criticism is good. You probably should have started that way. But the risk I would have is, are you really selling this jury on this after what you went through and the way you behaved for 5 weeks? All of a sudden today you come bearing gifts and peaches and cream and everyone's happy and relatable and let's all hold hands and we'll get through this. I wonder if this is the problem with these prosecutors. Credibility is your most important thing, and I'm not sure it's credible to be unlikable for that long and then today to be a chameleon. I wonder how they feel.
A lot of people in the chat were saying that they're like, the jury sees through this, and if my daughter was here who's been doing with this, she'd say the jury is smarter than the prosecution gives them credit for. And then
usually the case,
right? But I'm anticipating questions. At least I'm hoping there are questions. If they bought any of that stuff about you saw her at the museum, and like you said, Mark, like that a week before or 2 weeks before, she could talk to the neighbors, she could talk to the school. Like they need to ask the question, are we able to find, since she could control herself in public to act like a normal person, that means she can control her conduct. And I would have liked to have made the point that the question is not, could she conform her conduct? Could she control herself to decide how to carry out the crime? The question is just, could she stop herself from committing the crime? Not could she decide the ways to carry it out? Was she compelled? Could she conform to not do it? How she figured out how to get it doesn't change whether or not she could conform herself to conform her conduct to the law.
Yep. No, I agree.
And you can sort of look at the kind of, I don't know if it's hypocrisy or what the right term is, but if she had spent the entire day just sitting in a corner, rocking back and forth, they would have said, look, she broke no laws during that entire day, so she can conform herself to the law by rocking in the corner because that's not a crime. So it's just every nitpicking thing. There's no winning. It's, yeah.
So it's going to be, I'm hoping questions. I worry about that manslaughter. I really do. Earlier, I was thinking, as you started to say, Mark, as well, like, all right, she'll see the light of day. Not thinking at the time about, well, there's 3, maybe she won't, But it's like, you have such a risk. We know as lawyers, they like to split the baby. They like to compromise. They like, it was safe in Karen Reed because the compromise was a DUI.
Yeah, I mean, and generally, I don't like lessers. If you think you have a good case, I actually like putting people. I mean, there are times you don't, but I mean, let's be honest. She's facing life in prison. She's admitting the conduct. I fully get in these circumstances why a defense attorney, let alone one who's been doing this for 5 decades or whatever it is, would want that. I mean, you're trying to protect the client, get them the least amount of time, and hedge against terrible outcomes, but it without being favorable to her position, it doesn't make any sense. It's not that case. But
right. No, but I thought that when I read the instruction, I said, well, this one doesn't, I don't understand legally, like it's not relevant. Like I was surprised that the judge was like, oh yeah, that one can go in. But it did bring up some involuntary intoxication that I hadn't heard anywhere else in the instruction. So right. I did think that was interesting, but I don't necessarily see any sort of, so what happens if they find it manslaughter based on involuntary intoxication? It's still, the sentence is still the same.
Well, he also asked for it, he got it, and then left it alone in the summation. So like, it's not been flagged for the jury in any way. And again, maybe we'll find out what his thinking was one way or the other when this is over. But the jury has not been fully told like why they can or whether they should do this. And you wonder if you really wanted it as a hedge, if it might have been worth 2 minutes, 3 minutes in the summation to say, look, even if you're not getting past, the mental disease or defect, she had this cocktail of drugs, all this other stuff that could have influenced her, and basically wink at the jury and say, here's an exit ramp to not send her away for perhaps what'll be the rest of her life. But the problem is, the other thing is, if the jury thinks she did it and is appalled at her conduct, then don't they want to give her the most serious punishment anyway? I mean, she killed her 3 kids. If she was of the proper mindset, she did it on purpose. That's what she wanted to do. I mean, I don't know why. I mean, who's compromising to come up with manslaughter on what side of this you're on, unless you have jurors who are saying, I don't want to be here anymore, and we're never going to agree, and we can't do this to someone else. We can't have another 12 people have to deal with this.
Right.
So we'll just all agree, we'll hold our nose and say, let's just call it manslaughter. That's unjust. I mean, I hate this, but I understand why they did it.
Right. And, I've been kind of saying from the beginning that not that I agree that this is supported by the facts, but had the Commonwealth, even before the rebuttal, but had the Commonwealth presented a case that this was a woman who wanted to unalive herself and then just selfishly didn't want her kids to live with the knowledge of your mom took her own life, was like, well, I'm going to take the kids too so that they don't have to live with knowing I killed myself, that they'd have such an easier path to guilty. Not that it's foregone, but the case they put on, at least the one they started with, that she's just doesn't want to be a mother anymore. She got so tired of dealing with her kids. She wanted the easy way out. So she took their lives and then pretended to kill herself. That I worried that had they taken that path from the beginning, they might have been able to have an easier path at convincing 12 people that this was intentional, that she could have conformed her conduct.
Well, I think they would have been more credible. Again, I go back to just as a prosecutor and, to my own personal experience, you need to be credible. You're asking a jury to follow you and come over a very high burden of proof. And if they get the impression you're not even being sincere in what you're saying, or you're clueless in what you're saying, then it makes me question everything you're doing. I mean, take yesterday. I mean, what Reddington did yesterday at the very end was about the most effective kneecapping in the entire trial. I mean, he got their own expert to basically clown the prosecutors and say their original theory lacks any understanding and nuance to what's going on here. I mean, that was beautiful.
Yeah.
Oh, I mean, that was a risky game, but oh man,
It
did
landed.
that pay off?
It landed.
I'm just like that. The courage on that guy, because I don't think I would have had the courage to, to make that play, but it paid off. I was stunned that it did.
I mean, he had the daily copy, he had the opening statement, and he heard what this guy was saying. And I think, I mean, any expert like that is going to value their own credibility. They're not taking the hit for the prosecution on this. I mean, this guy has to work in the future in science and be credible. And he just said, yeah, and he clearly didn't even know what he was being asked. I mean, where it was coming from. But
Right.
yeah, that
But
had to be
it was
humiliating.
so compound. I was shocked that everybody let it go. I was like,
Yeah.
I mean, there were 17 sentences in there.
Yeah, I was thinking in like, how do you do this logistically? How do you actually get away with this just in your like day-to-day life? I'm like, wow, how did any of this actually happen? I mean, it was
I thought
it
brilliant.
was impressive.
Yeah, it was impressive. And I thought he got so much more from their experts. I would have wanted, like I just kept saying, I expect in closing to him to say that, like, I understand what they said today, they being the prosecution. They said, we weren't calling it a fake suicide. We were saying that she wanted to kill herself, but she had enough control. She could conform her conduct to not take her own life. But I don't think that's what they were really saying all along. All along, they seemed to be saying it was not a legitimate suicide attempt. I'll have to go back, and I know we've listened to the openings a couple times, but I thought they said she wanted the kids to be gone so she didn't have to live with them. And then she, essentially, did this half-assed fake suicide attempt. But even them saying it wasn't, it was this, it was that, their experts, two of their experts literally made contingent that the very first thing you must find in order to follow my conclusion is that this was a serious and lethal suicide attempt. Like, it was the whole premise. And they spent the first 5 weeks saying it was nothing. And he did say it. He said something like, they're laughing at her symptoms. They're saying it was little skimpy marks, blah, blah, blah. But their own expert, it was contingent. Their finding was contingent on that.
Why would you die on the Hill in a case of this magnitude with these issues and fight the way they did over whether this was a sincere suicide attempt or not, where the woman is sitting in a wheelchair for the rest of her life because she went oops out the window, whether you believe it was on purpose or, her fake plan went awry. I don't understand why they would even get into that level of the weeds and fight against that. Moreover, what's the big deal if she wanted to kill herself after killing them? That doesn't mean that she couldn't form criminal intent or do that. I mean, I don't see why they needed to do that. And then they use it to morph into this argument of she's just this selfish, privileged woman who wants to go back to, her life without having to deal with kids that can be difficult. I mean, why would you take on all of that stuff? What good comes from that? The bottom line is, if you have in your mind evidence that, she was planning to do this, she got rid of the husband, she did it, she wanted to kill herself, because that is also, a guilty conscience. It could be, I don't want to get caught, so the hell with it. It just seemed to take on a burden that they didn't need. It blew up in their face. And the fact that we're still talking about it just seems, again, not the right word for this case, but crazy. I mean, I don't know why they would do that.
Yeah. I didn't know, Runkle, if you were going to say something about that.
I mean, there is a better way to run this case for the Commonwealth, and the Commonwealth may still win this. I mean, you don't know necessarily what juries are going to do. There's a whole bunch of people on Twitter who are like Die Hard, she's got to go to, like this can't be not guilty by reason of insanity because it's so horrible, which I mean, it's kind of not how the law works, but okay. But
Why you're not on the jury, yeah.
But at the end of the day, the Commonwealth, I think, would have had a much stronger case if they just kept it focused on a consistent theory and like ran some of this past people. Like, oh, this is a fake suicide attempt. Did you ever think that was going to play?
She
And
didn't
quite
like
frankly-
her kid anymore.
No, go ahead.
I mean,
finish your
this
thought.
is kind of illustrating just how kind of weak this judge is, because at one point she's been arguing extensively like this is a fake suicide attempt. And the defense is like, well, I want to get in some of this other information because they're saying it's a fake suicide attempt. And the judge is like, oh, well, it does actually sound like you're arguing that. And the prosecutor's like, I'm not arguing that. I would have said, okay, is that going to be a stipulation then, prosecution? Because you're saying you're not arguing it. It really looks like you're arguing it. So I'm either letting in this other information to rebut the point you've been clearly making, or we're going to make it a formal stipulation and we're going to tell the jury that the prosecutor has agreed that this is a real attempt and you're not going to attempt to undermine that later. Which is it? This judge just lets the prosecutor get away with anything they want. And it's frustrating. And I mean, it opens up the grounds for appeal.
I'm fascinated by what the hell's been going on for the last 3 years. In other words, and you can only go from your own experience. I don't know what the level of discourse between the defense and prosecution were to, like, in good faith, see, is there an agreement of NGRI, which can happen. And so, like, I go back to the circumstances where I've had a few of these. They're awful, where people kill, siblings that are young children or parents. And when it becomes clear in the beginning of one of these cases, it's going to be a psychiatric case, obviously. Okay, you serve the notice, you do whatever, you engage an expert who is credible and hopefully is testified for the prosecution 100 times or is a leading expert like this other guy was that Reddington used, and they do an evaluation of the client, and then you give it to the DA, and then you wait, right? And then what do? They go out, engage a credible expert. They get an order to evaluate your client. You go, or you send your doctor, they watch, you exchange reports, you look at this. And in the cases I've had, I've been very fortunate. The prosecution expert has agreed with mine. It says these are NGRIs. Now, that's not always the case, but like the testimony in this case is that like Clancy is being evaluated by prosecution experts recently. Like, what? Was she not evaluated way back then with an eye towards a good faith determination of whether or not we may in fact agree? Or was this always like, the hell with this, we're going to try you, and that's just the way it is? Because it kind of feels like that, but that can't be. But was there
I'm rapidly growing to just hate experts as a category. I mean it. I think that experts really need to be overhauled in a serious way.
Maybe it should just be court appointed.
Well, possibly court appointed, possibly like for something like this, possibly just court appointed, and possibly just we need to really evaluate what scientific means, because a lot of the expert testimony isn't scientific. This guy saying, I formed my opinion based on how long it takes to crush up pills. It's like, okay,
well, that's garbage.
It's complete horseshit. But B, there's no science to that. It's just, I read this thing and I had an opinion, but it's the same opinion that any moron on Twitter is qualified to give.
Yeah.
It should actually be confined to science.
Yeah.
So if the guy's like, okay, here's the significance of the crushing up pills, it should be, this is in this paper and this is how we know it. We allow way too much stuff that is just not even created via the scientific method. Hair and fiber analysis, discredited. Bite mark analysis, discredited. Digestion testing, discredited. But now we're on to bullet, forensic tool mark analysis of bullets. And we're like, well, it's not discredited yet. And I'm going, but it's the same shit.
Right.
We need to actually have a rule that things have to be developed through scientific testing. And not only that, but that the scientific testing needs an adversarial process, i.e. that it needs, like, it isn't considered tested until you have people who are actively trying to disprove it. And,
I'm just, again, and I'll leave this alone. Where was the prosecution's expert with a credentialed psychiatrist who would have interviewed Clancy years ago when the defense was using a psychiatric defense and say, I analyzed her, way back then. And in my opinion, to a reasonable degree of medical certainty, which, like you said, may or may not mean anything. Here's what I found. And obviously, if the prosecution expert did not agree with the DA, she would have been a defense expert. But no one testified for the prosecution who evaluated her in the early part of this, which makes you wonder, did anybody, and as far as I know, the only people who evaluated Clancy to come up with any type of an opinion on whether, to a reasonable degree of medical certainty in 2023, she could form criminal intent or not, were people who looked at old records and interviewed her in 2025 and 26. That's crazy. That's useless.
They all interviewed her 2026. All the
that's
prosecution.
Just, what the hell were they doing in 2023?
Yeah.
well, and when they interview her, they're like, oh, she has this minor inconsistency about some trivial aspect of things 3 years later.
Well, there you go.
That means that she, is deceptive. And when she started dating Patrick, she didn't tell him that she was on psych meds. And I'm like, have you ever been on a date?
That resonated really well.
Sat down at the first date and was like, I just need you to know, here's the list of psych meds I'm on.
Reddington really, that resonated well. And it's funny because, he's not a young guy, obviously. And I don't know what the jury is or isn't. But when he was mocking the whole, didn't tell Patrick she's taking Prozac, he's like, before she goes upstairs, which, again, he's an older guy. I'm going to tell you I'm taking Prozac. What do you think is going on here? Nobody does that. That was ridiculous. The prosecution argument on that point was ridiculous, and I just got a kick out of him shoving that in their face. It was effective.
Well, and I saw them try to use this is something every day, So if I'm like, hey, I'm thinking about ordering, what do you want? What do you want? I'm not out the door necessarily when I'm saying text me. I say, all right, just text me. I'm going to go get my shoes on. I'm going to go get my socks on. I'm going to go finish what I was doing. Yeah. She made it seem like this is relatable. We all do it. He was already out the door. And I'm like, no. You know how many times I'm still in the house telling them to just text me? Everyone wants to shoot their orders at me. Just, text me.
All the time.
Oh, absolutely. I've got attention deficit. My wife is like, hey, if you're going out to get something, can you stop at the McDonald's? And I'm like, what do you want? And she's like, and I'm like, no, text me because I'm going to go shopping. I'm going to forget. I'm going to be in the drive-thru and I'm going to go, I don't know what you wanted again.
But it doesn't mean you were already out the door, that you only said it as you exited the door.
I have more text conversations with my kids in the house than anywhere else. I'm on this level, and they could be 2 levels away where you have 2 options or 3. Walk all the way upstairs. They're sure as hell not coming down. I know that. Option 2 is just scream up 2 floors. They might do that, or the common sense option is just text. It is what it is. That's how people communicate today.
Right. But her trying to tie it with that proves he was on his way out the door. Okay, I'm leaving. Text me.
It doesn't prove anything.
No.
I remember in a case that I worked on years ago where a prosecutor tried to make this big argument over, at the time, cell phone records were new, and that they proved that they were both in the house, and this client lived in a huge house, and she's talking to her son on the phone. This is before iPhone, so nobody really texted because you had to hit the same key 3 times to make a letter, but they would just call each other on their cell phones from in the house. That's normal. People do that all the time. But the idea that a text from husband to wife or family member to family member would prove that somebody wasn't home. First of all, there's nothing to support that. And you're asking the jury to speculate. And, you say this all the time. If you're the party that has the burden of proof and you're the one making that argument, speculating and saying, trust me, bro, on this,
Right.
you're not coming from a position of strength.
Yeah. Yeah. And like it was like that little nitpicky stuff. I don't remember which one of you was calling it nitpicky stuff, but when the expert, the last one, I think, she lied to me about the order of how she looked at the menu first, looked at the place first, then asked her husband if she wanted to, like if I'm thinking I might want my husband to stop, I might start looking around to see what the hell I'm in the mood for before I'd say,
Well, and being like checking the directions. I'm like, where I go when I'm needing food, like I often just pull up on, Google Maps and be like, hey, where, like, what's nearby and what options are, like the number of times I just put into Google Maps and just be like restaurant and
Right.
just, find a place.
Right.
Or if you know that the kid needs some medication, you might, for instance, suggest that place you went to that you like that is also right near the pharmacy and be like,
Right.
hey, you want to pick up some food? And also the kid needs some stuff to
That's a
help
really
him poop.
good point. Where is the pharmacy en route to these other places? Like if the pharmacy is en route to this other restaurant, then, that makes sense. That makes sense too.
You also made a really good point. I'm sorry, go ahead, finish.
No, I was done with it.
When you say like her inconsistent statements and the prosecutor is like pouncing on, oh, she's lying. This goes back to the fact, well, this is what happens when you interview her 3 years later, dummies. Like she may or may not remember everything. And I suppose in all fairness, it's hard because again, Reddington goes first. You don't know exactly what they're going to say, but there a preemptive argument about, well, you're going to hear, or they're going to emphasize that she lied. And this is, statements that she made, recently about what happened way back when and whatnot.
Yeah. And the one expert says, well, she was guarded on day 3. So when their rebuttal experts got on, two of them did the interview over 3 days. And the one guy says on day 3, all of a sudden she was guarded. And I forget the other word he used. And as an example of how she was not being as forthcoming with information was that he asked her on which side of her wrist she wore the Apple Watch. And she responded, I don't know. Well, since there's no incentive to not answer that question, like it has no bearing on a damn thing, doesn't that just go to show you she was a little mentally exhausted come that day? Or, Some people pointed out that sometimes people change it depending on their exercise. Like maybe people who exercise a lot, I don't wear an Apple Watch, but if I wore a watch, it would always be on the same wrist. But either she changes it or it's been 3 days of grueling questioning and she's mentally done.
She's done. She doesn't care. Yeah. Look, I think most people who wear an Apple Watch, I do. If you're right-handed, you wear it on your left and vice versa. And it's really not the kind of thing where I don't think people generally would switch. But you're right. Context matters with everything going on. I don't know can be, I don't know. I'm mentally drained, or it can also be just leave me alone. I don't want to deal with anything. Who cares? Like my life is over. It just, I don't know. Everything can be, I don't know. It could be talking to, a petulant child who, I don't know. I don't care. Who knows?
Right.
Context matters, and it's just not that important.
Well, and can you imagine being interviewed for 3 days with them grilling you about such questions as which hand was your Apple Watch on? And you're like 3 days of that kind of shit, you're gonna be just done.
Yeah.
Here's the thing though that I don't think Red mentioned, because they said that one of the doctors asked her to repeat the day's events backwards, which is one way to determine whether someone is telling a lie. And I was like, all right, so she was telling the truth because she could tell it to you backwards. And then that kind of never came back up. And I thought, at least to my understanding, that's a good technique to determine if someone's lying, and it never came back up. Because you don't practice your, like if you're practicing it, And then you guys, Bob or Tracy, I don't know which. Well, first of all, nine women, 3 men are the makeup of our jury. I don't know if you guys all knew that already.
I did not know that.
Yeah, and they just put up a poll. This poll is not what you think the jury would do. It's what you would do. So answer what you would be doing as the jury. I honestly still think it's going to be hung. And I just, to me, well, let me ask you guys this. Do you think there's a chance they don't retry it if it's hung?
No. And I'll tell you why. Politically, if you are the prosecutor, you have just dug into this. You have forced Patrick Clancy to come in and testify, to listen to the 911 call about finding his strangled, dead children on the floor. Everything that's gone on, you have fought the defense like hell over, whether this is appropriate or not. And all of a sudden, the jury says, we don't know. So now they come back and say, okay, we agree that she has a mental health problem or at the time, so let's send her to a hospital. That would be disingenuous intellectually. I mean, there's nothing that could happen from right now while they're waiting for a verdict until after the verdict and it's a hung jury that would make them change their opinion on her lack of criminal responsibility or not. So, and if they were to say, who cares, we don't want to do it again, so let's just agree to this, they would get flamed like nothing. And what are they going to do? They're going to agree to what are they going to plead out to manslaughter and agreed sentence? I mean, they're going to try it again. They have to.
100%. They'll try it again.
What else they're going to do? They're going to do it, and they have a bottomless budget. Clancy probably doesn't. Don't assume Reddington would be around for take 2 on this.
Yeah,
right.
And I have no idea what their financial arrangements are or aren't. It's none of my business. I don't care. But I don't know if he would or has the ability to say, "Oh, I'm key to do this again." I think on emotion he would. I think he's with her in that regard.
Right.
But to commit another repeat of this, and suppose that the family's out of resources.
Yeah.
They may want to try to get him out of it and just not have to deal with that. I'm sure they would prefer he not be around.
I mean, and he's really with it for his age, but just me knowing how even I feel at my age, right? It's taxing, and the longer days, even when Bob's
22 days of this.
And when we did we did the last trial we did with Bob's dad, and it was a quadruple homicide case. He would say, come the end of when we're getting closer to the end, you guys need to pick up the ball. I'm not as, I'm not thinking as quickly on my feet. I haven't seen that with Reddington, but I just can't imagine in my mind doing this again at that age.
But I mean, you look on Twitter, you see the people who are like, she needs to be burned at the stake. They will absolutely run this again because of that, right? There's no way. And I mean, I'm doing a little bit of psychologizing. I don't know for certain. This is me making my guesses. But you look at those prosecutors, and what I see is true believers. The kind of people who you're sitting there and, you've got some 18-year-old kid who is in the back seat of a car that was stolen. And, this kid's got straight A's and whatever. He's got a university acceptance. And the prosecutor's like, I think this needs 9 months jail. And you're going, why? And they're like, car theft is a major problem. And you're like, he didn't even steal the car. He's riding in the back with his friends. And they're like, no, we need to send a message to the public. You get those kind of prosecutors, and that's the vibe I'm getting from these two.
Well, totally. 100. I mean, look, go back to what you were saying earlier about the bows, if it's true. I mean, who does that? Unless somebody who, and this is always dangerous, whenever a prosecutor really blends their role as, my client is the Commonwealth, the people, whoever, but starts advocating for victims and that line blurs and they start acting like a victim advocate rather than my client is the entire state and whatever justice is, that's worrisome. They become personally focused on that result, which as a prosecutor, it's not their job. I mean, obviously, if they believe a crime is committed and somebody committed a terrible murder or murders, they ought to prosecute. But when they start blending themselves with the victims and lose that separation, you're 100% right. Like they're never going to stop just on that alone because they're acting as victim advocates, not prosecutors.
Yeah.
So, and like Ritzy one said, like the whole, then minimizing the fear. Oh, she didn't want to get a rash. And then you find out it's like a deadly rash. It's a fatal rash. It's a rash that, like,
it's not just fatal, it's like really unpleasantly fatal. It's like your skin melts kind of shit. You know, like if she'd
and they're
seen
like,
it,
oh, it's really rare.
I would see her saying like, I don't want any part of this because I know exactly how awful it is.
Right. And it's like I kept saying, I hope, the jury is smart. I know the jury is smarter than the prosecution's giving them credit for. And I just hope that they see all of that, because if we get some kind of compromise verdict on manslaughter and it goes to the judge, and just Mark thinking about like I know they're not elected, but still the political pressure that gets put on them. Do you think there's any chance that the judge, you're found guilty of slaughtering your children in this way, does anything but the max?
I mean, no. I mean, you can sit there and say there's mitigation in the sense that there's clear mental illness and maybe she was mistreated, misdiagnosed and all of that. But
he says that's why you just got manslaughter.
But that not only that, there are 3 beautiful dead children who are the victims here. And when you start talking like I'm talking about now, justifying what ought to happen with her, on some level, you're making her to be a victim. And I don't think in a case like this, any judge, those are my crickets. I got that from Ozark, by the way, years ago. I liked how Marty Bird's phone rang and I switched to that. Sorry.
Is that what he had?
Yeah, he did. He had the crickets. I don't know how any judge, if she's convicted of just, wiping out her whole family. Again, I don't want to sound nasty or whatever, but that's what she would be convicted of.
Right.
How do you not get as severe a punishment of that as there is, as opposed to you had, like you said, you got manslaughter, if that's what it were. The jury heard your defense. You had a good defense. You had a good lawyer. Jury rejected it. The law is this. I don't know how politically any judge is giving her any breaks. I mean, maybe if it's not the absolute max, but it's not like much less than that. The other thing is this, from a taxpayer standpoint, her in prison is going to cost $1 gazillion. She's physically challenged, which is part of the issue. She's clearly going to be on suicide watch all the time. She's going to have mental health issues. I mean, it's just going to be having
she'll
her
be a target.
incarcerated. Yeah.
She's just going to be a money sink.
For every
They've been deliberating
reason.
for 1 hour, 55 minutes. If anybody saw the chat ask, 1 hour and 55 minutes. So what do you guys think on how long they'll deliberate?
I'm thinking we don't get a verdict before Monday, is my bet.
Long time, because I think, again, she did it, right? Like the conduct, and everybody knows that. And that's hard to just say, well, we'll just send her to a hospital, even if it's the right thing to do. So I think there's going to be a few people who are not going to want to push that plunger right away, even if they think it's the right thing to do. Or there's going to be people on either side who say, she killed her kids. Like, no, I'm sending her away. I don't care about. And so I think it's going to take a long time. And I don't know that you're going to get 12 people to agree. But, I spoke to the Daily Mail about this. I think they just put up a story recently about the possibility of a hung jury. But in some ways, that article is dated because it didn't have this the specter of manslaughter, which I think becomes an issue if they can't agree. That do they just hold their nose and do that? But I agree with Ian. It's going to take days. If this comes back quick, something is seriously off. I mean,
I would be surprised by a quick, guilty. I'd be surprised by a quick not guilty by reason of insanity. I just don't think we're going to see quick.
And I think if somehow we saw quick, and I guess it's me just being naive, that I'd like to think in that situation, because usually when it's quick, I'm like, guilty. In my mind, the longer it takes, the more they're considering other options. But I would say it might be not guilty by reason of lack of criminal responsibility.
Does the jury have the instructions or not? Do they have? They do have their own.
Each one of them has their own.
Okay. I'd be interested to know if one of the questions you get, if there are any questions, notwithstanding whatever they're looking at, is if they were to come back and say to the judge, in layman juror terms, can you put in English what the difference is between murder and manslaughter?
Right.
That's kind of, to me, the obvious question that people would say, well, where did this come from, and why would this be manslaughter? You listen to the judge's instructions. How much of this do they really understand? Just hearing it through, I don't know.
Right, they're back there reading it. I think that I do think that that's going to prompt a question at some point, and I just, in my mind, I hope and pray they ask the question of, can we, if she was able to conform her conduct to do X, Y, and Z, does that mean that she was able to conform her conduct to not commit the offense? Because it's still just eating me that they left that standing there as though the jury can decide. The prosecutor said it. Well, she could go to the museum and she could, interact with people a week before, so she could conform her conduct. But that's not the question.
It's problematic because, of course, there was no objection. On the other hand, that if that is a fundamental misunderstanding of the law, and the prosecutor made a blatantly inaccurate and misleading statement of the law, where, I do think an appellate court may on its own say, how they sometimes do, look into that if that were the case. Because if she were to be convicted on a misunderstanding of what it means to conform your conduct to the law, that would be unjust, clearly.
Yeah. Which we would never find out unless they ask the question, because you can't ask the jurors what they do.
Right. Yeah, that would be tough. That would be, conviction, and then some juror comes forward after and says, I thought this, and there you go with, a motion in the trial court level, which probably would go nowhere.
Right. We saw that.
We
saw that play out.
In that other Massachusetts, or one of those other Massachusetts cases, which we don't name.
Right.
There's a lot of those. Yeah.
Because I wonder, I don't know that any part of, I don't think, but I'm not sure that any part of voir dire was, like, the jury selection was aired. But if any of these jurors watched Karen read, then we may get the kind of question, the kind of written statement, like, we have deliberated, we have thought this through, like real strong language, like, we're hung, don't mess with us, don't push us.
It's an interesting point, because as a matter of common sense and statistics, 95% of the jury has to be aware of that. You're in Plymouth, which I understand, I'm talking to Canada and Chicago right now, but I'm actually from Massachusetts, and Plymouth County is right next door to this place called Norfolk County, which it's still in America. It doesn't feel like it at times, but it's still in Massachusetts in America. And it's the same. It's the Boston media market. It's both South Shore, same area of even to localize the media market. Everyone in Plymouth County is aware of that. And also, I don't want to speak from too much personal experience, but this as well. Plymouth County is ground zero of all the other civil Reed, Carney stuff, O'Keefe stuff that's going on. It's in that courthouse. So, essentially. So everyone down there is fully familiar with the goings-ons of Reed and what happened.
I feel like Massachusetts residents are keenly aware of the words they need to write when they're hung in order for everyone to be like, oh shit, they're hung.
Yeah.
Judge
No,
can't say
I think that's a great
Judge, we're
point.
hung, except we're also wanting to acquit on the following offenses.
Right.
Exactly. Yeah.
God, can you imagine?
Oh, just being like, please don't do a canone on us.
I was
Says
just
the
like, the
jury.
worst thing that could happen is you have that one juror that wants to say, I want to say not guilty, period. She didn't commit the offense, and everyone else wants to say not guilty by reason of lack of criminal responsibility. I'm like, that would be the worst outcome, that they get hung on that.
Or that there's like everybody is sitting there going, we want manslaughter and one person for murder, or vice versa.
Yeah, no, it gets bad, but also this is, I think one of the jurors in Karen's case even said, I was not guilty across the board, but I'm paraphrasing, but everyone was adamant or wanted the misdemeanor DWI, the DWI, and we wanted to get out of there, so I just agreed to it, even though I was not guilty even on that.
But thank God, though, because that would have.
But in Karen's case, that was no big deal. I mean,
Right.
it's a harmless thing in the grand scheme of it. If you're kind of stuck between not guilty by reason of mental disease or defect vis-a-vis murder or manslaughter for 3 dead people, and you're talking about life in prison or close to it, so let's just compromise, and they're not aware of what this all means. Oof.
Yeah, when you have the compromises that aren't really a compromise, like, oh, she's just got manslaughter, she'll just do 6 months. No,
Yeah.
she'll get, 3 rounds of 20 and she'll get released when she's like 172 or whatever it is, right? Like,
Bob and I had a close friend who we respect a lot, who was on a jury. We didn't find this out until, more recently, that said it was murder, and she thought not guilty, but she gave in to second degree.
My God.
Because I was like, oh my gosh, how horrible. It was like a long weekend and they were battling. And so she just went, and I was like, oh, horrifying.
That's
Horrifying.
scary to hear. Yeah.
Someone who grew up around defense attorneys, nonetheless.
I mean,
I'm
the more
sure
scary
you
things
guys
are.
took that quietly.
Oh God.
You 2 defense lawyers, I'm sure, said, hey, that's cool. Wanna
Hey,
go
that
out for a
happens.
drink?
Yeah, it's scary though, because this is jurors
Yeah.
like.
Well, I mean, even more terrifying is whenever you see somebody, they're like, well, I thought not guilty, but, we'd been in there for a week and I was really tired of getting yelled at. Or the other one that just absolutely scares the crap out of me, where it's like, we have 12 jurors and 11 say guilty and 1 says not guilty. And the judge is like, well, is that person like engaging in compromise? They're like, no, they're just hard and fast on not guilty. And they're like, okay, we're going to punt that juror and put in an alternate. And I'm like,
that happens.
what?
That's scary.
Oh, there's some recorded cases where that's happened. And I just go like, that is terrifying, because that is actually what the person should be doing. If you
because-
think somebody's not guilty and the other people can't convince you on facts that,
And you stand it. Yeah, you stand to it.
And Bob and I always spend a lot of time in jury selection on, do you feel that you have that your type of personality, if you believe after listening to everybody and that although all 11 want to say, and we'll reverse it, guilty, not guilty, so that we're laying that seed with them. You told me going in, you would stand up for your convictions. And if everyone else disagreed, that you would fight. And if it's a long weekend, because of this person, we kind of geared all these questions. It's a long weekend. You want to go home. You wouldn't just compromise just to get it done if you weren't convinced, right? Get them.
You know what'll terrify you? In Canada, we don't get to ask jurors, like prospective jurors, basically any questions at all.
Wow.
So you get what you
Well-
get. You have to ask permission for any questions you get. And so the questions that you will get permission to ask are things like, is the fact that the accused in this case is, an indigenous man or whatever it is they are, is that fact something that you would not be able to put out of your mind in order to render a proper verdict in this case? So you have to act like, in order to show that somebody is not going to do their job as a juror, you have to basically get them to admit, like, I am totally not just a racist, but I am so racist that I wouldn't be able to to come up with a fair verdict.
I don't know.
And I mean, who admits to that?
I rely on, like, what do you listen to for music? On, if it's date night, what are you going to do? That's how I like.
We should do a whole conversation another day just about the finer stories and intricacies of jury selection. Because when I was a young puppy prosecutor in Manhattan, and we had trial training, the guy who's still a close friend and mentor, who was like one of the star guys, would always give the big speech about jury selection, and there were just two purposes, right? Brainwash and get rid of the wackos. That's it. Everything else flows from that. And of course, this was from a prosecution standpoint,
right?
Very different, but interesting stories and just how to do that, and asking about music interests and all that is fascinating. But this horror story of, like, it's okay to be a little bit racist, just until you're not racist enough, as Dr. Evil would say, and so you're fine, you're fit for service. That's troubling.
Like, we don't even get to know. And they basically just ask, do you have any biases that you couldn't put aside? And I'm just
not if you have a bias, just if you can.
Yeah, exactly.
Aside.
Yeah.
So never mind the fact, like you said, I'm a card carrying member of the KKK, but I'm willing to forget about that for this particular purpose.
Right.
I'll be fine.
Well, and you don't even get to ask. Like, you can't even ask somebody, these basic questions. So unless you somehow get information about the witness, through some corollary research, you're just going to be, stuck with whoever you get. And like, a lot of the time that's terrifying, because you're sitting there and it's like, okay, who's walked through the door? I have actually done for another lawyer the thing of, in a small town where they were picking, and I say small town, it's, still a center that they have this, but basically just watching jurors show up and identifying their vehicles. And the only purpose for that was basically like, okay, this person is driving a Ford F-150. Do we have anything we can determine about that? But also just looking for things like bumper stickers. Because, like, if the guy's got a bumper sticker that says something like, I hate black people, then you'd be like, okay, that guy's off my, like, we got a challenge for cause.
I think he asked that sometimes. Do you have any bumper stickers? We've got to know if someone's got bumper stickers.
But, like, you got to actually, like, it's impossible to know. Somebody could literally be the Grand Dragon of the KKK, and you wouldn't actually be able to ask them anything other than the court-approved question, which, again, will probably...
Can you put that aside?
Can you put that aside? And the guy's like, you bet I can.
Can you leave the robe in the closet for a week while we decide this very serious case where this possibly innocent black man is charged with a crime? Can you handle that?
Well, and the other thing is that the more thoughtful people are probably the ones thinking, well, I do have biases, and I don't know if it's possible for a human being to displace their biases entirely. And so those are probably the people, like, the people raising their hands aren't going to be the racist people. It's going to be the people who either want to get out of jury duty real bad, and so are willing to be like, yeah, I'm whatever it is you said that I can't be on the jury, I'm that. Or the people who are just like, kind of putting a lot of thought into it and being like, well, I don't know if it's possible for somebody to be completely unbiased, so I don't know if that's a thing. You'll get like the liberal arts majors who talk themselves out of the notion that anybody could ever be on a jury ever, as compared to, like, the guy who's actually super racist might be like, no, I could be on the jury. I totally would love to judge this, black guy, and I have no ulterior motives for doing so. And you're like,
Is that a sheep
Um,
popping out from behind you?
So
Yeah.
like unless the guy actually physically shows up in the hood and the robes and the whole thing, you'll never know. You'll never be able to do anything about it. And I'm sure there's been convictions that have been based on prejudice because of that.
How long in this case did it take for them to pick a jury? Because this is a case that should take a long time to pick a jury.
I feel like it was less time than we all thought, because I remember them thinking it could take. Let me see if Bob remembers. Hold on, I'll text him.
I mean, I can't imagine Reddington's unhappy with a 9-6 gender split. I feel like he did all right on that.
Yeah, but
I mean,
9-3.
You said 9, and then the extras are all.
Or yeah, 9-3. Yeah.
Is that? What do you think? You would have rather more men?
No, I
don't know. I mean, again, it's you have to see who they are, obviously, and see them in person and interact. I mean, so it's hard to just generally say, give me a man or a woman without knowing more. The concern I would have, though, since we're now generalizing exactly what we shouldn't do, but to the extent that you at least start out with those concerns, my gut is, and I could be totally wrong on this, that I'd be concerned about women who might have had some form of postpartum depression.
And they're like, I could handle it.
And they say, you know what? I didn't strangle my children to death. I dealt with it. I did this. I did that. And I think also women could be more judgmental to other women, particularly mother to mother. So again, without knowing any specific personalities, I would be concerned, because postpartum depression is a real thing percentage-wise. By the law averages, there had to be some women who were picked for the veneer who might have gone through that.
Right.
And whether you know it or not, and they say, I didn't do that. What's wrong with this
So
lady?
Bob said jury selection was 5 days.
Okay.
And if we've got 9 women and 3 men, then we still have 3 women and 3 men in the alternatives, because I think there was 12 women and 6 men.
So 5 days is actually pretty good. I mean, in the old days in Brooklyn, where at the time when, they were the wrongful conviction capital of America, I mean, they would start and finish, serious murder cases in Brooklyn in like a few hours, right? They'd pick a jury for 20 minutes. Not as bad as Ian's describing, perhaps.
in Canada, this would have been done in an afternoon.
Yeah.
What? The
I'm not
jury
even
selection?
kidding.
Oh,
Yeah.
right, because there's no questioning.
Because there's no questions. You literally just have however many peremptory challenges, which depends on the level of the offense. And, the judge is going to ask a very limited set of questions. They can be challenged for cause, but where do you get the cause, right? Challenged for cause, you have to have something, to say, oh, this person's a racist, but where do you get that?
The other thing, I don't mean to cut you off.
Or you can give a peremptory challenge. And, your peremptory challenges at that point are basically just going to be based on looks.
And in Massachusetts, from what I've seen so far, they do the peremptories one at a time, which is a terrible disadvantage to the skilled jury selector, obviously, because the way we do it in New York, you throw up these people in a box to be potential jurors, and, are there any, challenges for cause from 1 through 8, right? And then you deal with it, and okay. And then are there any peremptories? And sometimes one party blows out peremptories before the other. And then at the end, when they run out, you want the 5th guy down the aisle on no matter what. Strike, and they're screwed seated.
Right.
The way they're doing it in Massachusetts, you don't know, and it's one at a time, so you can't really play that game.
Each juror, they have to make a decision on the one and then move to the next?
How they did it in Karen's case, and
Wow.
there's obviously other Massachusetts cases I'm interested in coming up that will get that all sorted out. But if that was not an outlier and that's just how they do it, that changes the whole dynamic of jury selection.
Yeah, for exactly like you said, you can't count the numbers and aim for guy number 5.
Yeah.
That's also how it's done here. And the challenges for cause, it's actually kind of the jurors themselves become a rotating pool. So,
Wow.
If you've got a challenge for cause, that's judged by the jurors. So if you haven't picked any jurors, they use people from the potential jurors. But once you have jurors, they decide on the next juror and whether or not they're qualified. So
Bob, you're gonna ruin everything with your mic.
Oh, is that it's why would it be this mic as well? It makes no sense.
It must
Hey,
be
Mark,
common.
it's the echo.
Ian,
How are you? Good to see you.
I'm good. I'm good. How are you guys?
Okay. Wait, you look good in your Range Rover there, whatever that is. All right.
Yeah, it's Margaret's Denali.
Okay.
It's got how's the signal? Is it good?
Yeah, your
Or am I
signal's
breaking
good.
up?
And I'm not hearing us echo right now. So
All right, well now's your opportunity to go eat because I'm going out to eat. I'm not getting fast food. I have to get some oh she So what did you guys
Are you going to 3V?
Take long.
I didn't have to tell her. Yeah, of course I'm going to 3V. I heard their food's exquisite. So what did you guys? I missed. I haven't been able to hear. What was your take on the closing?
I think we're all
Reddington
muted.
was good, could have been better. Commonwealth was emotionally strong, but a lot of bullshitting. That's kind of my vibes.
Mark, are you not able to hear?
I can't hear anything.
Mark's Alison
He
did something to
I can't hear
Mark's
either
sound.
one of you. I got muted.
Let me see.
That's
Yeah, did you text Allie? Hold on, Mark. Let me figure it out. Alison must have done something. Okay.
She probably muted her mic, and our signal's probably flowing through hers.
Ian, I'm try to write a note to Mark.
Yeah, will do.
I'm texting Allie.
all right. I didn't do anything other than leave. So let me try to figure this out. Mark, try
can you hear us
talking
now?
You still can't hear us.
That's weird.
I still want to blame Bob, but he heard Bob
You broke
initially.
everything.
Huh.
Now I feel like a human experiment. You're all staring at me. I can't hear anything.
We can hear you.
1 second. My dog is going crazy. Be right back.
Huh.
All right. Hold on.
Can you hear us now? No.
Oh.
Let's see if he tries something. I did nothing other
Do
than
I
leave.
leave and come back? Is that what I do? Nod if yes.
Can
Blink
you
twice.
hear
if-
us? All right, leave and come back.
All
Babe, you alive up there? Bob's frozen. Everybody's frozen. Huh. Am I frozen, you guys? Let's see.
I hear you now.
You can't hear me?
I can hear you now.
All right, because now Bob's frozen. So I was like, the whole thing shot to shit. But
I know we're having like brutal weather here. It's like really dark and really.
what was Bob asking?
I have no idea. I couldn't hear.
Oh boy. He's got the Starlink, and I don't know why he keeps leaving home without it.
He's gone a long time. That's like going on weeks now.
I know. This is the longest we've ever.
We were supposed to have a nice meal in Massachusetts, but his plane got in late or whatever. But that feels like 3 weeks ago already.
I know it was in like 26 years. It's the
Wow.
longest that we haven't seen each other. It's
Wow.
crazy. But he's going to come home on Saturday. So, and then I don't know, everybody's streams got struck today, which I have no idea
Really?
how. because we have access to the pool camera through the whole Massachusetts media approval thing. So I'm like, how are we getting a copyright strike when we're supposed to be, approved media? So
I don't understand how any of this YouTube internet stuff works. What was inappropriate that they struck everyone?
Apparently they claimed it was a copyright strike. So, and that's why I'm like, well, that makes no sense because, but our stream does have Sport TV, and I had asked them early on. I'm like, well, how do I get the pool camera? Because I thought if I have the actual feed,
You went silent again.
so when somebody leaves, it's doing that to you. It's because Bob left and came back.
All right, I'll try again. Oh,
Ian, can you hear us?
nope.
I can hear you just fine.
Oh, I
So
can hear you. I can hear Ian. I can't hear Allie.
All right, let me do this. Can you hear me now? So Ian, he can hear you.
I can, yeah. I might have to play interpreter here and relay information.
I wonder what's causing that.
I'm going to try again. Let me go out and come back one more time.
All
Here we
right,
go.
I'm going to shut down a bunch of windows. Just get rid of everything.
Everything must go.
Everything must go. All right, wait, I heard him come back. Let's check him out. All right, how about now?
I hear you. Yes.
It has something to do with when Bob or I, as the host, I think it was like however he came in, started I don't know. It's weird, but I'll tell him don't come back.
The secret to 26 years of not seeing each other and happy marriage. You can just say, don't come back, and it works.
Oh, God. So if we get, we know the significance of a question, but can you think, if you're Reddington, what's the question like? If they say question that you're just begging the question to be. I think with Mark, it's like, what the hell does manslaughter mean? Why is this here?
That and I've seen this happen in certain trials. Can you tell us again what reasonable doubt is? If you're the defense and you hear that's good.
That is good. Yeah. What do you think, Ian?
Question: what is wrong with this prosecutor?
That would be good. That would be better.
You guys know I've said it. My question is something about, can we use this other conduct? Her following the rules of the road, even though no one followed her, to see that she followed the rules of the road as conforming of conduct, or if she could control the method of execution, does that mean she could conform and not commit the execution?
I have a prediction for if we get a question.
Okay.
The prediction is the question comes back as what is it? If we find not guilty by reason of insanity, does she get released or what happens? And of course, the judge says, I can't answer that. That's, not part of your considerations.
Well, they do.
But,
they do have that.
No, so Massachusetts allows, and they got the charge where the jury has been told, actually, that if it's NGRI, there's an order of commitment to a hospital. There's an evaluation later done at which I determine, what's going to happen. The DA has a right to be heard, and there are periodic updates. I'm paraphrasing, obviously, but they do know that she's not literally, I don't want to say walking out of the courthouse, rolling out of the courthouse, I guess.
Yeah.
They know that she would be hospitalized.
Okay, that's a good thing then.
But they don't know how long, and they were told it could be life, it could be less than life. And of course, you've seen some people on Twitter, the Twitter Law School, as you know, is a very open door policy.
Right.
There's not much admission requirement. Oh my God, she could be out in like a year or two. People, she will not see the light of day for decades if she goes into a hospital. No judge, I don't care how normal she appears, no judge is allowing Lindsay Clancy to just go free within a couple of years. That's not happening.
Yeah.
No.
She'll have hair like mine at the very least.
But you've had that color hair for a really long time.
Yes,
Right?
but she hasn't. So
Yeah.
I mean,
she not.
if they asked a question, because when you read back that part of the instruction, it's like the prosecutor can request and normally does. Like I was thinking, if I'm a juror, like, can you mean they might not? But I think they would be like, well, somebody would be like, well, you saw those ladies, right? They're gonna.
It's a risky charge for both. I mean, the concern for the defense, obviously, is that if the jury thinks it's tantamount to a real not guilty and she's walking out, that they say there's no way I'm allowing that. I mean, if I'm the defense in this case, I want that instruction. I want the jury to know that there is punishment. Yeah, it's not as bad, although in practice it can be actually for her. I mean, it is a Pyrrhic victory in that sense for Clancy. I mean, it's not going to be a pleasant existence. I mean, her earthly life is basically, I mean, let's be honest, it's not anything anybody wants.
You're around like all the time. You're around people who are in various states of mental illness, most of whom are probably not responding well to medication. So most of what you're dealing with are like people threatening to kill you because they, think that you have put recorders in their teeth and that kind of thing. So,
yeah, and that's a very good point. There's no like special hospital for postpartum psychosis and bipolar disorder. They all get lumped in and just, dinner time and
figure it out. Right.
It's not. Yeah, it's not good. I mean, I had a client who is like severely autistic. It's not, obviously that's not classic mental illness of any sort. And he was unfit for trial, which is of course different than, having a mental health defense. Unfit for trial under the theory that he could not participate in his own defense. I can't talk to him. He doesn't communicate. He's literally non-communicative. So how do we, and the question was, well, what do we do? Where do we put him? And part of the concern, and believe it or not, the state of New York, they were with me on this. The hospital people, like, we can't take him. You can't put him in a place where, as you just noted, you have people who may hear voices constantly, who are very ill, who are taking various levels of medication with a guy who is not in any way, shape, or form mentally ill. He's non-communicative. It's different, very different. Right. And I mean, that's a whole other conversation about how they treat severely autistic people who get mixed up in the criminal justice system. That's a story for another day. But, they just wanted to have this cookie cutter approach where, well, if you're not fit for trial, you just throw them into this area where you just better they deal with each other than deal with us. And I mean, that's what would be awaiting somebody like her. She would be a target in jail or one of these hospitals to the extent anybody knows who she is. And by all accounts, at least, I mean, she's lucid, she's aware of what's going on and who she is and what's happening. I mean, that is not a good existence. So if people are hung up on the fact that hospitalization is some kind of big win for her, maybe it is, but it's a Pyrrhic win. It is not a good existence that would await her at a hospital. It's a big win for Reddington, for sure, as a lawyer. I mean, that's better than prison. I'm not so sure how much better it is for her.
So Martha's asks, does a not guilty still keep her in the mental hospital?
Depends. I mean, if she was traditionally not guilty, which the defense concedes she is not.
I think that's the question here. Straight not guilty.
Yeah, out you go. But
yeah,
they still have to prove her guilt. They still have to conclude she's factually guilty. But when you assert not guilty by reason of mental disease or defect, no, it's different. That is not a traditional not guilty.
If she got not guilty, could they petition to keep her in as a seriously dangerous person type of thing?
They'd have to use different law. I mean, you could not use the criminal law to incarcerate someone who has no criminal exposure. I mean, we see this all the time.
She admitted it.
But the famous case is, we call them Jackson hearings, right? I think it's Jackson versus Indiana, which is the Supreme Court, where somebody was being jailed and there were no criminal charges, and it was a due process violation. They were trying to use the jail as punishment for somebody who had no pending criminal actions, and you can't do that. I mean, is there a Massachusetts law to civilly commit and allow that sort of thing? I'm not an expert on that, so I don't want to opine, but if she is not guilty in criminal court, out she goes. Good day. It's over.
Right.
And I
by
don't
the
think
way,
she wants that. Like, you know,
who knows, right?
it looks like she needs treatment. I mean, quite frankly, I think if they cut her loose, like
She
just,
might-
okay, good luck, you know, she probably doesn't last too long. So,
Yeah.
No, the concern too would be self-harm. I mean,
Right.
she the guilt she's had, at least at this point, she doesn't want to. It's been said, I think, by even Kevin, she doesn't want to be around. She's obviously a prime candidate for self-harm risk.
And so we got 3,930 votes, and we got 8% says guilty, 77 says not guilty by lack of criminal responsibility, and 18% just says straight not guilty.
All right, the 18% need a TED talk.
Right. We've been giving them, trust
listen,
me. This is
listen.
like on our stream, they're being told, come on.
Get off
We
the
get
internet, people.
the
Seriously.
people are like, Patrick Clancy did it. And I'm like,
Stop the Patrick
how?
Clancy stuff. Okay. Her own attorneys admit she's guilty. Okay. They were willing to stipulate to all of that evidence beforehand. There is no evidence that this husband did anything. If you don't approve of his lifestyle because he got remarried and started a new family and whatever, okay, of course, I don't think it matters. It's his choice. The man found his children dead on the floor of his own home, and his then wife, half dead, who's responsible, and his whole life changed. Blaming him or believing he did it because, you know, someone on TikTok or the internet or the Twitter lawyers are telling you that. Stop it. Just stop it. That's crazy. There's no. What is the evidence of that other than you just don't approve of his lifestyle and you wear tinfoil hats? The
problem is the evidence that they even rely on. Like a lot of people keep saying, and it's like blurry, you know, cameras, and then I think people that have used AI to try to clear them up, but that the shoes have changed, the jacket has changed, but there is literally nobody saying that he went to the one place, I think it's CVS first or the restaurant first, whichever, went home, committed the offense, and then went to the second place. So what does the change of clothes even mean?
What?
Like,
also, there's the kind of like how and why. He has no history of mental health problems that his wife had. Why would he be motivated to just one day? I don't know.
You're saying a man that wanted to do that to his children so he could go get married to another woman.
I mean, I can't even believe this is like a serious conversation. I mean, I guess we're not being serious, but the fact
No,
that
we're
we're
not.
even having this conversation,
And we don't have to. We can disregard. But it is.
It's people, 18%. I mean, more people think, if I understand the poll correctly, more people, not many, but more people think Patrick Clancy is guilty than believe that Lindsay Clancy of sound mind intentionally killed her kids. In other words, more people think that someone other than Lindsay physically killed the kids.
Right. It's gone to 15. It's gone to 15%, but at 4,100.
That's Ian's influence. See, he's going to get that number down. The more we keep talking, he's going to shame them, and it's going to be near 1% by the time he's done.
I mean, I just find it kind of astounding because people are sort of, you know, and I don't like when people nitpick through Lindsay Clancy's life, but they're doing the same thing, like nitpicking through his life, going, you know, we're going to try to find like some sort of, and they're not even inconsistencies. Like the guy moved on and tried to, you know, form a new relationship and have a new family. And I'm like, okay, so he's not rocking in the corner helplessly. You know, I'm not holding that against Lindsay Clancy, and I'm also not holding it against Patrick Clancy. So
but let me ask you guys this: because obviously Patrick testified that he had to, you know, undo or take off the ropes, and then that they were tied. Like,
And then the prosecutor pretended that that wasn't actually a thing.
yeah, and then in closing, she tries to make sense of it by saying he said it was, she wouldn't say tied this time, looped, like you tie your shoe, but without the bunny ears. You just said it was tied. You just said it was tied. And they had to wrap it.
Yeah, I mean, that's the prosecutor really backing away from their own position in a way that is like strikingly weird.
But she still said, you remember, I held it up and it just fell apart. In the
Yeah,
same
I mean,
sentence,
the thing is she's like, you know, it's tied, and then, you know, she's doing this demo which isn't consistent with the evidence. That demo should have been objected to, and should have been the source of a curative or something, because saying like, you know, it was tied, you know exactly what the witness said it was, and you know that that's not what you're describing, right? You're describing something that is contradicted by the evidence you elicited. So either you're eliciting perjury, and, you know, we can talk about that, or, you know, like what is this?
I thought it was gossip when she said it during the trial. There's no testimony that it was tied. No one has ever said that.
Yeah, other than your own witness responding to your leading questions, because she doesn't ask open-ended questions.
Right.
She specifically led that it was tied. So it's like, are you...
Two things can be true. One, Patrick Clancy did not kill his kids, which is true. And two, you can be judgmental, even though you really have no place in life to be judgmental given what he's been through. But you could be judgmental and say, well, I don't think he should have, left and gotten married and started his own family. I don't necessarily agree with you, but that doesn't make him a killer. That's ridiculous.
He damn well may have been cheating on her.
Who knows? But I should be careful not to delve into allegations and defense of defamation and whatever for other reasons and other cases. Right. But you're making him a valid defamation plaintiff when you just spew online nonsense that he's guilty because, of course he is. When there's,
and you couldn't say it was an opinion,
right?
And he weren't really saying it, because if anywhere you look online, they're saying it. With proof, and I look at all.
There is 0.0% evidence that
he posted something to the effect of, "You realize you are causing me actual damages by spreading these false statements," and I'm like, that's clearly this guy, he's basically laying out, "You are defaming me. I might come after some of you," and
I don't think, unlike others, people like him would go after like Twitter trolls and that. Right. But there was that one kind of like B-list celebrity, I forget her name. She was on one of those like Real Housewives shows or whatever. I don't know her name. I don't watch that stuff. Her face I can picture. I just don't know her name. But who made some kind of stupid TikTok where she said, "Oh yeah, Lindsay Clancy didn't do it. Patrick did." Because, and I'm just like, this woman should never be allowed to leave the house again. I mean, without her tinfoil hat, and your career is going to be over. But that person presumably has some degree of public influence to like the Real Housewives crowd, which I assume would be the right crowd to say, "Oh, he's definitely guilty because, the Real Housewife said so." There's like, that's an advanced course in the Twitter law school, I assume. So, right. But I mean, I could totally see him going after somebody like that.
Especially because that's somebody who isn't just making statements, isn't just somebody who's more likely to be believed, but also is a person with a big pot of money.
Yes.
And
doing it for whatever you call it, TikTok likes or clicks or whatever.
Cynthia, Bob will join when he gets back to Hull and has also put some food in his mouth, it sounds like. Because I was like, well, just eat fast food or suck it up and eat fast food on your way home, which, Bob doesn't do. He's like, I'm not eating fast food. Like, you could get a burger and take off the bread. You could get, there's something you could eat. But so he's gonna be here. So the I forget, I had something in my mind I was gonna say, totally off the whole Patrick thing, not having to do with the Patrick thing. Now I can't remember what it was. That's my
People should just leave him alone, and that's all that really needs to be said about him. Really, it's terrible what he's been through.
yeah. But what I also find shocking is that they.
I told
he's
you
right.
we're having a serious
Weather's serious.
That's our weather alert. Now that's my phone, iPad, watch. They're all like.
So is it a hurricane?
Imminent threat alert, flash flood warning, blah blah blah. Yeah.
Flash flood warning. It's not. I'm from the East Coast, but when we get those out here, it's a tornado. And I was like, what? A what?
Yeah.
Hurricanes I'm used to. I mean,
Yeah.
whenever we got like a danger warning, that's when me and my friends would be like, all right, let's go hit the ocean. We're not allowed in the water. Let's go.
Yeah, well, that's not where I want to be right now. It's kind of yucky out here, but all right, the alert is over. So
your dog's so sad, like, oh.
Oh yeah, no, she they get that, how they react when the weather is coming, and so she was in major follow you around everywhere mode today, and that's why earlier I was like, where did she go? She's probably hiding in the closet or something.
She's making sure you're safe, or she wants your support.
No, she's not making sure we're safe. She's scared out of her mind and just saying, "Don't leave me."
She wants your support.
Yes.
Protect me.
Yes. Yeah.
Our dog used to get freaked out by like lightning and fireworks, and he's gotten better over the years. So.
Yeah, July 4th can be tough on dogs. Oof.
But do they here? I've had a jury deliberating until 10 p.m. They just say, "All right, it's 4:00. Everybody go home."
Probably. I mean, in my experience in New York, the court officer union is powerful. Let's be honest. They run the courthouse. Okay. So what does not happen is juries don't deliberate past 4:59 p.m. because what happens at 5:00 on the dot is every court officer turns into a pumpkin. So I've in Massachusetts, I don't know yet. These are things I have to figure out the culture in the next couple months. But, I see in certain jurisdictions, like they're staying late, and I just laugh because at least in the city, it doesn't work that way. First of all, 4:00 is really the time, Mr. Slate blows the whistle and Fred Flintstone is yabba dabba doing out of there.
That's crazy. I mean, it makes it harder just like to get through, deliberations if you've got to call it at a certain time. But what I know, looking at all the Massachusetts jury instructions and things like that, as far as legislation's concerned, I feel like they're very defense friendly.
I do too. If you look at their charge,
incredibly so.
In particular on reasonable doubt, where they talk about moral certainty, that's kind of ironic because we're not supposed to talk about anything that's religious or whatever. But that is a gift. And then, of course, we're all talking about what we call the insanity defense. And for it not to be an affirmative defense is unbelievably a defense advantage. That's probably the biggest defense advantage imaginable in the Massachusetts. I don't know what they call it. We call it a penal law, whatever, the criminal code or whatever.
I think they call it penal as well.
Whatever it is. That's just unbelievable. I mean, if Lindsay Clancy was being tried in probably, 45 or 40 other states, certainly where I'm familiar with, the defense would have to prove by a preponderance, which is greater than 50%, that she had the condition. And, even that, I think a lawyer could make the argument based on their expert and all that and perhaps win. But to not have to do that and to have the prosecution have to disprove it beyond a reasonable doubt, there are not words to describe how different that is and what a huge advantage that is for the defense. So she is at least in the right jurisdiction to assert this defense. That's
because
for sure.
Out here, we don't even have the the impulse side of it. So you're done. She wouldn't even get to raise a defense. I mean, good luck just relying on simply, I didn't know the illegality or the morally wrong or criminally wrong. Like, I don't think that had as strong of a chance of surviving as did.
Totally. And I'm also, I don't know, and again, I don't know what the judicial culture is other than the comments people used to make during Karen's case and some other things. But in my experience, I can't fathom this case being tried and the defense saying, I want an instruction on manslaughter. And I think a judge would kind of look at you and say, yeah, that's great. And I want to win the lottery. No, any other, as part of the charge conference, what else? Like, I mean, I think if anything, a judge would say, can you explain to me how a jury could find her not guilty on murder, but there's a reasonable view of the evidence. But she didn't intend to kill. She just intended to act recklessly in doing what she did, because that she knew there was a risk if sorry to put it in these terms, but tie a rope or something around someone's neck that it could cause death. And I just disregarded the risk, but it wasn't intentional. I mean, what are we doing here?
Maybe arguing that if you go by the Commonwealth's theory that she wasn't compliant with her medication plan, that was reckless. And then only because of that recklessness did it cause her to, I still don't think that it fits.
I don't like that, because I think you have to be reckless in appreciating that and disregarding the risk of, if I tie this around someone, it will likely result in, unfortunately, what it did here.
Yeah. It's a strange one. I would not be surprised if we get a question about that. Like, wait, how does this work? What do we need to find this thing? Because which part was reckless? That could be the question. If under manslaughter, what are we deciding is reckless?
I mean, the whole Massachusetts charging procedure, it does sound cluttered. It doesn't sound very organized to me, how they differentiate between the various murders and manslaughters. And it doesn't sound crisp. Now they have it in writing, so maybe that works for them, but just listening to it earlier on TV, there's no way they're retaining it. I mean, it's confusing. And you've seen it in some of these other cases where there were issues. Back in Karen's cases, there were big issues with, what the slip looks like and how you're charging the jury with this or that. And it just seems to be happening.
Yeah. And it's surprising where we're saying, well, the legislature tends to be defense sided and, and then to have that bizarre, like, verdict slip issue where you just can't say, like, not guilty.
Yeah. Except witness intimidation. They're not so defense friendly with witness intimidation, but I'll leave that alone.
Yeah, right. I mean, then they just want to willy-nilly interpret their statutes however they want. No, the rest of our statutes are really written to protect the people, and not, and the right to free speech and all the other rights. But this one here, we're going to take a real strong view of. We're going to say that doesn't protect that.
Yeah,
Really?
I'm curious how many other states don't make this an affirmative defense. It's shocking to me, actually. But I mean, there's a few others. I don't know what they are, but I'm curious how many.
Even in the states where it's, because even in Illinois, you just have to raise it to a certain level and then you get your jury instruction, but the burden always stays on you. Like, you still have to demonstrate it. Like, the shifting the burden to, as long as they establish it by any amount to be beyond a reasonable doubt.
I mean, think of it in practice. I mean, you could have a situation in Massachusetts where the defense doesn't put on a case, has no experts, and just tries to pick apart these prosecution experts, brings out the fact that she's taken all these drugs and all this other stuff, and you're going to make a good faith argument and get the instruction and say they didn't prove it beyond a reasonable doubt, where, like, for example, in New York, you lose. A judge would say you don't even have enough to support it. I'm not even going to give an instruction, and there's no evidence to support it.
Right. Yeah. I mean, she was in the right jurisdiction, because I don't think
Yeah.
many states still have the impulse prong, the failure to do they have it in New York? Is it both?
New York is, right. Appreciate the nature and consequences of your action, and are you, right and wrong. So,
Right, that is too. There is no.
I mean, New York's kind of traditional with the defense. The Massachusetts language, I think, is a little different. This conforming to the law is different phraseology. But I mean, generally, right from wrong and knowing it's illegal, and wherever
that's what
you go.
Get too. We don't have the impulse or the inability to conform your conduct.
No.
And without that, she'd be screwed.
The thing that surprised me is the proof beyond a reasonable doubt of, that they are, sane. In Canada, it's a very different standard. It's a balance of probabilities on whichever side raises it, which is actually kind of interesting that the prosecution can theoretically raise, a mental illness defense. But there's a presumption that you're not suffering from a mental disorder. So there's no evidence. It's just that's where that goes. But it's a balance of probability standards, which, would be much worse for Clancy here in terms of the burden of proof.
So what happens if in the middle of a Canadian trial, I want to raise an issue and say, on the balance of probabilities, I think that juror is a card-carrying member of the KKK and is being biased.
If you figured that out midway through the trial and you could bring something to the court's attention, at that point you could ask for the juror to be, struck. And then hopefully they've got alternates, or else you're into a mistrial. I mean, stuff does happen. There was one case not too long ago where a lawyer was in a coffee shop lineup and started chatting with somebody about the case they were on. And the person was like, "Yeah, I know. I'm one of your jurors." Oh. And that juror, it ended up that the judge was just like, "Nope, we're yeeting the jury entirely."
So let me ask you guys this. Have you noticed that every morning the judge says, have any of you seen or heard anything that would cause you to be not, affect your impartiality or cause you to be biased? Not just have you heard or seen anything.
I mean, I feel like it's impossible for them not to have heard or seen something.
But did they do that in Karen Reed? Wasn't it just, have you seen or heard anything?
I mean, I think they, has anyone seen anything in the media? Has anyone talked about, the usual questions? I mean, that is an interesting phraseology, but I mean, it doesn't offend me in the sense that if you don't want a juror who on a case like this just can't handle it. I mean, that these jurors are going to be haunted for the rest of their life. I mean, they saw autopsy photos, heard 911 calls. I mean, we've all seen similar stuff, and it doesn't leave you. And even on some of those cases, they're not as not to compare murder stories, what's worse than others, but this is as bad as it gets.
Yeah. But I thought it was odd that it didn't start with, have you seen or heard anything, and then ask whether it's affecting their ability to remain impartial. Because I'm used to, it's like, well, have you seen or heard anything about this case, period? And then let's take the next step.
Right. That's interesting. Yeah.
And I wonder
that is interesting phraseology. It almost assumes I'm aware you must be somewhat exposed to this, which is concerning.
Right. And that's why I was wondering, did they have a discussion ahead of time? Like, look, we know they can't avoid it, so we're going to ask it this way, which would be just strange. It's not what we're used to.
Yeah.
What did you think about, so although we didn't see it on screen, we know that Reddington turned and said, I'm gonna challenge you, with his court. Then he starts with the pool room quarters. I'm gonna challenge you to prove. And then there was that, objection, direct your comments to the jury, because he clearly turned and spoke directly to the prosecution.
I thought it was cheesy. I have to be honest. A little over the top. A little bit. The quarter thing with the pool, I thought that was funny, although one of the few things I give the DA credit for, she played that game, I thought, well, because he put it out there. I mean, I understand a judge saying, don't turn and look at the prosecutor and start issuing challenges to duel and pistols at dawn in the middle of a closing argument. And I mean, I mean, it's Reddington, so you like it because it's funny and he's charismatic and he's from another generation of just like old school lawyers and a lion of the bar, as they would say. And I mean, it's funny, but the judge was definitely going to step in and say, like, challenging them to a duel essentially is not how we do this.
And then he was able to kind of keep it going without ever pointing at them again with the quarters. So you knew that was, I challenge you again, I challenge you again, I challenge you again. I understand it.
And it's funny because you're watching him do all this stuff, and I'm wondering, is she going to object, or is she now gun shy from all the other stuff that happened? And when I thought she was going to object to the quarter stuff. I mean, she objected to her freaking name. I think, you'd think this would be more concerning.
Oh,
and
that
then
was so
but
funny.
it occurred to me in hindsight, before we now flame her for the name thing, which I'm happy to do. But she didn't object, I think, because she's like, all right, I'm going to throw that back in his face.
Right.
And I thought she did a little bit.
She did a little bit. I don't think she did it well, but at least she tried. And I think some of it she was bullshitting that she just made up, like,
yeah,
after the fact. And, Bob and I always, because we always have, and I don't know if you do this, Mark, but we have like a theme, something you repeat throughout your closing.
Of course.
And we always try to remember, and a lot of times forget, to say, now I know they're going to stand back up and they're going to try and repeat, they're going to use and repeat the thing. So it kind of takes the sting out of them doing it, because that's what they always do. They always find a way, whatever gimmick you use. And is that something you learn as a prosecutor, where they say to you, take whatever it is they're doing, take it and give it back?
There are so many cliche canned lines. I mean, I can picture them right now, where I can probably call someone at the Manhattan DA's office, say, go to your little, bank of whatever. And I mean, some of the lines you can remember, and some of the training. I mean, some of it you've all heard. It's all real cliche. Every time a defendant testifies, what they're going to argue in summation. He admits what he must and he denies what he can. I can't tell you how many times I've heard that exact line passed on like a family heirloom from like lawyer to lawyer. And yeah, I mean, there's all kinds of the way they try to make you do it and that. And eventually each lawyer gets their own style and comes up with their own way. And some people become Reddingtons, they, I don't think he has a prosecutor background. I don't know. But my point is, he clearly is really comfortable on his feet and is really focused on connecting. I mean, like with his shtick. And, part of the give and take with that may be you lose a little substance a little bit, because you're not looking at notes, and it can happen. Whereas the DA actually was mostly on her feet too, but you've seen other DAs who get up there and they just do this. I mean, they literally, or when they cross-examine, they have their checklist and they're checking off and not listening. And, Reddington is the kind of guy who listens, and so there's flow in his cross-examination because he's not checking off boxes. So everyone gets their different styles, but yeah, in the beginning as a prosecutor, they teach you. But as far as theming, yeah, I mean, I think the theme here, more perhaps it could have been, was just why there's reasonable doubt, and with a hyper focus on, I've got the best expert bar none, and they've got a clown show, and they're asking you to take their word. And in order to get where they want you to get, you have to fully discredit my guy, and you can't do that. There's no world in which that's a possibility. And he did mention reasonable doubt like 9 times, but it was always conclusory. They have the burden. That's true, yeah. But that doesn't add much other than explaining like what that means in practice. Like, they don't have the evidence because of this, this, and this, so they can't meet the burden.
What'd you guys think of The Shining?
The problem is this. I'm a big believer in pop culture if you can use it in a trial, but he's dating himself.
Right.
Again, I don't know the ages of the jurors, but I don't know how many of these jurors, think of Jack Nicholson as anything other than like a 90-year-old nothing.
Right.
If there are other jurors who know him, obviously Jack Nicholson, The Shining, and One Flew Over the Cuckoo's Nest, all the other stuff. But I don't know if
that this weekend, my daughter and I, the film student.
One Flew Over the Cuckoo's Nest.
Yep.
It's so good. I mean, it's.
But I do think that The Shining has a that's got a cult following. So I think that no matter where you're at, that
I don't know.
Jack
I don't
Nicholson.
know. I mean, we're of a certain age where I think we think that, but there's only there are
certain
movies
moments
that
of
the
it.
Godfather does. Like, for example, right? I mean, everybody knows the quotes. But
if
The
you went
Shining-
with the chopping through the door thing, everyone's seen that. If he's talking about the typewriter scene, not everyone has seen that.
Oh,
Yeah.
work and no
So-
play make Jack's a dull boy. You don't think?
yeah, I don't know that everybody knows what that
Talk
is.
to a 20-year-old. See how many of them. Talk to a 20-year-old and just say, "I'm referring to a movie. All work and no play makes Jack a dull boy," and
No
see if
clue.
they go, "Oh, The Shining," or if they just go, "I don't know. Is it the latest Marvel movie?" At this point, it's an old movie.
Somebody
It's
said
like if I ask you about,
Oh yeah, I did.
I want to say
lost on
Citizen
the Few Good
Kane,
Men one.
like
He did a few
not
good men
Citizen
one.
Kane, but something that came out the same time, right?
Right.
It's. And if I asked you about Citizen Kane, you'd probably be able to tell me about the critical, key bit. But if I asked you about the middle of the
Rosebud.
movie,
How'd I
you're
do?
going to be like, I don't know, right?
Somebody said they're 42, and they don't know. What? How's that possible?
It's an older movie.
Because The Shining came out, I want to say, in 1981, which is about 45 years ago, if my math is or close to it is correct. And that's correct. It's a long time ago. But again, we don't know who this jury is. I don't know.
Somebody
the
said
ages.
that he was trying to make people think of the Bow twins by bringing up The Shining.
Okay, well, then maybe Reddington's playing chess and we're all playing checkers because
I can't find it to highlight it
the
again.
picture of the boat.
34-year-old says, I've never seen The Shining.
They don't know what Jack Nicholson is. I mean, he was a relic when he was in Batman in 1989. They don't know A Few Good Men. They don't know Cuckoo's Nest.
Well, the quote that he used from A Few Good Men, I was lost. I didn't know that. And Bob's like, what do you mean? It's the whole thing about the code red. I was like, all I remember is, you're
You
out of
can't
order.
handle the truth. Yeah.
Right. You can't handle the truth.
Right.
So yeah, maybe.
It depends on the jurors. I don't know. I mean, how old they are.
Yeah.
I mean, I like old movies, but I don't know if, like Ian said, a 25-year-old kid is gonna be like, "What are you talking about, boomer?" That's what he's thinking.
Yeah, and they may well just be like, "You've completely lost me on this point," and I don't know, because once you're making references that they don't get, they're tuning out, and then it's hard to get them to tune back in. So, yeah.
I mean, there
That
was
said,
a period of time he could barely use it. God, sorry.
oh yeah, absolutely. But I feel like that ship sailed. But I got to step out for a bit. I got to try to conduct a surety thing, so doing some lawyering. So I might be back later if you guys are still rolling, but otherwise I will
Bob or I'll-
see you later.
I will, before you go, your timing is very suspicious. We all just heard that can crack. We all heard that.
Oh, I need my caffeine.
Oh, that's
But, So I don't know how bail works where you guys are, but here a lot of bail is done on what's called a surety because we don't have bail bondsmen. It's actually illegal to be a bail bondsman in Canada. So sureties are always people who are like your friends, your family, or whatever. But
Like
they
federal.
agree that, they agree to supervise you in the community. They put up money, or they put up the promise of money, or they put up property. But in theory, they can also be criminally prosecuted if they fail to keep an eye on you. It basically never happens unless there's serious. There is a case where it happened where the surety knew the person was dealing drugs and was okay with it because they were getting a cut, and they were like, "Yeah, we're prosecuting." But the courts now, because of those requirements, they're wanting more sureties because bail's been a big issue, but they also want the sureties to get independent legal advice because it's like you're signing on to potentially lose a whole bunch of property and so forth, and potentially to go to jail. So you better understand what you're agreeing to. So a friend of mine is trying to get their client out on bail, and they're like, I need somebody to do a surety, independent legal advice. So I'm like, all right, I can do it. So I got to go do that.
I'm troubled. I'm troubled though. And so in Canada, if I understand this correctly, you can leave your racism in the closet and pinky promise to be fair. Okay. But if you want to be a bail bondsman, you're subject to prosecution, arrest, and incarceration. Got it.
Yeah, except it's not even a bail bondsman because you're like, you cannot do it for money. You cannot accept money for it. So it's literally only, I've seen like family will do it. I've seen friends do it. I've seen employer-employee relationships. And I've actually seen that both ways, where an employer is the surety or where an employee is the surety.
Mm-hmm.
But like, you know, you're not going to find some random person on the street who's willing to be a surety because they cannot get anything for it. But the court is like, you better make sure they understand what they're signing up for. So I got to go give the speech. I got to go, like, you know, and it's got to be fairly in depth. You got to be like, so, you know, this person's got a criminal record or doesn't have a criminal record.
And all the things you could do. All right.
Yeah. So anyway, I will see you guys later. Cheers.
Yeah. You know,
can I step out for 5 minutes? I just have to return this call. I don't want to put you on the spot.
No, I'll be good.
Oh, you went silent again.
Because he left. That's all right.
I'm going to take this call and then I'll come back after the call.
Gotcha. Okay. All right. So he's been booted. So I don't know. Somebody help me figure out what's going on, that when we enter and come back in on YouTube, people are like losing sound, because that happened before. And that was just Ian leaving this time, not Bob or I. So I'm going to go back up to the beginning on the supers, y'all. And I'm sure maybe I should start at the bottom, because the people at the top might already be long gone. Law and Order says, why DA allowed to bring up her asking for a lawyer? Because she didn't do it to a cop. That's why the Constitution's like that whole, your right to assert, you know, your right to a lawyer not being used against you comes into play, like when they're trying to arrest or interrogate you, and then you ask for a lawyer, not when you tell a doctor you want to call your lawyer. But I appreciate your comment. We got some jewels from Sammy, an Irish lad, an Irish, and Lee, and Aunt Lydia, and Grandma Cranky. Thanks, guys. Shaboog says, Perry Mace Reddington for president. Thanks for your generosity. And we got the Red Hoosiers and Regina. And then Not Your Lawyer says, Massachusetts lawyer here. I am behind watching, but without an objection, the bows are nowhere in the actual record. Court TV doesn't count. Wow, that's true. Unless somebody said it on the record. Well, thanks for that, Not Your Lawyer. Got a new member, Tina Wiggett. Love it. Thank you. Family hug. Concrete Jungle says, if MS, manslaughter. Sorry, guys. See, my brain needs food. Can they appeal due to Commonwealth bias, misrepresentation of evidence, and get a retrial without murder 1 and 2? I think so. Well, would double jeopardy attach? But if double jeopardy attached to all of it, I don't know. I have to think about that. I think so. I think that would be a not guilty on those. So I think it would only be on manslaughter. Bob, have any info on the jurors now that are finalized? 9-3. 9 women, 3 men. And hope you're here soon to give us more. Red Hoosier with the jewel. We got Megan Rittenhouse says, thank you for the insight and measured combo. Well, thank you. We got Diane with the jewel. Thank you. And then Sarah B. Creative says, I think of them as an overcooked steak. I prefer mine mooing. All right. All right. I hear you. Oh, thank God. Sorry. Hey, hey, oh, hey.
I made it.
You made it. If you're eating, I can go through some more
I
chats.
skipped my whole lunch.
No, eat something.
No, I was gonna go get seafood.
Nobody wants hangry, Bob. Go
I'm
eat
not
something.
hangry. I was gonna go get seafood.
I know, but you will be hangry, Bob.
You were starving. I wanted to come, and now our guests are gone anyway.
We're coming back. There's something going on when somebody leaves. So when Ian left, but Mark's going to come back.
Wow.
But why don't you get a snack or something while I go through the chats?
I ate. I made a sandwich. I'm trying to tell you I was going to go get seafood. And then you're like, I'm starving.
Aww.
So I want to so I just made a sandwich. I'm good.
So should I?
Yeah, go get some food.
All right. I'm not going to leave.
That's why I ran home.
God forbid when I come in, I'll just do this.
Oh, yeah. Oh, yeah. All right. So I have not obviously been able to really hop and chat much today. It's busy, right? We went in, closings. They're about, what they both run, about 50, somewhere between 50 and 55 minutes each. Both sides. Did Allie run a poll? Hey guys, how you doing? How's it going? How you doing? It's good to see you. I thought it was so I don't know if Allie was passing it on. So it looks like the jury makeup is 9 women, 3 males. The 4-person of the jury, my best guess is the oldest female juror that there was. And she was, but she was very diligent in watching the trial. I mean, they all were, but she like leaned. Yeah, no. 9 women, 3 men. There were 12 women total and 6 men total out of the 18. So majority female, which I think is good. That's what I wanted. And so yeah, the 4-person is a woman, because she was always like leaning forward. She was very, very engaged in the process, which is what you want. And the one, I believe the one black male juror did not make it. I think there was a guy in the second row that always wore like a vest. There were two guys in the back row. I forget, like Michael Bryant has some kind of nickname for him. It's like Monster Truck or some shit. I don't know what it is, but one of them made it. There was one that had a ponytail. He did not make it. The other one, that when this thing's over, I'm going to tell you who his doppelganger is, except this guy's like a larger version. I'll tell you that because I can't, I'm not going to give description to jurors until it's safe. And then we had an old, like the juror that I was telling you about, who I thought was probably the most senior. Yeah, I thought I don't know that Reddington loved the call on the like one of the males word on the street is he's, because you're always trying to read him, right? Like he wasn't getting the vibe from the one male in the back row that ended up sticking. And so there was a couple of other, like I said, the most senior male, he made it on. He was the most diligent note taker. I don't know how many notebooks he must have filled up, but he was always taking notes. Always, no matter which side, he was always taking notes. He made it on. And there was another guy who I think would be 1, 2, 3, juror number 10 in the front row, closest to the gallery. He made it on. The two youngest female jurors did not make it on. And they both looked like potentially young mothers. So I don't know how to take that. Like this, I was saying it last night. This is a really, really difficult case to try to figure out in a perfect world what your perfect juror would be. A lot of times you can kind of get a feel based on what the fact pattern of the case is, on who you'd like to have sitting in there. And this one was just hard. I basically felt like I didn't want any men on the jury, to be honest with you. But I thought that a 9-3 count, women to men, was good. I'm glad. And the judge, in terms of selecting the foreperson, that wasn't randomly. So I don't know if he picked this particular female because she just happened to be last seat, first row. I don't know. Or if he was watching and was like, wow, she was very diligent in listening to the testimony. I mean, who knows? But we'll see. You never know what a jury's going to do. Ponytail guy did not get in. Ponytail guy did not get in. Here, I'm way behind on chat. So 9 women, 3 men. I would say the average age of the jury is from 40 to 75, with most of them falling within, I'd say, the mid 40s to mid 50s range would be my guess. I'm usually somewhat decent in guessing people's ages, but so we'll see. So we couldn't get a jury clock or a verdict clock going. What time is it? So I think they went in. So they've been in about 4 hours, right? They go in about 1. I can't remember what time I left the courtroom. That's a good question. Rebecca Lavoie asked if the judge had instructed the jurors on whether or not they can take a straw poll when they first get in. And he did not. Certain judges are like, I don't recommend you do a straw poll when you first get in. I'm a fan of the straw poll. I think it's, yeah, I remember Judge Newman and Murdoch, he picked juror number 1, didn't he? I thought he picked juror number 1 as well. Like in Illinois, they go back and they select their own foreperson, which I prefer, frankly. But maybe I don't. You can always make arguments both ways.
you know? Like, you don't want some alpha going back there and just like, all right, you know what, I think I'll be the guy, you know? And like, everybody's like, oh, okay. So maybe it's better when the judge picks it. I don't know. But yeah, so the judge made no comment whatsoever, one way or another, on his opinion on straw polls. So I did learn from the amazing staff who I brought a dozen donuts for. Like, all the court officers have been so awesome. I like to take care of them. So I brought them some donuts this morning, and just really nice people, really nice people. And they kept order, kept the order in there, because it was getting progressively crazier and crazier as the days progressed. I've seen somebody posted the media chasing after Reddington this morning when he got to court, and it was kind of insane. I was standing back, but I was filming the horde that swallowed him whole, and they're like moving along with him. Because he was just walking toward. He didn't stop to speak. He was just moving towards the courtroom. So this whole gaggle of reporters were like moving with him. It was like a giant moving pile. It was like a rugby scrum or something. It was crazy. Let me see. I could probably send the picture to myself, the little vid, so we could watch it. So Allie they cut the stream, huh? It's weird. And I heard Mel got cut too. Michael Justice Served didn't get cut. I think it might have just been Mel and us. Odd. Very, very odd. And I text Kathy Russin, who, really is in the know in terms of her position over at Law and Crime. Which now owns Court TV. They're the pool camera. And I'm like, Kathy, they cut our stream. I'm like, did y'all make some kind of copyright claim? Because we didn't get a strike. People are using the wrong terminology. We didn't get a strike on it. They just cut the stream because it was like copyrighted material, but not really. Especially because we had the SJC order, that we were credentialed, that we could rebroadcast it. So, but Kathy's like, we never manually file copyright infringements on anybody. So it's like, it wasn't us. So it had to have been a bot. I don't know. Or somebody, who sucks just put some kind of shit in, which, people are stupid and petty. So I have no idea. But I kept telling Allie, I'm like, just go to Boston 10 or Boston 25, because I told Kathy, I'm like, look, for as long as I did, like back when Law and Crime would do the talking head shit in the middle of, in the middle of trials, they would break in. They'd always be 45 minutes behind. I'm like, I was on there for like a year and a half for, 1, 2, sometimes 3 hours at a time. I'm like, I think I've earned the ability to be able to stream your shit because you guys never paid me a dime. She laughed. I was serious, I'm like, come on. No, I'm not nervous. I'm not at all nervous. I mean, you never know what a jury's going to do. Look, I've said it from the beginning, and I'm of the same mindset. Even with the addition of the manslaughter charge, which, really does give the jury a place to hang their hat. If you've got people that are like, well, I'm not going to be able to vote not guilty for her. I'll admit her care was fucked up. I'll go manslaughter. I think the people that are going to be favoring the side of not guilty by reason of lack of criminal responsibility will probably be less inclined to move towards the manslaughter. You know what I mean? I think you'll get the movement from those that were thinking, I'm going murder one on this thing. That's where I'm at. I think they would probably be inclined, if it was going to get the job done, to get a unanimous verdict, that they would be inclined to move towards the manslaughter, which is a max 20. I think it's a minimum 5, and the judge is sentencing. So, she's been 3.5 years. Another factoid that I found out today, Judge Sullivan was a pretty renowned defense attorney. So he was a successful defense attorney before he took the bench. So that was interesting. Yeah, I'm not nervous. What's making you guys think I'm nervous? I got up at 5:15. So it's already been a long day. So I don't know how much energy I'll have for this. I'm going to have to take a nap, and kind of bound and determined to get in that ocean today. I actually have my swimsuit on down low, because I've only been in it one time in the 3 weeks that I've been here. So yeah, it's kind of that road, kind of an access road like that. So what did you guys think? Start telling me that. It's interesting to read online, like outside of kind of whatever my feed is on Twitter, which are typically, the people that follow me pretty heavily. When I kind of got outside of that, because Dr. Nikki Jackson was hitting me up, she's like, I really thought the prosecutions, and I like hearing people's opinions. And so Dr. Jackson was like, she said, I really thought that the prosecution did well.
I did too.
Yeah, I know. Allie said
In a
that.
bad way.
Well, yeah, that she was effective.
To a certain extent, I felt that way. Yeah.
You're not alone.
But has Nikki been watching the whole thing
No.
to see? Right.
No.
Like, if you don't know that shift in the prosecution, then you can't gauge whether, because that's why I'm like, all right, you're looking at this because the chat kept saying they know how she's been this whole time. They're seeing this for what it is. You said the same thing. Yeah. I was kind of looking at it in a vacuum, and I'm like, well, that seemed like an empathetic, seemed like a complete 180 and the presentation of a much effective case.
Yeah.
Much more effective than the bullshit that guys, I broke my little
back scratcher.
Yeah. So I don't have like the handle.
Why aren't you using the gavel?
The gavel just didn't feel the same as like flailing it around. I don't know why. Just didn't.
You know where that gavel's from? I told you that story, right?
Yeah, from your dad's. No. I forget.
Clearly.
But I know you've had it a long time.
I've had it since college.
Your dad gave it to you in college.
Incorrect. I mean, you really, really forgot it completely. Don't gore your head with that piece of metal. That seems like a bad idea. There you go.
Remind me, babe.
Nah, I think it's a members only type thing sometime.
Okay.
Tell the story of the gavel.
No, I'm going to remember.
Maybe. I give you a wide berth because of your perimenopause brain. So.
I know, because otherwise you'd be like, I cannot believe you forget this thing. We talked about it. So,
well, give me your full assessment on Reddington. What did you think of his close?
Well,
I didn't get to hear what Mark was going to say. Ian said, you know, he thought it was
I
okay.
got 3:31 from when the
For-
judge. I got my I started the clock when the judge said the words, "You're excused," to the jury. But I mean, I guess they hadn't even walked out of the room yet. I got 3 hours and 32 seconds. Do we? I thought you said there's a way for us to put up a clock. Okay.
What?
That there's a way for us to add a clock, little clock ticker.
I mean, it's, I think I've done it before. I think there's like a widget. You kind of have to get like, there's a widget that you have to get for, yeah, there's definitely a way you can get a clock.
But we have to have it start at 3 hours and 32 seconds. I don't know what Court TV thinks they're talking about. I got 3:32. Cam's listening to closings right now.
Oh,
She's
she
been
is?
sleeping. Yeah.
So
You know, I thought his closing was great, except there was stuff that I thought he left on the table. And I know it's really easy for me to say, you know, sitting down over here while he's saying it, and then having the benefit of listening to the cross, I mean, to the state's closing. What did the jury do? Did you already tell the people what the jury did when he pointed to them and was like, I challenge you?
the jury didn't do shit. So don't even ask me. Like they
What?
weren't doing, they were sitting there. They were like, no one was laughing. Like they were all paying rapt attention. The only thing that I
They're
thought
back in
that
court. They're back. Is it just to say goodbye for the day?
what?
Okay.
Are they back in court?
Yes, I'll excuse you all until tomorrow morning. Thank you.
Oh, he
right.
let him out?
I stopped my clock. Yep.
All right.
And they have their verdict clock at 3:31. So we're right up to each other. And that's it. It's done.
Okay. So that answers my question. So it's 4:10 here. Was that in real time?
Yeah, that's happening right now. Yeah. Anything else we need to address before tomorrow, council? Nope. So they're adjourned until tomorrow. They have their own banner underneath their other banner.
Well, so I was starting to tell you, I didn't know if you heard the story so Kathy, back in the old Law and Crime days, like I don't know if she was like the GM, but she's high up in the hierarchy of Law and Crime, which now obviously owns Court TV. So when that was going on, when your whole kerfuckle was happening, I text Kathy. I'm like, hey, they cut our stream. And she's like, what? And I'm like, yeah, they cut our stream. And I'm like, well, and she's like, she talked to she's like, we didn't do it. Like I asked. And then she said that we don't manually, because we didn't get a strike. That's not what it is. They just cut the stream. Like strikes are serious shit. Are you listening? Because I want to read this. I want to read this to you.
Yeah, no, I'm listening. Strikes are serious shit.
So I said, hey, Kathy, our stream got pulled. And I said, we have the SJC order. And I said, you know why that happened? She's like, no. She's like, we didn't do anything. I said, it's weird. And she said, how are you getting the stream? I said, I think Allie was streaming Court TV. And she said, okay, so during Verdict Watch, we are actually showing Court TV programming. I don't know if that has anything to do with anything, but we're not showing the courtroom seal. And then she said you might need to grab somebody else's stream during verdict watch.
But they're the pool camera.
Yeah, but like you can go to Boston 10 or Boston 25. Like, even though they're the pool camera, I just read to you, they're showing paid programming.
Yeah, but why aren't we getting the pool feed? That's what I don't
You
understand.
got to plug in. Like, it's a whole thing. We could have gotten the pool
I think that's
feed.
what they told me I had to plug
Yeah,
in.
right. It's a whole thing. Like, we have to buy the shit. I'd have to get Recovery Addict to walk me through it. Or our friends over at Trial Channel TV, because they've plugged in before. But at any rate, so then I get the email at 12:13, and it says, "Hey, Defense Diaries podcast, due to a copyright match, your stream was interrupted." Video title, today's title. And it says streams are interrupted when copyrighted content is detected. After copyrighted material is no longer being streamed, streams are automatically re-enabled, which is what kept happening to you. So you'd pull the stream off, they would start the stream again, you'd put the stream back on.
Well, I hope that this doesn't mean we're not going to be able to monetize this.
No, it's fine.
We better put the damn thing. We lost 64,000 views. Putting the money on right now.
Well, if you do that right now, then the ads start.
Yeah, they're getting ads. See ya.
Wow.
Ads. We lost a whole day's worth of money. Everyone else has their ads on throughout the trial. We're not even on trial right now.
That's what separates us from the animals.
Well, that would have worked if I would have ended the stream earlier. Now we lost literally all the money for 64,000. How could it be 64,000?
Wait, why do you figure that it's... I don't understand what you're saying. Why do you figure that we lost all the money?
Well, we didn't have any ads on for 64,000 views.
Okay, well, we put them on after the day's event. Like, you don't want commercials popping up in the middle of a closing.
You don't get paid for that. 64,000 views that we've had so far.
And the trial our shit.
So it's time to end
our shit.
Oh, it's time to end the stream anyway. Oh, we got to go through all the chat, all the supers.
All right, start going through the supers because I'm taking a nap before we do any kind of like in the courtroom thing.
All right. Member for 15 months. Thank you, Ernie. I've been locked in replay jail, but want to say hi, everyone. Still the best channel, chat and mods in the land. You're live right now. And thank you for your continued generosity.
Can I call you Big Ern? Or would you be offended by that? I don't even know your size, obviously, but I like Big Ern. Hey, Big Ern. I forget what it's from. It's a movie.
Well, Jenny says, rumor has it, it was trolls that were mass reporting channels that were sympathetic to Lindsay, as it happened to a lot of channels, I think.
That tracks. That tracks.
I don't know if it was or not. That's what I said to Mel, but once I found out.
I'm sure that's exactly what happened. I'm sure that. But Michael didn't get, Justice Served didn't get.
He might be plugged in.
He's not plugged in.
All right. Indy Cindy says, where did the doctor sleep? I asked, but dipped earlier. We don't know. He said one was at a private house, and one was in
a van down by the river.
I think yes, one was in a van down by the river. No, one was in a hotel. But in closing,
I sleep in a van down by the river. I'd have to get really loud to nail that, but
yeah, we know.
Yeah.
But Reddington made reference to that because he asked it of the experts.
Yeah.
All right. Kath Boone.
When we come back later, I want to have a much more detailed conversation about the closings with you.
Oh,
other than missed opportunities.
Yeah. Well, we'll have to see because I gotta. Well, yeah, we'll see. I'll talk to you because I'm like Cam's been sleeping most of the day, but I gotta be with her a little bit. Hannah says CBS reported a juror cried during Red's closing. Did you see that?
I did, and I could not confirm. I know exactly the juror that they're talking about. I could not tell if she was crying or not.
All right. Did she make it on the jury?
She did.
Yes. All right. Thanks, Hannah. Bob will get into it more on our evening live. Marie Martins did a juror cry during the Commonwealth's closing. I'll be mad if it's true. Court TV is saying that, but they lie all the time.
I did not see a juror crying during the Commonwealth's closing, but let me say this. It was second row. I think probably 18, 17, 16.
I don't think you could give
15,
numbers. Don't give
14.
numbers.
It doesn't matter.
Oh.
I was trying to think of where she was from the end. So there was a woman who towards the end of the state's closing, I thought was dozing. So that could be the same because she was like, I just thought her eyes kept closing. Like I did not see tears running down her face. What are you doing? What's going on? What's happening? All right. What is she doing? I don't know what the hell's happening. So I don't know. I didn't see tears, but again, I had
Walgreens was calling with an update. So I was listening and pressing the buttons. I was still listening to you.
I hope it wasn't for my father.
No, leave it be.
Yeah. Boy, he's lucky I wasn't home yesterday. I would not have been a happy boy.
He's still asleep.
I'm sure he is. So I don't know. I mean, she could have been. I really thought she was dozing. Truly, I like Sue was sitting right next to me.
You're talking about the person on the Commonwealth's closing, or the person that might have been crying?
Closing.
What?
Well, somebody just here said that somebody was crying during the Commonwealth's closing.
Oh, I was just making. Right, I was just making sure you weren't referring back to the person possibly.
No, I'm referring to the comment that's right on the screen. So I don't know. I mean, because I told Sue we do like hand signals because we weren't talking. So I like tapped Sue and I'm like, and then I closed my eyes like sleeping. So I'm like, are you seeing the same shit? Is she nodding off? Which doesn't indicate that she thought it was like she might just be tired. I don't know, like who knows? But that's probably the woman that they're saying was crying. I don't think she was crying, but
all right. Well, thank you, Marie Martins, and you got it here first from inside the courtroom. Wow. Kim says that view is killer. Will Margaret adopt me too? Thanks for your generosity. Basin jizz for the most part. I think.
Basin jizz?
Maybe I'm saying that wrong. Maybe it's basin jizz. Because 4 is capital, the is capital, most is capital, so I don't know.
I think it would be jizz, not jizz.
Oh yeah, basin jizz. Basin jizz. All right. I called my 41-year-old daughter. She knew the Shining typewriter reference, and she said her 14-year-old son, and she were just talking about that scene the other day. All right, thank you. Because the boys were saying they thought he dated himself, and there was a good chance there was several.
He's 75.
People, but that there was a good chance there were 7 people in the jury who don't know that reference.
Okay, well, I can tell you, Kevin Reddington knows the average age of those jurors. Every single one of those jurors. Shining was right in their wheelhouse.
Well, there was a 40-something-year-old who said they never saw it. Hey, looky here. The one, the only. Mark
hey, there he is.
I had to depart for new business, which I know you can all appreciate.
Yes.
Absolutely.
So,
absolutely.
but here we are. Look at you, beachside still, loving it.
I mean, yeah, I've been into the ocean one time in the 3 weeks I've been here.
Nantasket Beach.
With this proximity, I've been in one time.
I'm jealous though, because you get to hang out in Massachusetts for a couple of weeks in the middle of summer. I get to do it in December, apparently.
Hey, you're going to be hanging out in Chicago in October, though.
I can't wait. I can't wait.
Me too.
Yeah, it's going to be fun. Yeah.
They're trying to have you have a jury that goes into Christmas, the way that trial could go.
It starts December 7th, I think, is the date, right? Yeah.
Your jurors are all going to be pretty upset.
Well, picking a jury is going to be very difficult. We were talking about picking juries earlier. That's going to be tricky. I'll say no more about that.
Yeah.
And then I won't speak to the merits of it, but if you saw one of the recent filings from yesterday, the trial is going to be in Boston proper, Suffolk County.
Oh, shit.
Even though it's a Norfolk County case. And one of the questions then is where the juror is going to come from. We have until September.
That's the only part that matters, right? Is where the juror is coming from.
Right. And we have until September 10th, I think it is, to voice an opinion on how we feel about whether to allow Suffolk County jurors instead of Norfolk. But I won't talk about that either.
Yeah, and it's a shame because that's a really interesting conversation. It's not as, I don't know that it's as evident as it may seem on its face. Like, you're like, oh, well, like hometown. We want the hometown. Like maybe not. Yeah, it's interesting. We'll have that conversation in private.
No, he's not going to talk about it at all, babe.
We'll have, well, it depends on how many beers are passed around sold. But beyond that, that's and who knows?
So, Mark, I didn't get to hear your take. What were your takes on the closings?
I thought Reddington's was good. I thought he left a little on the table, a little bit. But overall, I think it was really good. And I think, I imagine since you're there, you could see he must connect with them well. I mean, his charisma.
Yeah.
And I just would imagine the jury would like him personally and like his shtick and just the way he practices and has been practicing for probably 50 years at this point or longer. The only thing I thought mostly that we talked about this earlier, so it is somewhat repetitive. Sorry if everyone's heard this.
Not for me.
Allie's like, I'm out of here. I don't want to listen to this.
I'm gone.
I thought he left a little on the table with the advantage that he had with the non-affirmative defense and the burden of proof, and maybe could have said that I have pretty much the top expert in this field, which he said, but that in order to find her guilty, that what that really means, practically speaking, is that the prosecution would have to wipe him out, like discredit him thoroughly. And that if you believe anything that expert says is even plausible, by definition, that's a reasonable doubt. And and kind of compare him to their experts, which were, at different levels, obviously, but not. And so I thought that was kind of left on the table. But I mean, I like the presentation. As far as the prosecution, I didn't like it that much. I thought the most powerful points she made, for some reason, she buried in the middle after she perhaps might have already put the jury to sleep a little bit with the opening salvo of about how this privileged woman had access to healthcare and experts and this and didn't take her pills. Yeah, I just thought it was irrelevant. And also it felt so canned. And she had the advantage of having the last word, and I thought she just gave it away, just stuck to this canned speech rather than react to what he said. And I think the other thing she didn't do also was talk about the burden of proof, in the sense of she made a few arguments that, they're not bad. The CVS trip, the go fetch dinner, the Google Maps. I mean, I get it. That can be clear indicia of, I don't want him to be here, which could show some state of mind of right and wrong and that sort of thing. But I don't think she ever said, how I'm getting over the problem and the burden of proof, and really address the defense evidence, defense experts, and why that doesn't matter and there's still no reasonable doubt. So I don't think hers was very effective in that regard, and she still has the burden of proof and didn't really speak about it. And then I think she got also kind of the disadvantage of the bifurcated charge the judge gave, which was 2 minutes after she finished her summation, the judge told the jury what reasonable doubt is and what it isn't, and it almost felt like a rebuttal summation for the so I think all in all it was probably pretty good for the defense. I just thought the prosecution, I don't know, I wasn't impressed.
Well, and here, let me ask you this question. So, coming into closings today, do you feel that it was her explanation was sufficient in terms of her trying to explain why for 8 days they were beating the jury over the head with the fact that this was a ruse suicide? No. That it was, I mean,
no.
To me, it was, I couldn't believe when both of their experts, which they had to do in order for their motive to work, the suicide attempt had to be serious. It had to be an actual attempt.
Agreed.
For their motives to move. But you and they knew this. They knew what their experts were going to say. I was gobsmacked. I couldn't understand what they were
question
doing.
Their trial prep. I mean, again, and we were talking even earlier. I mean, why was she only evaluated? This case is 3 years old. They've known this is a psych case from the jump, and they have these after the fact experts who are trying to talk to her in 2025 and 2026. Who are going just on what she says and old reports, but don't know anything in real time, and then apparently draw significance from a few inconsistencies, whatever it is, from things that happened years ago. So I don't understand that, and I'll never understand. I mean, I've said this before publicly and say it again, why they didn't just own the mental illness, which I actually made a note in the beginning of her summation. I said, finally, she's actually going to talk about it. And then within 2 minutes veered into, this privileged woman with all of her access to resources and whatever, shame on you for not taking your pills. But I don't know why, as a prosecutor, in a case like this, if you're going to bring it, you have to be credible, you have to show integrity, and you have to also tell the jury, we get it. She's not well, but in our position, the law doesn't excuse what she did, and here's why. And I don't think you spend 5 weeks doing what they did, knowing what your experts are going to say, and then they got kneecapped on this yesterday. I mean, that was
just
brutal.
Couldn't believe it.
Yeah,
Man.
I mean, they walked. Yeah,
Mark, I was sitting in the courtroom just when Heilbrunn, our nice German friend, doctor. I'm like, what a name. I'm like, when this guy first laid it out there, I'm like, holy shit. I'm like, these two women for the last 3 weeks have been just preaching that this was a complete ruse. It was total bullshit. She had no intent on trying to end her own life. And I'm like, I couldn't make sense of it, man. And I was curious if you thought that whatever her strange explanation was satisfactory. I didn't.
No. And I also question, again, I guess it's better to be more humanitarian, polite, attempt to be credible, attempt to show that you have a heart with her demeanor today. But on the other hand, they've been watching you for 5 weeks. And they see a radical shift, and if anything, there's a risk of you're not showing who you are, and that you're comfortable in your own skin, and that you believe anything you're saying. I mean, as a prosecutor, credibility matters, and to shape shift like this throughout the trial, it's not a good look. I don't know what they're going to do. I'm
Never
hard,
know.
hard pressed to think that 12 people are not going to find, just on burden of proof grounds, with how choppy the case was, that perhaps, she's not guilty by reason of mental disease or defect. But, then they threw that manslaughter wrench in there, which we talked about this earlier too. Legally, that strikes me as absurd. Just legally, whatever people's view of Clancy is, it doesn't fit. I don't think there's any reasonable view of the evidence that you could find her not guilty of intending to kill the kids if you believe mentally she was there, but that she did have an intent to act recklessly. That doesn't fit for me.
I agree. And putting that portion of it aside, I didn't know if I loved the move anyway. It's like, because Reddington asked for it. He had asked for it, and the judge bit. And like, I'm like, man, I
don't like it, but I get it. I mean, look,
too.
she's facing life in prison. I get it. And if manslaughter is better than murder, it's a hedge.
Yeah,
but
it's
I
a
think
total
it is
hedge.
also you're asking for a potential compromise on a case where you've gone all in, that she lacks the ability to form criminal intent at the time this happened.
Exactly.
I mean, the jury doesn't know that he asked for it, so it's not
Right.
hard. It's not prejudicial in that sense.
Yep.
But it seems to me that she's either guilty of murder or not responsible because of her existing psychotic state at the time this happened.
And and it's different than when they threw the OUI in on Reed. I mean, that made perfect sense. I mean, that's perfect. Like here, I agree with you. I think it undercuts what you've been pounding the lectern about for 5 weeks, in the sense that it is that hedge. It's that thing where they're like, well, okay. Because what I've always been concerned with this case is, how it is over in Twitter hell.
Very well. Very
right.
well.
I know you do. You see the people out there that are like, I don't give a shit if she was teeming with psychosis or not. She killed her kids. She's going to prison, and that's it. And I think that there's a section of society that believes that and feels that way. You know what I mean? And if you get one of those folks, maybe that, like, maybe you can get them to move to the manslaughter. But I don't think you're going to be able to get the folks that are of the mindset, say, like of myself, who truly believes that this woman was in a state of psychosis when she did this awful thing to her beautiful kids. I just believe that, like, with every fiber of my being. And I'm going to trust the people that were closest to her that testified on her behalf. I mean, to me, Sue Clancy was everything. Like, that woman, in terms of when she walked into that courtroom, and I was sitting kind of like parallel to the door, and I was, all I could think about was what was going on in her mind as she walked in that room, with the loss that she suffered, with the fact that this is her ex-daughter-in-law, and she's coming in to testify on her behalf, and it was like, to me, she was an incredibly powerful witness. And these were the folks that were closest to her, and it wasn't her mother. You know what I mean? Like she held so much weight for me because of who she was now, in terms of that relationship. This isn't her biological, it's not her blood, and Lindsay took her grandchildren away from her permanently. So, 99.9% of the time, you're not getting that person coming in to testify on your behalf. It weighed heavily for me in terms of what she knew. And I knew that she was the one that had put Julie Paul on the case. And I'll die on this hill. I think if nurse practitioner Julie Paul wasn't in the midst of retiring, her notice was in, she was done, and I think her friend came to her and said, look, my daughter-in-law is struggling, and she's been like, whatever she's been doing, whoever she's been treating with, it's not working. I'm asking you, can you please take a look at her? You know what I mean? And from her testimony, just in terms of when she was on the stand, you can tell she was a serious woman who took what she did for a living seriously. And I think that had she not been retiring and would have continued caring for Lindsay and being her treater, that we're not sitting here today. I firmly believe that. I think that she would have changed the course of the way that this thing shook out. She would have seen to it that she got the help, because she had that sense of obligation because her friend asked her to do this. You know what I mean? And I'm sure Paul said, look, I'll be happy to do it, but I'm retiring, and when I'm done, I'm done. I'm going to have to hand her off, and that's when she gets handed off to Gelada. You know, man, and it's like, but for me, that particular witness just carried a huge amount of weight, and and it's like this whole thing where the Commonwealth was shaming all these family members, none of which were in the medical field, none of which were trained in mental health issues. It's like, I'm like, what, are you kidding me? I don't know, man.
They tried a clunky case. There's no question. There was, in many ways, between the mortal sin in the Catholic Church, the way they treated Patrick, the bow ties, the other stuff, the throwing a conniption over, addressing me in court by my name, which, there's other things you could be addressed by would probably be more offensive than that. But I mean, look, going back to the manslaughter thing, if you had people who were locked in on, I'm not letting her go because she killed her kids, and you had other people who were just like, she was sick, like legally sick. Yeah. That probably doesn't get resolved. I mean, you don't know what goes on in the jury room, but that's tough. But now you throw out the manslaughter thing in the middle, and you also add to the equation, they know if she's convicted of killing 3 kids, she's going away for the rest of her life. They're not told that, but they know that. Right. They also know that if she's, not guilty by reason of mental disease or defect, she does go to a hospital, but she could get out, although practically speaking, very unlikely for decades at the earliest. But they know that. So the people who are like locked in on murder are going to be even more concerned about that. And then here comes manslaughter. And you say, well, that'll still get her some time in prison, and they won't know what it is. Right. But not a hospital. And it's inviting a compromise for what feels almost like a legal fiction almost.
I agree. I agree. But I think that it's going to be tougher to get the folks that are of the mindset that the mental disease or defect was real, in the sense that they're like, look, this woman cannot be held responsible because she had lost her mind, and like they're going to be immovable objects. Whereas I think the M1 folks would be, like you said, more inclined to slip to the manslaughter. You know what I mean?
So here's the question.
I don't know.
And it's based off a comment that somebody made earlier. Mark wasn't on when I read it, but they asked if she were to be convicted of manslaughter and there was an appeal on all the shenanigans the state pulled and it was sent back, they could only try her again on manslaughter, right?
If she's acquitted on murder, it's gone.
It's gone.
Right. So maybe that's his strategy. Like, there's some appealable shit here. So let's.
Well, here's the other interesting question. So he requested it. Now, I guess in order to get it yanked on appeal, you'd almost have to have a lawyer argue that he was ineffective for doing that. Because
no, I'm saying, like, I hear that would be a little much, right? And maybe it could win on ineffectiveness. But he's just to say on other grounds, like the other shit that went down at trial.
If she's acquitted of murder, it's gone. Yeah, I mean, if she's not guilty on murder, then you would essentially have a manslaughter case. But again, if she was convicted of murder and it was reversed on appeal, well, no, that doesn't make sense because she'd be convicted. I guess you're right. I mean, technically, it is one way to make it a manslaughter case, I suppose. It take a long time to get there.
Right.
And then, of course, if she was retried and convicted of that, whatever the sentence is, times 3, probably. Either way, it's almost like six, one half dozen of the other. She's going away for maybe not life, but damn close.
Yeah, I mean, but Sullivan's got the difference being that it's mandatory life on the M1, whereas with manslaughter, it's a range. You know what I mean? And Sullivan
times 3.
But even if he goes low end, you're looking at 15.
I can't imagine.
How could he go low end politically? I mean, if a jury concludes that she, of sound mind, legally speaking, again, as absurd as this sounds, recklessly killed her 3 kids and appreciated the risk and disregarded it and blah blah blah. But we all know, I mean, it would be intentional, really. If, again, taking the mental health aside, it's clear what literally she did. How do you, as a judge, not impose as much as you can?
I think therein lies the rub with the way, like in Illinois, we elect our judges. Here in Mass, they appoint them. So, like, the political strain that he might otherwise feel.
Yeah, but still, we know he's not.
Let me finish what I was saying. Like, I don't think that would exist for him. And let's just assume, as a career defense attorney, which is what Sullivan was, that he doesn't feel the same way that the jury felt in terms of their verdict. And, obviously he's not going to set it aside, but he could, in some world, say, you know what, I understand and respect, and I'm going to, respect what the jury's done here. However, in light of my ability to have the discretion in sentencing, I'm going to sentence her on the lower end. I mean, if I were a judge in that position, I wouldn't give a shit. Like, if I was sitting there and saying, okay, had this been a bench trial,
you got to face everybody on the days later, though.
So
all
what?
the other people
Maybe you're assuming everybody thinks that psychosis doesn't exist in the world.
Right,
no, but I think most people would say, if you take a defendant who is guilty, again, whatever, just assume it comes out. The jury convicts her. Okay, so legally she's guilty of strangling her 3 kids, young, beautiful kids. Forget who she is and just said, what do you want to happen to her? I think you would have about 99.5% of the population would say, what's the maximum and how do you make sure she gets that? And I think that's what most people would say. Now, we're lawyers. We look at this stuff from a different way, and there are legal issues clearly with her mental illness that impact the outcome. And it's a shame that the prosecution didn't at least try the case acknowledging that until kind of the very end, but not really.
Oh God. I feel so exactly like you do, Mark. Like try this case on the up and up. It's like it's a legitimate issue that should have been addressed head on, and let's deal with it. Because look, I mean, no one who has any idea how the criminal justice system operates as a whole, and I don't really care what state you're in, by and large, mental illness is really not accounted for. I spent decades trying to get.
I'm just troubled with, and again, you can only go in your own experience with these kinds of cases to the extent you have any. They're trying her in 2026 for what happened in early 2023 with experts who interviewed her in 25 and 26.
Yeah.
That's not helpful. And some of them don't appear to even have the right psychiatric nuance, specificity. This is problematic. I mean, and I also wonder, just on, again, my own experience, what were they doing for the past 3 years? I mean, were they in good faith? And I don't know the answer to this. I don't know what Reddington was doing either. Were they open to the concept of him pitching them and presenting them with evaluation reports and everything else about, look, she's NGRI, agree with me. Let's agree and put her in a hospital. I don't know, but I can't believe they tried this case without any experts who interviewed her in close proximity to the incident years ago. And then their powerful evidence is, well, she, said things in 2025 and 2026 that are lies. They're not true. They can't be because she got it wrong or whatever. And they don't account for the time lapse. They don't have anyone who looked at her back then, so what do? They have her treating physician who is, in doctor years and doctor dog years is a child with no experience. She's doing it on Zoom, which so are we. Everything. I mean, I get it. Since COVID, a lot of things are on Zoom, but this was after COVID. And this is you're doing mental health interviews of someone who at least clearly has postpartum depression and has other problems, and you're just giving them, pills on the internet essentially, and doing telemedicine, not taking proper notes, you have no experience, you've never dealt with this before. I mean, this is a tough way to try a case, and then to do it tactically the way they did and minimize the mental illness instead of embracing it and just saying, she can still be guilty and be ill. No one's saying you get a pass because you have mental illness, but it's a hell of a way for them to try the case, to basically say, if you're not seeing unicorns and you're not rocking back and forth staring at the wall, then, you're not ill enough. It doesn't work that way. If you go to a kid's birthday party and smile because some kid got cake on his face, well, clearly, right from wrong and are in full control in terms of controlling your actions.
Right. And if you don't get mental health, if you don't get the right kind of mental health help, and you don't comply with it the way they interpret comply, you're not even eligible for this defense.
Well, that's a great point, because I know we talked a little bit about that earlier. They conflated criticism of Clancy's mental health regimen and willingness to engage. And that's all fair, like in an abstract, but now you're talking about proving beyond a reasonable doubt whether she had the ability to form criminal intent. And the fact that she may have been a shitty patient, well, that's unfortunate. And that may suck in terms of what happened, obviously. But in terms of proving her guilt, that doesn't mean anything. That has nothing to do with, she may have screwed up her pills and treatment, but that has nothing to do with whether she could or could not have formed criminal intent. You can't punish her for acting like a bad patient when she later on does that. That's not how criminal law works. That's not how due process works.
That's what they argued. There was no objection.
Yeah.
Well, frankly, what upset me the most in terms of how they elected to try the case was this concept that they, even all the way through closing, pushing this narrative that if you're in a state of psychosis, that your intellectual capacity disappears like a fart in the wind, and it just doesn't. You're able to, you're able to operate a phone. You're able to use Google, and like it's that thing that you were talking about, with the whole unicorn in the corner thing. And it's just disingenuous. It's
antiquated.
It's antiquated, and it's not true.
But again, you go back to, where are they getting these experts from? The idea in 2026 that mental health experts are not aware of that people who may very well be ill and be psychotic or have serious mental illness or kind of come in and come out of psychosis are not walking zombies 24 hours a day, who they don't walk around drooling on themselves, muttering in tongues and doing these things. They can actually function. They can put their shoes on and go walking and say, it is my purpose of tying my shoe and I can go walk. They're not literally unable to function. And then there are times where, if voices are being heard, commands are given. Those things happen. It doesn't sound real to people who don't experience it. Right. But, if you've been doing this as long as we all have, it's real for certain people. And, when you have the defense expert that you had, and you had the prosecution one who really didn't do that much other than agree unwittingly that the prosecution's premise of the case for the first 18 days was, as I like to say, showed no nuance. It was this oversimplified view of, and their own expert blew that up. And so, I mean, who knows? You know, I think the
gotta take
deliberations
this.
are
See,
going to
that
go
was
on.
like something I would have liked to have seen Reddington lean into. That little part right there when he was able to. And I didn't catch it in the room whether or not it was obvious that what he was reading to the doctor was a portion of the Commonwealth's opening statement. I didn't catch whether or not that was out. I didn't know if Reddington said it. I recognized it when he was doing it, so I knew it, and I leaned. I forget who I was sitting next to yesterday. I'm like, oh, that's the opening. He's gonna run this move on him. And then when the guy answered the way that he did, I'm like, wow, you can't write it up any better than that, man. I'm like, that was amazing. But I didn't catch whether or not that was known to the jury. And, you know, I'm like, okay, well, whether or not it was or it wasn't matters not, because he'll bring it up in closing. And then that didn't happen. So I was like, you know, but it's easy to sit here and armchair quarterback shit. You know what I mean? It's like,
and I also think, look, he gave like one of those real old school connect with the jury, move around, get animated, change your tone, your intonation, modulation, and it works. The risk sometimes of that, you know, the cost benefit analysis is if you're not going to give yourself a net or, you know, a list of bullet points like hit this, hit that, you can lose things. You just, because I mean, it's still, you know, not a perfect science when you're doing this without a net. And so, you know, it can get a little redundant at the end or a little repetitive, but it seemed, at least from out here, it really connected. I mean, I thought it was good.
I was getting it was funny because I was sitting with media, a vast majority of which are not attorneys, you know, and I was asking them what their take on the closings were, and a lot of them were like, you know, I thought that the prosecution did pretty well, you know, that they thought, and I was like surprised. Then my wife texts me, she's like, oh, I'm worried about the Commonwealth's closing. I'm like, what do you mean? She's like, I thought, you know, I thought she may have scored some points there. And I'm like, really? I was like, I don't know, man. I just must be such a die in the wall defense attorney. I didn't see it that way.
Well, I mean, look, I also think, though, obviously a guy like Reddington, it's riveting. The jury's paying attention. And if you're the prosecutor, I don't know why you would go into your canned speech for 30 minutes and then break out a description about the timeline doesn't fit, the phone call had to be at this time, you know, all that kind of stuff.
Right.
Sending them out, checking Google Maps, doing all that. Why not lead with that? I mean, the case is about one thing and one thing only. I mean, they're arguing she knew right from wrong. Period. I mean, that's it. The murder's conceded. I mean, the killing, not murder is a legal term. The killing is conceded. And I just don't know why you would bury the lead in 30 minutes of meandering on about, you know, why didn't she do this? And she could have done that. And she went to a party and smiled and all this other stuff, and say, why not just, if you're looking for evidence of she knows right from wrong, then make your argument, which is she just happened to do this right after she sent him away, checked on how long it would take, you know, and that shows something. Why all this other stuff? Why die on the hill of 2 weeks of whether it was a real suicide attempt or not?
It'll never add up to me why they elected to do that.
Yeah.
All right.
But
man.
I think real quick, I think the defense benefited by one thing. Usually they don't. You know, the prosecution goes last. It's such a huge advantage. She didn't do anything with going last. I mean, she stuck to her canned speech and didn't kind of like pick apart anything I thought Reddington said. So I don't think that hurt him. But, you know, I guess when the verdict comes in, we'll know.
Well, no,
Or
none
not.
will know.
Yeah,
Or not.
exactly.
I mean, I
If there is
I-
no verdict, can you
right.
imagine?
That's where I've been on this thing since the inception, and nothing's really changed my mind. I think it's such a divisive issue, and I think that there's just people that exist in the world that, fortunately for them, they've never had anybody in their life that they care about that has been stricken with this kind of mental illness, where they just don't think it's a real thing. Not in the context where somebody is capable of doing something like this and truly not have control of their mind. You
Yeah.
know what I mean? It's like,
Yep.
it's a hard thing for people to grasp. And it's like, you're really trying to rationalize an irrational act, and it's kind of impossible to do. All right,
Yeah.
I'm gonna go through these
Yep.
super. Love you, brother. Thank
All
you
right,
for
we'll
jumping
talk.
on, man.
All
All right,
right.
man. I'll
Have
see
fun.
you.
Bye.
All right, bye. All right, the one and only Mark Bederow. Thankful to him. I'm sad I missed Ian. I'm sure he was wonderful, as he always is. Let me start going through some of these supers here. I don't know if we got to this one. I don't know where Allie started or ended. I can see here. I'm going to start here. Gabby for Justice. Couldn't it run consecutive? So 20 times 3, it could. And it most likely would. In terms of consecutive or concurrent. So concurrent means that they run at the same time. So, but yeah, it could. And I'm speculating completely in terms of what the judge might do with respect to if they land on the manslaughter. He would handle the sentencing. Do I think that there exists a world? But everybody was telling me that the judge wasn't going to dismiss Aaron Spencer's case. And, I'll just leave it at that. We know how that worked out. But thank you for the 2. I appreciate it. Glokenard, thank you very much for the jewels. Queen Moo, $10. If her Apple Watch was recording her heartbeat at the lowest it had been all day, then surely that raises the questions, especially as that was when she was supposed to be unaliving her children, right? Like the issue with how the Commonwealth elected to try the case, and make no bones about it, they had to. Once they decided there's no way in hell we're going to allow the homicide aspect of this case to be stipulated to, we're putting the evidence on, it's like they said it. They said it during the argument. Like the defense is just trying to put the kids out of the minds of the jurors, and we're not going to allow that to happen. The kids have to be thought of here. They were lost in all this, and that's what our focus is going to be on, and the jury needs to hear it. And, of course the defense doesn't want to, so that argument, and it has merit, it's a merit filled argument. But the problem it creates is you've got Reddington on one side, like, I'm not going to even cross these guys. If you'll remember all the way back to the beginning of the trial, when the cops were getting on the stand, there were a couple he asked a few questions to, but for the most part, no cross, right? So he wasn't challenging that aspect of it. And at the end of the day, you're just having to lean into what he felt was the issue in the case in controversy, which truly was the issue in controversy. So, yeah, I don't know. This is probably one of the toughest juries that I think I've seen 12 people have to sit on and make a decision. It's that thing where there's no CAT scan or MRI. There's nothing that exists on the planet in terms of the technology we have available to us that you can put an image on a screen and say, there it is. You see that spot on the brain right there? That's the psychosis. That, it's like you're arguing this thing that some people think is a thing. Some people know it's a thing. Other people don't think it's and there's no way to prove it, which to me is the difficulty with the burden of the Commonwealth having to prove beyond a reasonable doubt that she did not have psychosis, because they agreed. They got past the initial hurdle. They agreed that she had a mental disease or defect. That's no longer in controversy either. So the question then slipped into the two prongs, which is an either or proposition, or it could be both, but it doesn't have to be both. That's where you're looking for the and. You know, when you're reading statutes, every word is incredibly important within a statute, and that statute is or. You know, did she understand right from wrong in simplistic terms, or not and, or was she able to conform her conduct to the requirements of the law? You know, and could it be shown that both of those things existed? You know, and it was so, like, you're hearing these experts for both sides, really. You know, when you know what they're going to say at the end. It's not a mystery. You know, they're testifying for one side or the other. They're going to be saying what they need to be saying. So I never know how much weight jurors actually give that stuff. It's the educational part that I value of expert witnesses more than their ultimate opinion, because experts can be incredibly important in terms of educating the jury as to things that may not be within their realm of understanding or their knowledge base. You know, so you need those experts. That's why I was very concerned that Spinelli didn't testify, especially in light of the fact that there were 6 men on the jury, none of which who are obviously ever having a baby and have never experienced the hormonal upheaval that goes on in a woman's body, you know, before, during, and after birth. You know, like, you need an expert to come in and explain this is what's going on in a female's body before, during, and after they give birth. And this is what can happen with their mind as a result of the hormones, you know, and I don't even know, did he, I can't remember, did he bring up the breastfeeding thing in closing? I don't know that he raised it again. I thought that was a very powerful point. And I think he probably would have drilled home on it if Spinelli would have testified, because there's no question she would have touched upon that particular area and what impact that stopping breastfeeding can have. And what the question of if she stopped in October, would she still be experiencing what she was experiencing potentially as a result of her stopping breastfeeding all the way into January? So, you know, those questions kind of like were left unanswered to a certain extent, but, you know, but man, yeah, this is just a tough case for a jury to sit on, you know. And I had like somebody, I was like tweeting this morning. I put out my tweet with that sunrise because we were up so early, and, you know, and I was acknowledging that the jury has the weight of the world on their shoulders. And like, there's some idiots that are just like, wow, being so dramatic. I'm like, what the fuck are you talking about? Like, how tone deaf are you? Do you not realize what it's like to sit in judgment of another person at a trial, where when the reality of what you're doing takes hold and you realize, wow, like, what we elect to do here in this room is going to forever change the course of that person's life. You know, this isn't a TV show. You know, that's what I told this woman. I'm like, you just don't fucking get it, man. Like, these trials aren't games. You know, I don't go into anything lightly. You know, I really don't. And I'm never beholden to anybody. I don't give a shit what side they're on. You know, it's like, you guys who watch this channel have been watching this channel for years know You know, like I'm not, oh, everybody's innocent. That's fucking absurd. And it's insulting. And it diminishes the weight that should be felt in terms of when I say that I believe that somebody is factually innocent. I mean it. I don't give a shit what anybody else thinks about it. And people are allowed to disagree, but I don't go into those things lightly. You know, and I take risks on this channel by alienating people. I mean, that in and of itself should tell you I don't give a shit about clicks and whatever the fuck people are always saying. Oh, clicks and whatever. No, man. If I wanted clicks, I'd ride the fence because that's the safe bet. You know, so for all the people that like to talk their shit, you know, answer me that. Answer me that. Why would I knowingly alienate potentially 50% of my audience when I take a position on a case that I feel strongly about? That's how strongly I feel about certain cases, to the extent where I'm willing to put it out there because I'm an advocate. I'm not some dude that's reading wiki pages on cases, or I read a book, or I watched a fucking documentary on it. You know, I've been in the system for decades, and so was my wife. And, you know, and I respect people disagreeing with me, because everybody is entitled to their own opinion. But to attack people, and like hate people because they disagree with you on a case it ain't it. It ain't it. Like, you need to, like, those folks need to take a look in the mirror and ask themselves some questions. You know, it's like I've never disliked somebody because they completely disagreed with me on a case. Be like, wow, I hate you. I hate you now. Think about how stupid that sounds when I say it just like that. Like, especially people that have zero vested interest. It's not your family. Quit acting like it is. Quit carrying the banner. You know, it's like when I'm on a position, and frankly, it's rare when I think that somebody's factually innocent, because 95% of the time cases plead out, because 95% of the time they get it right. In the rare cases that go to trial, they typically go to trial because there's issues. You know, and you have to be of the mindset that wrongful convictions are some kind of fantasy fiction, that they don't happen, that these cops never get shit wrong, which is absurd. Again, we're not living in a TV show. These are not scripts. These cops go to an academy for however many weeks, and then they become cops, and then they work their way up, and then they become detectives. They're not Monk. They're not Columbo. They're just regular folks that have a gun and a badge, who had some training, they have some experience, and they're doing the best they can to try to solve crimes. And to think that they're not ever wrong is ridiculous. But whatever. All right. Purple Grizzly Tech, 5 pounds British. Thank you very much. I've been lurking throughout this and just want to say thank you for your coverage. So passionate and insightful. And also, I love your snark, Allie. Man, I missed a lot of her snark. I know she was firing on all cylinders on this trial. I'm sad to have missed it. Reality with Krista Marie, $5. I love our shoobies. You can be a non-shoobie and buy my parents' house, selling one of the rentals in the Crest, and be my neighbors. Are you talking about? I mean, you gotta only Philly, Jersey when the Philly people come in, right? The Jersey folks call them shoobies, right? Allie knows the answer for that definitively. But thanks. Allie would love a beach house, I'll tell you that. Dieter, thank you very much. Misbehaving, $2. Use CCs to cover accused killer mom banner. Oh, closed captioning. Yeah, I hate that banner. I hate that banner. Do better.
Can you mute for just a second?
For what? I know. I was getting cooking instructions. So let's see. Nola, RN Jen, $5. Any prayer warriors out there, let's collectively say a choir prayer for Red, Lindsay, and that jury. God be with them and give them strength. They're gonna need it. That is gonna be. I'd love to be a fly on the wall back there. Man, I'd love to be a fly on the wall. Sav Bent, and thank you very much. $5. Thank you. This is a masterclass of real, authentic, and zealous advocacy. Chills. Yeah. That came in early. Queen Moo, $2. Oh my God, I want to give Big Red a hug. I can see obviously Allie wasn't going through stuff early. Elkie.
Thank you.
Elk.
Do I need what?
I'm never gonna be able to pronounce that. Elk.
Yeah.
Why? I'm gonna just call you
Okay,
Elkie Tarot.
Okay, bye.
Call it a day. Thank you very much for the jewels. Wearmouth. Is that how I say Weymouth? 5 pounds British. Real life Perry Mason. The clerks haven't taken their eyes off him. Go on, Kev. Yeah, he was great. Autumn Blaze, $5. I wish Red would have pointed out that their experts had 0 PP experience. Postpartum was hardly mentioned unless I missed it. You did not miss it, but it was still powerful. Yeah, I agree, but they know. Like that was pointed out enough really, really heavily during cross-examinations. I just think that it's one of those things where, is it worth a mention? Yeah, probably. Is it like a death knell to a closing? No, because he had hammered it home. Like bringing up the bands, whether or not they were tied. And I think she's still misrepresenting. People clipped where he said that they were tied like you tie a shoelace, just without the loops. And he used the words, I untied them. She still was lying in the closing. But like he brought that up because he didn't make a motion to have the record corrected in terms of what was said by Patrick Clancy when he testified. So, but yeah, I hear you. But like, again, it's really easy to sit back when you're not in the well of the courtroom delivering a closing, to kind of be like, oh, I wish you would have said that. And you know who else is doing that? Every single lawyer that's ever given an opening or a closing. There's never been a closing where I wasn't like, damn it. I meant to get this point out. It's just, it's impossible. You have to just rely on the jury having been attentive and hope that they'll go back there and do the work, but thank you. Boris, Remember, for 16 months, this closing is decent considering the case isn't. So I'm assuming you're talking about the Commonwealth. I think that was the general consensus. You know, I mean, you have to put away the aspect of which I don't know if the jury's going to be able to in terms of her demeanor, both of their demeanors throughout the course of the trial. Are they buying this in a closing where everything that preceded it was the diametric opposite of it? You know, or does the fact that she's trying to come off as an empathetic, caring individual ring hollow because it's performative? You know, I don't know. Like, are jurors even thinking like that? You know, you never know. Maybe 3 of them are, 9 of them aren't. Like, where's this woman been all the whole trial? You know, like where have you been? Who knows? But thank you. Mama Eve, $5. You are you sure? Thank you for the 5. Joy for Truth and Justice for John O'Keefe, $10. Oh my God, it's killing me. I despise this woman. She's so fake. Here you go. If we see the complete 180, she's done overnight. The jury will see it too. Wow. I should have just said what I said after I read your comment. Saying the exact same thing. Ugh, she's such a disgusting excuse for a human being not guilty. Thank you. Shota, see, thank you for telling me how to pronounce it. $5. I was done with the CW yesterday, so I only listened to Shred's closing. My BP can't take the CW shit of a case, so it's on mute, just watching your face. What was Allie's face telling you? I'm dying. Dr. Jen Toxic, member for 19 months. And thank you, Shonta. Melanie's chat got shut down. Get ready. Yeah, so did ours. Colleen, say hi. Oh, family hug, new member. Welcome. And Ninja Catherine, I did it. I was like, what is that? Ninja Catherine. Thank you for the jewels. Little Miss Motions, $7. First flight exactly, Pat enters CVS. Second flight exactly, Pat exits CVS. Both calls, 5:34. Not at 5:33 and 5:34. Exactly when Pat is out of sight of cameras. I take it you're still on the Pat did it train. Yeah. Thanks. I completely and totally disagree with that. But Mandy Moore, $10. The fact that Callan was able to be resuscitated completely goes against the thought process that she started immediately.
All right, she got me for 10 more minutes, and I might be gone for the night.
Bathroom door.
Come
on, man. Come on. You'd think after 3 weeks in the upstairs setup, she'd figure it out. Yeah, I don't know.
All right, you got me for 10 more minutes.
Well, I mean, you don't even have to jump on at this point.
All right.
I'll read through them and, you know.
All right, and I'm not sure if I'll be able to come on with you tonight or not. We'll see how Cam's
Why?
feeling.
What's going on?
Just Cam's not feeling great.
Okay.
All right, I love you.
I love you too.
Bye, guys. Thanks for watching with me. It's 8-hour live. I love you, Dave.
I love you.
Call me when you're off, okay?
I will.
Cam's watching it now. She's outraged. She just came in and she said, "What? Now she's it's understandable and she's relatable." I'm like, I know. I wanted to use that claw hand and I told Cam, I'm like, find the part where she says, Being a mother is the atrocity, cruel and atrocious. I'll find a timestamp. I heard it. Did you hear it?
When I was in the room,
Yeah.
yeah.
Wow. Okay.
I couldn't
Love
tell you the time though. Love you too.
I know. Bye.
Alison, A, $5. I'm late with this because I'm at the beginning, but this is Patrick drink definitely came from a SpongeBob episode, not this trial. Oh. He lives in a pineapple under the sea. Thanks, Alison. The devil's lettuce. $7 Australian, I believe. I really thought K-Red would have mentioned the parts. He got the CM experts to admit that they agreed with the defense's evidence. Thoughts, Allie? Did she get to that? Yeah, he didn't. I mean, when he's thinking about his closing, he's picking out the parts that I think that he believes were understated throughout the course of the trial. I mean, when he's crossing those guys on stuff like what you're talking about, it's hard to miss it. And it was so close in time to the closings. I think that he probably just opted to let it stand where it was. But I mean, I hear you. Because you never know what a jury picked up on. And there's 18 of them. You don't know which 12 it's going to be. And, I mean, just think about life. People often miss the point if you're trying to say something and you've got a very defined point and you're sitting there and then the person gives a response where you're like, all right, well, you clearly have no idea what I was talking about, and it's like you don't get to quiz a jury as to whether or not you understand what just happened there. Because sometimes it's nuanced. So, yeah, I mean, I hear you. I mean, and kind of a bigger point is the fact that you felt compelled to type that out kind of makes your point. You know what I mean? It's like, but you do have to kind of pick your poisons a bit when you're closing. It's like you're just never going to be able to fit, and I'll just call it 3 weeks of evidence into your closing. Because that's really where I considered since I got here with the cross of toughs, is where I considered the trial to really have begun. So, but thank you for your generosity. Michaela, $2. If they snack back, why did Patrick have to unwind them? I mean, he said untie them. I mean, people were clipping that left and right that day when that whole thing with La Posada on the Zoom went down. I mean, it's not an interpretation thing. You just listen to what he said. You know what I mean? I don't know. And then she doubled down in the closing today. So, I would not be surprised if one of the questions was, can we see Patrick Clancy's testimony regarding the bans? What did he say? We need a refresher on that. I wouldn't be surprised. And thank you. Views through a lens. Thank you for the jewels. Storm Dancer. Was she in Elsie's head and knows exactly how she was feeling, thinking and hearing? She's such a liar. as what I expect from this DA office. Sit down already. I mean, that's the thing that just drives me nuts. Bad choice of words, but like the any prosecutor pretending that they're in the mind of somebody or that they have any idea what was going on in her brain is so disingenuous. I can't with it. I can't with it. It's like you have no idea what was going on in her mind. Good message, and thank you. Bailey Church, thank you for the jewels. Shannon L, thank you for the gifted 5 DD podcast memberships. I appreciate that. And hopefully you guys all thank Shannon back at 11:45 a.m. Thanks, Shannon. Moo Brews, thank you for the jewels. Shonta 5 from the comments, glad I muted from the movie Shining, the movie Shining's twin evil self. Both of them look like an older version of those twins. Isn't it funny that those memes were going around with them dressed in the twins outfit from The Shining, and then Brad uses a scene from The Shining? Like, and that's what I'm saying. Like Allie was saying that some people were like, "Oh, he's dating himself," and the movie quote's going to be lost on them because it's. But this is an older jury, and if they're any kind of movie fan, they've all seen The Shining. It's one of the classics, and I love that scene. Jack Nicholson's deranged ass had been sitting there for weeks, just typing the same thing over and over and over and over and over. I wanted him to use the monologue I pulled from Good Will Hunting. Plus, it's a Boston movie, so I think it would have resonated with a mass jury. Like, and it was, if you're not on Twitter, it was the scene where Robin Williams is kind of flame throwing Matt Damon, because Matt Damon had looked at the painting that Robin Williams had done, and he makes some kind of hurtful critique of it being muddled and, hypothesizes that it had something to do with him being with a woman that he was never in love, some shit that Robin Williams was really upset about and went and thought about it that night. And then when they're out by the water and they're sitting on that bench, and he goes through, he's like, look, you're a genius. You've read all the books. You can cite all kinds of shit. You can talk about the Sistine Chapel, that scene. And he goes through the laundry list, but you never lived any of it. That's what I feel like all these experts were. Both sides are all men. At least the defense experts acknowledge that postpartum depression is a thing in this world. It's like these guys for the Commonwealth. My God, if you're in the medical community, if those guys were like a treating psychiatrist and they had like patients, and I caught wind of this trial, I'd be like, man, like, I am done with your ass. Like, you really don't think postpartum depression's a real thing? Really? I don't know. They got to walk out of that courtroom. Oh, this is some insider shit. I can't believe it wasn't one of the first things that I thought. And I don't know if it's out there, and I'm not going to reveal my source at all, but Avram Mack is no longer employed. talking about the first witness for the Commonwealth, no longer employed. And I think every hospital that he was affiliated with has removed him from their website. Have it on good authority. Thank you very much, Shanta. 4 of 6, $10. Thank you. Concrete Jungle, 250 euros. Love it. Can Red get corrected record regarding bans? No, he had to do it then. That's what I was talking about. Like because I asked him flat out, I'm like, are you gonna ask the judge, to correct the record in terms of what was actually said and point out the fact that she just made some shit up on a whole cloth? And he handled it in closing. Hopefully it was enough. Thank you, Concrete. Dottie for Gotti. Thank you for the jewels. Sunny Day Steph. What's up, Steph? I jumped every time Red slammed stuff on the tables with the mics. Do you think jury heard as loud as we did? Still did amazing justice for Elsie. No, it did not sound that loud in the courtroom at all. I mean, I was 8 feet away from him or whatever, 10 feet. It did not sound like you had it getting amplified through the microphones. Because I think there's microphones on every table. The courtroom, it didn't sound nearly as explosive. Like when he snapped the quarters. I give it to the Commonwealth. My favorite thing that she did is when she snatch up the quarters. She's like, I'll take this one. Puts it in her pocket. I was like, all right. Douche. Thank you very much. Sunny Day. RMS, Mass Injustice. Thank you for the jewels. And SS Web. I'm assuming you're talking about the Commonwealth. They had a stronger close, unfortunately, just my opinion. I mean, you're not alone. Like, that's what I was saying. I was sitting next to Lauren and I was sitting next to, I don't know what publication she wrote for. Might have been USA Today, but it was one of the bigger publications. And they were both like, yeah, I wasn't feeling Red's closing. And I thought the CW's closing was pretty good. And I was like, really? It's like, I just not seeing it. I mean, that woman's so full of shit. I'm like, did you watch the whole trial? I don't know. Chicken shite. Member for 1 month. I bet Allie can pronounce my handle correctly. No question. No question. Thanks for being a member. Dottie for Gotti. Thanks for the jewels. Desi Dog Mom. Thanks for the jewels. Boris 5. Count your days, YouTube. This is ridiculous. Ugh, no. Like, I'm sitting there, like, just walking out of the courtroom when Allie starts, like, hammering me, like, what's happening? They cut the stream. It's like, it's fear-inducing when they cut your stream like that. You're like, what is going on? It's crazy. Oof. DK up. That's what I'm going with. Thanks for the jewels. Cynthia, $2 go to Law and Crime Alley. That's been working. Yeah, it's like Law and Crime and Court TV are one and the same these days because Law and Crime bought them out, but we survived it. Fortunately, it wasn't during the actual closings because the end instructions were boring as shit anyway. Like, I mean, fortunately, right? You guys made it through all the closings, right? Yeah. Trialed. Trial addict extraordinaire. Thank you for the jewels. Amanda, thank you for the jewels. The virtual juror, $2. Group mass reporting pro Lindsay channels. I mean, that's what my guess is. There's got to be a better system than that. There has to be a better system than that. I think it should only be the copyright holder that can do it, not just some randos. You know, especially because we have authority to restream it. We went through the process. That's how I sat with the media and was able to use my phone. Whatever. Lovely Gigi, $5. Why does the judge pick the foreman and not the balls? I cannot even begin to answer that question. I don't know if that's just their normal practice or if that's Sullivan's normal practice. I don't know. I really don't. But somebody said, you know, oh, they always pick number one, whoever's in that seat. You're it. All right, so these are going to be a bunch of supers during the stream getting shut down. Michael, not up on YouTube, but up on X. So that was us. Thank you for the 2. Misbehaving, trolls reporting LC supporters, not law and crime or court TV. That was true. I confirmed that with Kathy Russin. And thank you for that. Stephanie Mum, thank you for the jewels. Stephanie Mum, thank you for the jewels. Three times, another time. Thank you. CC from Tennessee, thank you for the jewels. Kelly Whiteside, $5 is DA going to get in trouble for lying about Patrick's testimony during closing. She said she never testified the bands were tied. No. Like, everybody's like, that's just not how this shit works. Like after all the Karen reaches, is Tank going to be in trouble? Like, why isn't Canoni in trouble? Alan Jackson's going to be in trouble. David Yannette. They're trying cases, I'll just say I misspoke. Some bullshit. But no. Don't hold your breath. Sylvia, 1,000 jewels. Thank you. Disco World Edge Witch. Canadian 5. Is it me or does Sprague act and sound uncannily like Lally? I hope I'm not the only one who sees it. What do you guys think? She giving Lally vibes? Thank you for your generosity. Chiefs Royals, $10. Follow up. I sent clip of last rebuttal witness to DDX account. He did deny listening to 911 call during X and the next day. He said he listened to it, so CW would have given it to him that night. Issue? It's a good question. I mean, there's not supposed to be any communication. But if he had it, because typically when we hire an expert and they need certain things, then we send them whatever they need and they have it. So, in theory, he would have all the materials, including the 911 call. So I don't know. I mean, if he's having a conversation while he's still on the stand, yeah, that's an issue. But the fact of the matter is he probably had the materials. Thank you for your generosity. Magical Mary, thank you for the jewels. Molly, or morally neutral, $10 Canadian. They keep confusing delirium with psychosis. The whole thing was confusing. Like, honestly, it was like, what are you people doing? I just don't know what you're. I don't know. It's crazy. But thank you for your generosity. Serene Owl, thank you for the jewels. Again, thank you for the jewels. I like your dog more. Member for 2 months. Why do Ian and Mark think, what do they think about Spinelli not testifying. Hopefully they got to that question when they were on there, because they gone. But thank you. Winnie the Golden, $5. I don't think Spinelli could testify because she had started medication. Accurate. That's exactly what was going on. That's exactly what happened with her. Miss Priss, and thank you for the generosity. $2. When was the jury instruction revised? Recently. Pretty recently. Very recently. I don't know exactly what year, but it was very recently. Thank you. Michelle Underdown, thank you for the jewels. Ritzy one. $10. I was offered by Jennifer Sprague. I was offended by Jennifer Sprague minimizing LC's fear of taking. Is that how you spell it? I know what you're talking about. I think it's a different spelling. The moment my doctor said fatal rash, it didn't matter how rare. I said, absolutely not. That really bothered me. Yeah, it was. But I thought that Red handled that well. Because I think most people would be like that. You know, if the doctor's like, well, you know, you can take this, but in very, very rare situations, it's known to cause what's called Stevens-Johnson rash. They can be fatal. I'd be like, yeah, pass. What else you got? So I hear you. Concrete Jungle. $250. Could false facts from the CW be used for an appeal? Yeah, I mean, it's an issue. You know, it's definitely an issue that could be used for an appeal. Thank you. A Dog Mom, thank you for the jewels. Simtoshi, thank you for the jewels. Cynthia, $2. Have Bob join as a guest, Allie. We tried that from the car. It sucked. It's no bueno. But thank you. Probably as NG. I'd like your guys' thoughts on the people that think Patrick did it and blame Lindsay. I think that's crazy. I don't know if they got to it. I don't know if they got to your question, but I'm assuming that they all are of the same mindset that I am and Allie is, that the whole Patrick thing is. I get it. I mean, I understand. Like there are certainly, because the investigation was what it was. You know, I mean, that's that thing where when cops think, well, we don't have to solve this one, then they don't do the work, which is what happened here, you know. Jennifer Hipsky, thank you for the jewels. Appreciate it. Lovely Gigi, thank you for the jewels. Allie the Cat Tracks, thank you for the jewels. CCG Shots, thank you for the 5. We appreciate that very much. D. Desderata, thank you for the jewels. Optopoppet, $5. I mean, Mass has a solution for the Patrick stuff. Just ask Aiden. No idea what Aiden said about it, but thank you for the 5. Jay Malay, thank you for the jewels. Susan Davis, thank you for the jewels. Sarah B. Creative, $10. I think of them as an overcooked steak. I prefer mine mooing. Wish I knew who you were referring to there. Well, that wasn't that long ago. Oh my God, it has been that long ago. Oh, gosh. Thanks, Sarah. You're the bee's knees. Concrete Jungle, $6. Well, €6. If MS can appeal due to CW bias, misrepresentation of evidence, and get retrial without M1 and 2, Bob, have you any info on jurors? Now they've finalized. Yeah, I gave you guys that, right? It's 9-3, women to men. 2 youngest women not on it. Average age 40 to 55. There's an older gentleman, I would guess in his 70s. 4-person, an older woman, I would guess that she was the oldest woman of the bunch. So she's the 4-person. Tina, I don't know if Allie gave you a family hug. Oh, family hug. So I'll give you a family hug. All right. Looks like Allie got all these low ones here. All right. Kelly Never, thank you for the jewels. Hockey KC, thank you for the jewels. Boris gifted 10 DD podcast memberships. Thank you, Boris. We appreciate that very much. Always. Kelly Never, thank you so much for the jewels. Jersey Girl Trey, $2. Gonna start saying, oh yeah. Oh yeah. Oh yeah. Do it into Motta's voices. I hope you do. I'm not gonna lie, it's pretty addictive. Oh, so I pulled this one up, or Allie pulled this one up. And then kindly, and I want to get to it. It's a few down. I'm going to probably mispronounce it again, but Basenjis are dogs. So that's coming. That's coming. Thank you. Allie asked these. Where did the doctor sleep? Got to that. Got to that. Got to that. Chicopee Farm. Ah, there. So this is who gave the love. So it's Basenji. Basenji dog breed. There it was. There was the clarification. Takes a village. Takes a village. Thanks, Chicopee Farm. Appreciate that. See? I had no idea. No clue. I had as much idea about a Basenji being a dog as Mac has about postpartum depression. Penelope Pit Stop, $5. Red didn't bring up the eve of trial discovery. It wasn't Lindsay on that website. True, he didn't. Red's expert caught it. But at that point, he didn't need to. The suicide issue was put to bed. You know what I mean? That's what I'm saying. Like that thing, once their experts testified it was a serious suicide attempt, was over. So they didn't need to get to that particular search because that's what it was related to. They didn't care about the truth before that. Thank you. Thank you. Had that not been addressed by their experts, then that would have been a big whiff to miss on that for sure. Deb Smith, $2, but only his DNA on the bands, not hers. Yeah. Patrick didn't kill the kids. He just didn't do it. Didn't do it. She remembers it. Like, does anybody think that she's sitting in there taking the bullet for Patrick who did this? Really? Like, that's the question for everything that you put out there that's not quite making sense for you. Do you think that Lindsay would be taking the bullet for unaliving her 3 children for her husband? I don't think so. But thank you for the generosity. B Mama RN, I would have cried. We have 3 babies, no longer here. A mother who begged for help, having many people fail her, praying this brings more research and updated protocols to treat maternal mental health. Yeah, me too. Hear, hear. Great post. Thank you for that. $10, Rosie the Lab. You come here for a fair and balanced debate, and I appreciate you. Yeah, I mean, I have my thoughts on it, obviously, but I don't hide that fact. And I'm always willing to listen to the other side. Always. I may not agree. I may debate it, but I'm always up for it. Always. It's like the people that refuse to get into the conversation, those are the ones you can't trust. Simple. Those are the echo chambers. Thank you for the 10. Basenjis for the most part. Basenjis are dogs, FYI, LOL. One of your fellow classmates Beat you to it. Thank you for the 2. Appreciate it. Member for 1 month, Andrea Yates, trial 1, 8 women, 4 men. Second, NGRI, 6 and 6. Interesting. Thank you for that factoid. I did not know that. It's interesting. Maybe my concerns are misplaced about men. But hers was a different case, though. She had that whole religious dude that was all up in the shit. I don't know. Juju BB, $10. Thank you so much for covering Lindsay Clancy. Will you please cover Latarsha Sanders' retrial? Poor black mom, killed her 2 kids in psychosis, pled NGRI. Sully was a judge and psych records excluded in this trial. Guilty, just overturned. I saw that. Yeah, I would absolutely cover that. Presuming that the streamers give enough of the shit like Law and Crime and Court TV. I mean, they should go in there and stream it. I would definitely cover it. Yeah, because I knew Sullivan got overturned like right in the beginning of the trial. Thank you for the generosity. Susan Davis, 10 jewels. Thank you very much. Sapphire and faded jeans, $5. How did the jury react to the DA talking smack about Sue Clancy lying to Lindsay about how much better she seemed? I found it appalling. I wish I could tell you, stone-faced. They just were very good at not showing their emotions. They just were. You know? Like I would always ask Sue, because Sue is like, I am not, like in her Twitter, she's like, I am not going to be giving you blow by blows. I'm literally in here observing like the jury, things that I see in the courtroom. So I would always defer to her, you know, and she picked up on a few things, but it's just, they weren't that jury. You know, you get the Karen Reed jury and they were all very emphatic, laughing and, you know, I mean, like this was not that jury. They were much more somber, just in general. Didn't get the tells that you'd hope for. Thanks for the 5. Patty's Next Chapter, thank you for the jewels. Candace Hoff, thank you for the jewels. Steph Marcel, $2. The 2 mortal sins of the mortal sins 2 times. Case should have been thrown out. Well, if she gets guilty, it's going to get appealed. And that's going to be one of the primary issues on appeal. Promise you that. Thank you. Patty's Next Chapter, thank you for the jewels. Mama G, thank you for the jewels. Mama G, member for 7 months. Pretty please answer my earlier question. I hope we got to it. I had to have, right? I've gone through all of them at this point. K, Red's Public Barbecue, $2. Emailed you regular stream if you get a minute under Andrea. Emailed you reg stream if you get a minute under Andrea. I'm not gonna lie, I have no idea what that means. I'm sorry. I apologize. Betsy Reader, $5. Can you tell us, quote, it was Patrick Thinkers, why you don't think it was him? Well, the primary reason is because Lindsay remembers doing it. That's my reason. I know it wasn't him. I mean, this whole concept that he somehow figured out some kind of drug concoction which causes her to have amnesia and that he wakes her up when he goes to find her and she's down there, he plants the seed that she did it. I mean, she has a memory of it, doing it. So like, I'm volleying that question back to you and answer that question for me. How are you ignoring the fact that Lindsay has memory of doing it? Not a planted memory, actual memory. So I volleyed it back over the net to you. If you're still here. And that, like always, I'm always up for the debate. Sarah WB, thank you. 2 times. My 3 loves, $10. Can you guys explain closing arguments? They are not to be taken as evidence, nor are they evidence. But yet it's the last thing the jury hears. Am I getting this correct? You're both empathetic and real. It's a great question. It's a great question. So closing arguments are argument. Okay, I know that seems repetitive, but an opening statement, you're not allowed to argue. Okay, what you're doing in an opening statement, that's why they call it a statement, not an argument, is that you're laying out for the jury what they can anticipate hearing throughout the course of the trial. So you're giving your narrative in terms of your theory, and then you're going to say what the evidence is going to show you. So you always hear that phrase over and over, or some version of that throughout an opening statement. When you get to arguments, jury's heard all the evidence, and then each side is arguing what they believe that evidence shows. Hence the argument part. Because both sides are looking at the exact same evidence, but they have completely different theories, right? So that's the arguing part. So, but you can't take what their argument, the things that they're saying out of their mouth, why this particular piece of evidence is damning. You're not taking that argument as evidence, but you can obviously consider their argument regarding that particular piece of evidence. Does that make sense? Hopefully I explained that in a way that makes sense. And thank you. Oh, you scared me. Little Cora B came up. Do you want to come up here? Come here. You want to come up? Oh, all right. Come on. All right. Say hi to the people. Hey, stay off there. Paul C. Young Esquire, thank you for gifting the 1 DD podcast membership. Happy to see you in here, Paul. Thank you. Thank you. Courtney Hoster, thank you. As an RN, I'm deeply appreciated Red shouting out Meg Collins in the nursing profession. Yeah, that was awesome. That was awesome. And thank you for your generosity. All right. Chloe, circa 76, 5 joules. You want to hop down? Here, I'll help you down. Whoa. Thank you for the jewels. Acid reflux, $20. Red should have argued, why was she getting Miralax for kids if she knew they wouldn't be alive? She couldn't have premeditated what she did based on that. I thought the exact same thing. There was like a case that I was following for a hot minute. It was 20-something young man, black, down around Illinois State University. His name was Jelani Day. And he went missing. He was getting his, I think he was getting his master's in speech pathology. And it was like right around the beginning of school for that semester. And the morning he went missing, he had stopped and at a weed dispensary and got weed. And not just like a one pre-roll. He bought like a stash of weed. And so he ends up going missing. They don't find him. I forget what the length of time was, but it was a lengthy period of time. They ended up finding him in a river 40 miles away from where ISU is, in a former sundown town, floating in a river. His body's almost completely gone, deteriorated. And the medical examiners opined that he drowned. And I'm talking about a shallow shallow river. And, you know, and one ME said it was suicide. I'm like, what? And it's that same argument. Like, why would he be driving to a dispensary and getting weed for whatever it is a week, depending on how much weed he used, if he's going to commit suicide in some weird wooded area 40 miles away from where he goes to school? Doesn't make sense. I agree. It's a good argument. It's a very good argument. And thank you. UK Carey, thank you. Lovely E Chase, thank you very much. Roosevelt Media News, $10. Why did Red not get into her criminal culpability, knew right from wrong, and was able to comply? I don't know. You think he was light on that? I think the easy answer is I believe that he felt that his entire argument was going to that. Because remember, in his world, the homicides was a done deal. There was no argument about that. So everything he was saying was relating to those two prongs. If that makes sense. Thank you. Appeals are made for walk-in. $5. Appreciate that. Jury expert said disgust is one thing a juror can't get past. In my opinion, Red successfully got the jury to empathize with his disgust of the CW and GRI. Now, Ocean. Yes. I'm ready. Thank you. Stay-at-home juror, $20. Value for value. Thank you guys so much for your dedication to this case. You guys are the best team, Cam included. Chat, we all spent so much time together every day. The best chat in the universe. Family hugs to everyone. Thank you for the incredibly kind message. We really appreciate that. And I'll die on the cell. Best chat in the land. That's it. Thank you for your generosity. Rose Chavez, $10. I started following you during this trial. Appreciate all the coverage you and your beautiful wife have been doing. I love both for your insights. You got a new fan from New Hampshire. Oh, thank you. Thank you very much. We're so happy you found us and that you like us. We appreciate it. Michelle Fannin, $20 for Allie holding it down during the fiasco this afternoon. For real. I'm sure she was freaking out on text. And I was like limited, I could hit the people up that I know. An awesome group chat with Bederow and Ian. Much love. Thank you so much, Michelle.
Just wanted to shout you out.
Hey, thanks, man. Hey, man, appreciate you. Thank you. Thanks, man. That's what happens when you do it live on a porch, right? Thank you, Michelle, for the kind words and the 20. We appreciate it very much. Coco and Chloe, $20. Bob and Ellie, thank you. As a 25-year labor and delivery RN for your amazing service to this case and issue. Our dismissal of maternal health care in the U.S. ranks last, or our dismal maternal health care in the U.S. ranks last and declining of all developed nations in the world. Man. So upsetting. So upsetting. It's crazy to me. It's crazy. Thank you, Coco, for doing what you've done for 25 years in the trenches. I too, much like Red, love nurses. You guys are amazing. Amazing. Thank you for the kind words. Music to my soul, $2 revised model jury instruction published 3/30/26. Ask and ye shall receive. I don't know who asked it 10 minutes ago in a super, but Thank you, music, for doing the work. Well done. Appreciate you. Rose Chavez, thank you very much for the jewels. Michaela, $10. Thanks for all the amazing coverage. Do you think the long period that elapsed between the court order and the psyche vals and aptitudes because they went to multiple docs who reviewed and declined to back the DA? I mean, that's certainly possible. I mean, I've been on that side of it. You know, we had a one case in particular wherein the allegation was that our client had abused his stepson. And when I say abused, they were saying that he held this 5-year-old boy's hand over a lit stove. And like nothing about this guy, our client, in any way, shape, or form, because that's so incredibly cruel and horrific that I was like, this guy couldn't have done this. Like, there's nothing about it. He had like an advanced degree. There's no indication that he was like some kind of monster, you know, and he'd been with this little guy for years, you know, and I kept sending out the pics of this wound, this round kind of quarter-sized wound on the top of his hand. And I wasn't given like all the doctors I kept sending it to. I'm like, all right, just need you to take a peek at this. Can you give me 2 potential sources of this injury? Like the first doctor wrote back, he's like, it's a burn, duh. I'm like, oh my God. And I had a really, really challenging time finding a doctor for that. So that's not only possible, it's likely that happened. I mean, you have to believe. You have to believe. And even though Spinelli didn't testify she was going to, you know, unforeseen circumstances barred that from happening, it wasn't the Facebook post. But you have to believe the Commonwealth searched high and low for a woman, either nurse practitioner and or psychiatrist, psychologist, who would be willing to come in, who did have some knowledge about postpartum depression, postpartum psychosis, and say what they needed her to say. I mean, I just, common sense dictates that happened, that they would have been searching high and low for that person. Oh yeah, I watched that. I made a short about it. That was an amazing rant. It's an amazing rant. That didn't get nearly as much traction on Instagram as it should have either. It's a great rant. Thanks 2 times, Michaela. I appreciate you. Rose Chavez, thank you so much for the sun balloon. Ginger Freckles, thank you for the jewels. Rambo Bambo, $5. If the jury is hung and it gets retried, they will go. Will they go after Patrick? I'm not in the Patrick did it camp. Just curious, since so many people believe it. I don't think so. I really don't. There's no retrying it against Patrick. That would be completely separate case, having little to nothing to do with the fact that Lindsay was tried already. They would have to try him instead of retrying her. Unless the suggestion is that they were in cahoots. So, yeah, don't hold your breath on that one. It's my honest opinion on it. And thank you, David James, Bob. I do believe she was insane, but I also have belief she needs to be punished for this. Your take, free Richard Allen. I mean, the easiest way I can describe my feeling on it is that, first and foremost, if she was truly psychotic, and I don't know if you caught it when Resnick tried to talk about, if you're in a state of psychosis, and you're disassociated, that your diseased mind and this feeling that you're outside of your body is as if you are a marionette, that it's not your own volition. You're not the one doing it, even though it's your hands and you're the one in terms of your vessel that's committing, but it's not your mind. Like, I don't know how you punish somebody like that, but put that aside. No prison in the world is worse than the prison that is going on in Lindsay Clancy's mind. You know what I mean? Someone wants to be dead still 24/7, always one-on-one. She's never left alone. I mean, if you're paying close attention to the case and you can kind of see what went wrong here and how many people had to have failed for it to get to this point, I just don't know. It's like that comment, which is a fair comment, completely fair comment, but it really just shows like kind of a disbelief or not a complete understanding of when somebody's lost their mind and has no control to be able to snap between what's real and what's not. You know what I mean? I mean, it's like if I had some magic wand and I could make everybody on the planet experience it for 10 minutes, then it would go away completely, I would 100% do it. Have you in a nice, safe space, tap you on the head with the magic wand, have you go psychotic for 10 minutes, tap you on the head, have it be over. And then you'd know. Then you'd know. There is no magic wand. There is no CAT scan that can show us where we can point. You know, we're forever going to be stuck in this thing. And then you have prosecutions like this that make people believe, because she's saying it in a court of law, that you have to be seeing unicorns in the corner and frothing at the mouth and your eyes are bugged out and you can't make words like in the movies. It's not what it is. Can there be people that it's progressed that deeply that's not postpartum psychosis, but just regular old psychosis / schizophrenia? I mean, yeah. But this was a different thing. The genesis of it was a combination of this polypharmaceutical cocktail she was given without any of these people looking at her prior medical history. And the fact that she was in postpartum depression and had stopped breastfeeding. I mean, there were so many things going on with her, like the hormonal imbalance, the upheaval that's going on in a woman's body. Like, it's just, everybody needed to hear Spinelli. At least everybody that's not in any way, shape, or form familiar with what's going on with women's hormones before, during, and after birth. Duncan, Idaho, $5. The Patrick Diddick thing is another outgrowth of how many people are treating this trial like a true crime reality show for entertainment. Not good. I could not agree more. And it's drawing the attention away from what should all be placed on women's mental health. I mean, it was the comment from the labor and delivery nurse of 25 years ago who said it best. I mean, she's in the trenches. you know? Our handling of it is the worst in the world for developed countries. It's ridiculous. You know, I mean, we live in a country wherein a married woman could not get a credit card unless her husband co-signed for it up until 1974. And if you think 50 years is a long time, man, it's a blink of an eye. I mean, think about that. We live in a country where until the 19th Amendment was passed, that women didn't have the right to vote. I mean, put some pieces together. It's not that complicated to figure out what the fuck's been going on. You know? And I'm not here for it. I don't support it. I think it's fucking bullshit. And I want to do everything in my power to support the people that are fighting that and that mentality. These fucking idiots on X talking about repealing the 19th. What a bunch of fucking morons. I don't want to even live in the same planet with people that think like that, men that think like that. And if they got a problem with me, I don't fucking hide who I am or where I'm at ever. Ben, thank you for the buck. Appreciate it. J-Man, $2. Does anchoring bias explain Patrick? I can't explain them. I don't know. I think here's my only explanation for those people is I think that the number of women that are in some form of postpartum depression / psychosis that unalive their kids are not quite as uncommon as we all think. The trials are uncommon because most of these women end up unaliving themselves, which means, of course, there is no criminal case, which of course means there's no trial. So it's a blip in a newspaper and then it goes away. I mean, statistically, you can pull it up. What I think the problem is for these folks, and particularly, you know, and I got a lot of shit from the Patrick Did It clan when I posted my video telling them to knock it the fuck off because you're diminishing what the real issue here is and you're taking the spotlight off of it with some bullshit. And that's how I feel about it, point blank. And what I think is happening is that they're a group of people that are trying to rationalize what is for all of us, a completely irrational situation, because a mother would never do that to her kids. A mama bear would never do that to her kids. So they're trying to rationalize it, and it's way easier to say it was the dude. He'd do it because he was dating the jogging friend, and he then married the jogging friend. Like you know what I mean? It's like that's the genesis of it. You know, and the reality is it was a shitty investigation because they didn't think there was anything to solve. So that's where I'm at. Ben, thank you for the jewels. Sleuth investigates $10. The prosecution, this whole trial is like, believe what we say, not what we didn't show you. They didn't investigate to the highest specificity they should have. I agree. Perfectly timed comment for what I just said. Thank you for the 10. Gentegrity. Oh no, Gentegrity. I like it. $5. I feel like if this was premeditated, she would have drugged the kids ahead of PC leaving. I feel like if it was premeditated, she wouldn't have used exercise bands. It's like awful. Like strangling, like it's like, ugh, I can't even with it. It's, but like I am not on the it was premeditated camp at all. I think she was literally out of her mind. She was a different person. She was sick. Thanks, Jen. Appreciate it. Just another ADHD witch. Thank you for the jewels. Rambo Bambo, $10. I just want to get back to Delphi. I have no doubt about Richard Allen's innocence. Talk about someone making jack statements under drug-induced psychosis, and those drugs were involuntary. Well, yeah, but I mean, he was psychotic when they started giving him the Haldol, so it made everything worse. I mean, it was psychotic because they had him in solitary for months. Like people, he got his tablet. I'm like, I don't give a fuck, man. It's not how that thing works. You're in a cell 23 hours a day with no human contact. Oh, I talked to Walla in a cage, literally in a Hannibal Lecter cage. And most importantly, they didn't allow him to have in-person visits with the person he needed. It was absolutely required for him to function as a human being, which was Kathy. They knew that. I mean, the easiest way in the world to get somebody to say, I did it, is to take away the thing they need the most. You don't have to torture them beyond just taking that away, keeping them in solitary. Just say, hey, want Kathy to come visit? Yes. Just say you did it. Does that seem that complicated? Is everybody like mind blown by that? How fucking easy that would be for somebody who's been in a cell at that point for 4 months in the most secure prison, in the most secure cell, in the most secure prison in the state of Indiana, which was an utter hellhole. I don't know. Don't worry, I haven't gone anywhere on Rick Allen. Thank you. Chuju BB. $5. Do we know the real reason Spinelli didn't testify? Yeah, there was the medication. She was like falling asleep. She had to take the meds. The whole Facebook post thing seems to be a conspiracy. That's not it. That wasn't it. It was the meds. Like she's senior. I think she's in her late 80s. I agree. I think she was critical. Thank you. Appeals are made for walking. Now men claiming they can just be a woman. No, sir. As far as I know, men can't have babies. So, I don't know. I mean, that like as far as like without getting into anything beyond just the biology of it, because whatever people feel is 100% their right in their business, and that's it. I mean, like just talking about the biology of it. Lisa, MW, I don't understand why they don't give bioidentical hormones to women with PPD since it's a hormone imbalance. 100%. Thank you for all you do. I love you and Allie. Well, thank you, Lisa. We love you back. All right. Well, we got through all those guys. Wow, long stream. 9 hours. All right, let me give some love. We got some Venmos. Let me get through those real quick. Let's say the 27th. Gail, $10 trial coverage. Thank you. Thank you, Gail. I appreciate you very much. Let's see. I want to make sure you didn't give me Cato 7 on the tubes. Thank you so much. I got your $100 Venmo. Incredibly generous. Defense Diaries, thanks for the amazing coverage and with such a kind and respectful and fun community. I love other creators like Mel Little, Avi, but Dee Dee is the vibe for me. I'd love for you to get Bob Alessi's take as a doctor and a lawyer. I'm sure I can arrange that. Thank you so much for that generosity. Truly. Cindy, a $20 Venmo. Thank you very much. I appreciate that. And then Christine, 25. Thank you for your coverage of the Lindsay Clancy trial. Safe travels. Thanks, Christine. Appreciate you very much. Oh, okay. Hold on. Elise, thank you for your $10 Venmo. I appreciate it. And then Denise, $50 Venmo. Thank you very much. Thanks for your coverage. Love this channel. Thank you very much for that. And you guys are awesome. Thank you, thank you, thank you. And then I did get a Cash App. A couple, actually. A few, actually. Christy, I did get your $100 Venmo, and thank you for alerting me to what you thought was an issue today. I appreciate that, truly. And then Kristen, wish I could do more. You know the rule. Please don't ever apologize when you're sending us money. Please, we're thankful for every cent, truly. I mean that. Thank you very much. Anya sent 10. Have an awesome day. Thanks, Anya, too. Nice message. And then Carrie, $10 on the Cash App. Thanks for coming to Mass. Appreciate you and Allie. Thanks, Carrie. We appreciate you back. And then finally, the PayPal. We got 50 from Debbie. Thank you. No message, just 50, solid. Thank you, thank you, thank you so much, everybody, for your incredible generosity. Thank you for hanging with Allie all day. I'm sure she was wonderful. She seems to be very, very comfortable with guiding the ship on her own, which is great. It's come a long way, baby, from the days where she's like, I don't want to be on there alone. I was like, you can do it. You got it. You'll crush it. They'll love you. And all those things are true. All of those things are true. All right. One more. Madam Clerk Suit. Oh, Madam Clerk Suit. Yeah, right. I loved her. As a bipolar person who has had psychosis, the mean people are why we suffer in silence. I have zero doubt. And I'm sorry that that's your reality. We're trying. All we can do is keep the conversation going. You have to move the needle. All right, y'all. Mods, thank you for your incredible coverage all day. 9 hours, 30 minutes of our mods just crushing it. Don't forget, we have a buy me a pizza or buy me a coffee for our mods. Hopefully they've been dropping that in. Give them the love. They're working. They're working. Believe me when I say this. They're back there working, reading every comment, keeping our chat civil, you know. And they know my rule. Like I just, they're not allowed to boot people because they have an opposing opinion. Like the rule is, if you're an asshole, you get booted. Not if you have an opposing opinion. It's my only rule. I have one rule in here, and that's it. So thank them for keeping this chat awesome and our community amazing. And Tracy, if you're in here, I love you. I'm sorry that you went through what you're going through today. It sounds awful. I hope you're okay. I'll let Tracy share if she hasn't already. She had a rough day. And she, despite it all, still doing what she does because she's amazing. So, all right, to you, whether you're old or new, if you're new, welcome. We love having you here. We're so happy you found us. It's challenging because sometimes we don't get dropped in the algo. So sometimes you just fall into our laps. Sometimes another creator talks about us. Whatever the case may be, however you found us, we're thrilled you're here. We hope that you enjoy it here. We hope you get some value from us. And we hope that you enjoy the community. We think it's a wonderful community. So we're eternally grateful to all of you. And it's been a privilege and an honor to be here going through this trial with you. And it's not done. We're still waiting on a verdict. So, but the heavy lifting for me is done. So we just adore you. Thank you so much. The numbers continue to grow as we shoot towards 77,000. It's amazing. We're so thankful. We truly are. We truly are. I mean, we put in the work, and it's rewarding to see that it that it resonates with people enough to hang with us, because there's a hell of a lot of content out there to watch. So that is not lost on me. And I'm just so grateful that you guys have elected to spend your time with us. So thank you a million times over, truly. And don't forget to like, share, and subscribe. It's all free. Helps grow the channel. Tell your friends, tell your neighbors. If you're on a replay, leave a comment. And just know, above all else, this absolute truth, that without you guys, I would literally just be an old man talking about all kinds of cases. Talk to you tomorrow.
Absolutely.